Court officer? Court officer?
ಹೇಳಿ.
ಮೇಡಮ್ ಕೋಟ ನಂಬರ್ 17 ಅಲ್ಲ?
ಹೌದೌದು ಹೌದು.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Yes, memos you give. No, fresh matter idru next week ಎಲ್ಲ full ಆಗಿದೆ. We'll give it, we'll post it. No dates. No date, it will come. It is being numbered, it will come according to that. Wait. Submission, wait, sir.
Until when?
Which year? Give it next week. Next date could be 20 vacating stay. All settlement memos you give, wherever settlement are there. ಆಯ್ತು 230. Yes. Give it. Settlement. Be a little louder, sir. Huh? Vacating stay. Madam, ತಗೊಳ್ಳಿ ನಾಳೆ ಹಾಕಿ. ನಾಳೆ ಬರಲೇಬೇಕು. Correct. Yes. So what? Fresh matter. Pending. Intermodal ilva. Intermodal ilva. Why pathology has become a problem, is it? Then intermodal case kodi bharat. Give it, give it. It will come, give it, give it. I'll, maybe, sir, I can't take beyond 200 or 250 on a Monday. We'll post everything. No date, give it. No, sir. No date. Give it. Which year, madam? Kodi next Wednesday haki. Vacating stay alla bharat haki. Fresh matter. It will come Monday or the next Monday, but no date, give it, yes. It will come, sir. Give it. It will definitely, all fresh matters will get listed. Anything else, sir? Anything else other than harassment? Bail ilva? No problem. No problem, no problem. Give it, yes. No dates, sir. I'm not giving dates at all. You're all creating problems, sir. Dates kotre, yes. Settlement kodi, sir. Please give, yes. Threat of arrest yake? Why threat of arrest? So, bail ತಗೊಂಡಿಲ್ವಾ? Sorry, sir. ಒಂದ್ ನಿಮಿಷ. ಮೂವ್ ಮಾಡಿದ ಥ್ರೆಟ್ ಆಫ್ ಅರೆಸ್ಟ್. ಬೇಲ್ ತಗೊಂಡ್ಮೇಲೆ ಯಾರು ಸರ್ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ? ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ಬೇಕು. ಅದು ಬೇರೆ ಮಾಡಿ. ಥ್ರೆಟ್ ಆಫ್ ಅರೆಸ್ಟ್ ಅಂತ ವೈ ಡಿಡ್ ಯು ಸೇ? ಬೇಲ್ ತಗೊಂಡ್ಮೇಲೆ ಯಾವ ಅರೆಸ್ಟ್? ಕೊಡಿ. ಗಿವ್ ಇಟ್. ಯಾವ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ. ಇಟ್ ವಿಲ್ ಕಮ್. ನಾಳೆ ಬರುತ್ತೆ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಮೇಡಮ್ ನಾಳೆ ಬರುತ್ತೆ. ಕೊಡಿ. 230, yes. You have joined there. Come that side. ಕೊಡಿ. Yes. 230, yes. ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್ ಸರ್? ಕೊಡಿ. ಏನಿದೆ? ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ ಸರ್? ಕೊಡಿ. ಸುಮ್ಮನೆ ಬೇಲು ಅರೆಸ್ಟ್ ಒಟ್ಟಿಗೆ ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ. ಇಟ್ ಡಸಂಟ್ ಲುಕ್ ಗುಡ್. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ, ತೊಂದರೆ. ಎಸ್. ಸಮನ್ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಇಸ್ಕೊಳ್ಳಿ ಸರ್. ಏನ್ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ. ಯಾವ್ದಾಗತ್ತೆ ಅದು ಮಂಡೆ ಹಾಕಿ ಮಾಡಿ. ಎಸ್. No stay, we'll see, give it. No problem, give it, sir. Yes. Give the memo. Pending matters, give the memo. No date, yes. No date, yes. ಅದು ಕೊಡಿ. ಆಯ್ತು, ಅದು ಕೊಡಿ. That we will see, yes. ಕೊಡಿ, ಬರತ್ ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ ಸರ್, ಕೊಡಿ. ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ, ಕೊಡಿ. ಡೆಮೋ ಡೇಟ್ಸ್. ಬೈಗಮಿ, ಏನು ಆಯ್ತು, ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ? ಪೆಂಡಿಂಗ್ ಬರುತ್ತೆ, ಕೊಡಿ. ಎಸ್ ಗಿವ್ ಇಟ್. ನೋ ಡೇಟ್, ಅದು ಕೊಡಿ. ನನ್ನ ಕೈಲಿ ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಮಂಡೇ ಹಾಕಿಸ್ತೇನೆ. ನಂಬರ್ ಆಗಿದ್ರೆ ಬರುತ್ತೆ, ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ. Give it, sir. Give it. We'll see whenever it's possible. We'll post it. Monday agalla. Monday, there are already 300, sir. How much can I take? Yes. Why? What were you doing till now? Move the memo. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗೋವರೆಗೂ ಫೈಲ್ ಮಾಡದೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ವೈ? ಗಿವ್ ಇಟ್, ವಿಲ್ ಸಿ. ಎಸ್, ಆಯ್ತು, 2:30 ತಗೊಳ್ಳಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ 8th. ನೋ ಪ್ರಾಬ್ಲಮ್, ಗಿವ್ ಇಟ್ ಆನ್ 8th. ಏನಕ್ಕೆ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗ್ತಾ ಇದೆ? ಎಲ್ಲ ಹಿಂಗೆ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗ್ಬೇಕಾದ್ರೆ ಬಂದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಯೂಸ್? ವಾಟ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್? ನಥಿಂಗ್. ಆಯ್ತು, ಅದು 2:30ಗೆ ತಗೊಳ್ಳಿ. ವೇಟ್ ಸರ್. ಏನು ಹೇಳಿ? EC ಆಕ್ಟಾ? PC ಆಕ್ಟಾ? ಸರಿ, ಕೊಡಿ. ಅದು ಫುಡ್ ಗ್ರೈನ್ಸ್ ನಾಳೆ ಹಾಕಿ ಮಾಡಿ. ಎಸ್ ಸರ್. ವೇಟ್. ವೈ ಕಂಪ್ಲೇನೆಂಟ್? ವೈ? ಮೈಕ್ ತಗೊಳ್ಳಿ ಸರ್.
During the pendency of the anticipatory bail, my lord, Sessions Judge passed the interim order directing the IO to not to arrest the accused persons, my lords.
ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಆಗಿದೆಯಾ?
Illa, my lords.
ಆಗದೇನೆ ನಾಟ್
Pending, please, my lord.
ಆಯ್ತು, ಕೊಡಿ.
Obliged.
So, criminal petition, Swami. I'm respondent.
13%?
13%. Stay, vacating stay, Swami.
ಹಾ?
Stay ಆಗಿದೆ, Swami. Vacating stay ಆಗಿದೆ.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇನಾ? ಯಾವ ವರ್ಷದ್ದು?
2024.
24.
ಹೌದು.
ಮುಂದಿನ ಬರು ಥರ್ಸ್ಡೇ ಹಾಕಿ, ವೆಡ್ನೆಸ್ಡೇ.
Date ಕೊಡ್ತೀವಿ.
ನೆಕ್ಸ್ಟ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಎಲ್ಲ ಬುಧವಾರ, ಮುಂದಿನ ಬುಧವಾರ.
ಮುಂದೆ.
Released after 4 weeks.
Ah.
And there is also a stay, which I want to pray.
You are the respondent.
Yes, my lord.
All right. Which year?
2023, my lord.
Next, where is the memo?
I have submitted, my lord.
2023, next Wednesday. Vacating stay.
Yes, my lord.
All right. Call the case. First list.
Kind submission,
Okay, that's good.
kind submission. Serial number 50, my lord.
No adjournment, sir. You mention when the case is called.
Lord, Friday it was.
Whatever it is, any mentioning about the cases only when it is called. Yes.
Memo for withdrawal is filed, my lord.
Withdrawal idre kodi.
Already filed.
No problem. Which serial number?
35, list.
Right. Yes.
List 1, fresh matter, still number 1.
Please.
He is brought back under 319.
I'm sorry, my lord.
He is brought back under 319, is it?
More than anything else, my lord, the procedure that is adopted by the learned trial judge is unknown to law. I shall just give your lordship a few facts, my lord, in just 2 or 3 sentences. Well, the final report in the form of a charge sheet came to be filed against the petitioners complaining of the commission of an offence under section 302 IPC, among other offences. All of them are on bail. Well, the trial went on. Charges came to be framed. Petitioners pleaded not guilty. Trial went on. Nearly about 65 witnesses came to be examined. Then, my lord, the prosecution would close its case or side Thereafter, the trial court would post a matter for recording of the statement of the accused in section 313. Statement of the accused also came to be recorded. Then it was set down for either for defense evidence or for hearing final arguments. It was at that point of time, my lord, a writ petition came to be filed before this honorable court seeking for further investigation at the hands of some other agency. But that writ petition came to be dismissed by this court. But the aggrieved would take up the matter before the Supreme Court in a special leave petition. That also came to be dismissed. In the meantime, they would also make an application before the benign government seeking for an order for further investigation. And what the government does is, in exercise of the powers said to have been clothed upon it under 173(8), though it is not so, it is only a power that is clothed upon the investigator, not upon the state government. If my lord were to read section 173 subclause 8. However, my lord, the fact remains that the government would order for further investigation.
Government orders.
Government orders further investigation despite the dismissal of the writ petition and also the special leave petition by the Supreme Court. Doesn't matter. But further investigation came to be taken up. Additional
That's
report.
5 years ago.
Yeah.
Further investigation order is 2019.
Yes. But the issue is this. Let them file. Doesn't matter. I was aggrieved, my lord. Subsequently, I filed. Additional report came to be filed. It can't be a supplementary charge sheet or a fresh charge sheet. It is only a report which is additional to the report that has already been filed. That is how, my lord, the language of section 173(8) says. My lord, well, have a look at section 173 subclause 8. It can't be a fresh charge sheet or a supplementary charge sheet. It is a report which is filed in addition to the report that is already filed.
What do you say the report?
Well, yes, I shall come to
The
that.
charge sheet filed under 173(2) is also termed as a final report.
Quite right.
The same way, this is also a report.
Yes, my lord, that is exactly what I'm saying. Now, have a look at 173 subclause 8, my lord, for a
Yes.
second.
Yes.
Although my lord would be coming across the day in
Yes,
and day
yes.
out. Just for my satisfaction, let me invite
Yes,
my
sir,
lord's
yes, yes.
kind attention. Let me not be
Yes.
mistaken, my lord. Nothing in this section shall be deemed to preclude further investigation. Yes, my lord.
Yes,
In respect of an offence after a report under subsection 2 has been forwarded to the magistrate, and whereupon such investigation, the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the file. That means it will be a further report to the report that has already been filed. No quarrel about that
yes,
issue.
sir.
And, a further report has been filed. Presumably, my lord, basing on the additional evidence which the investigator would have collected, my lord, the trial court would proceed to alter or add the charges to the charges that has already been framed. But after altering or adding the charges, what is the procedure that needs to be followed?
216.
216. But that 216, but it is subject to 217. Have a look at section 217 first.
216 at any time, even after the judgment is reserved.
Quite right. Quite.
Yes,
Now that is subject to
yes.
217. Have a look at section 217. My lord gets it.
Yes.
Whenever a charge is altered or added to by the court after the commencement of the trial, the prosecutor and the accused shall be allowed to recall or resummon and examine with reference to such alteration or addition any witness who have been examined and does the court have reasons to be doing it. But this is the procedure which is required to follow. Instead, what he does is he would order for a de novo trial. That is impermissible under law.
Subsection 4 of section 216.
Yes, but that is exactly I submitted to your lordship.
Yes.
This is
Either direct a new trial or adjourn the trial for such period as may be necessary.
But have a look at the first two sentences.
Yes,
If the alteration or addition is such
yes,
that proceeding immediately with the trial is likely, trial has already been over. Trial has come to an end. It is a case where the trial is yet to commence. But 216 subclause 4 comes into play, or it could be pressed into service, provided the trial has not commenced. Here in the instant case, trial has already commenced. That means recording of evidence is almost over. 65 witnesses have been examined. No, my lord, charges came to be altered or added Then, my lord, the procedure which the trial court is required to follow is under section 217, not under section 216(4).
Recall of witnesses.
Yes, my lord.
Hmm.
Instead, what the learned judge says is, he will go back to chapter 18. Have a look at chapter 18.
Yes.
My lord, what he does is, my lord, chapter 18, no sooner the final report is filed, under 226, my lord, the prosecution is required to state its case.
Yes.
227, my lord, the accused can make his submission for an order of discharge. 228, the court can proceed to frame the charge.
Hmm.
Thereafter, my lord, 229, 230 evidence, recording of evidence. That means, again, my lord, reopening of the case for a fresh trial. It can't be done. That is the law. That is what the learned judge has done here.
Let's see.
It
Now,
warrants-
where is the order, sir?
It warrants certainly consideration at your lordship's hand because a serious and important legal issue has been raised.
No,
May I
what,
just request your lordship to kindly turn
where is the
to?
impugned order?
Yes, my lord, I shall take your lordship to the operative portion of the order, which my lord gets at page 142, ink page 142. My lord, he can't fall back upon 216(4). 216(4) comes into play only before the commencement of the trial. Otherwise, only 217. Kindly read. Application filed by the accused number 12600 section 231 CRPC thereby disposed of by directing the prosecution to conduct the trial as enumerated in section 216(4) CRPC. Needless to mention that the materials, etc., etc. Then, my lord, liberty to examine the witnesses as contemplated under section 230 and 231. What is not permitted, he permits. 230 and 231 comes into chapter 18, commencement of trial. Not otherwise.
What was the application filed?
But we would say, continue. Well, let him examine the additional witnesses that is filed in the supplementary charge sheet as fresh witnesses. I have no objection. But if he wants to examine the witnesses who are already examined during the trial, the provision that could be pressed into service is only on 217. Recall them. Do it. I have no objection. But now the procedure that is being followed is, again, my lord, he is PW1, he is PW2, he is PW3. That is impermissible. That is the first submission which I am making on the legal issue.
Yes.
My lord, the second submission is, my lord, although, my lord, we every now and then we say that the prosecution is the master of itself as far as the examination of witnesses are concerned. But it should not be detrimental to the interests of the accused, and it should be a fair trial. But he will file a list of witnesses on the first occasion, which I have produced. He would seek for issuance of summons. The court would issue summons. But for one reason or other, the matter is adjourned. Again, he will file an additional list, second list of witnesses for issuance of process. Process is issued. Witnesses are present before the court. One among them came to be examined in part. Then, my lord, the matter is adjourned at the instance of the prosecution. Next time, he would file another list of witnesses.
Repeating those very.
No, some
You-
other persons. Well, that is what the Supreme Court has condemned. May I just invite my lord's kind attention to the judgment of the Supreme Court?
So according to you, 217 permits recall of the witnesses and not bringing in new witnesses. In a case where it is under 216(4).
Yes.
Yes.
Well, to see, subject to what my lord would ultimately say.
Yes,
216(4) is only in relation to a case where the trial has not commenced.
that we'll see.
Here, the trial has commenced.
No, 216 deals with alteration of charge. Now, alteration of charge, commencement of commencement of trial or conclusion of trial has nothing to do with alteration of charge. It can be altered at any time,
Anytime it could be.
at any
done.
time.
As my
The
lord has
procedure after that is under 216(4) and 217 is what we'll consider it. Yes.
What has-
ಎಲ್ಲಿದೆ ಅದು? ಎಲ್ಲೋದ್ರು ಅವ್ರು?
In fact, in the prayer which came to be made by the prosecution, they would ask for de novo trial. May I request your lordship to kindly turn to paragraph 17, 16 and 17. Well, this is a full bench judgment of the Supreme Court, criminal trial guidelines. Kindly go to paragraph 16 and 17. The council appearing for the states and the High Court submitted that the provision in the draft rules requiring the trial should be concluded on a day-to-day manner cannot be complied with. It was argued that the courts have to more often than not postpone or adjourn cases due to non-availability of witnesses or on account of absence of defense counsel or the prosecutor. The learned amicus curiae submitted that given that the trial begins after charges have been framed, the prosecution witnesses should be available on the dates of trial for the simple reason that they are relied on for proving the charges. It was submitted that this court should indicate that as far as practicable, the trial court should carry out beforehand sequencing of witnesses, deposition in terms of eyewitnesses and other material witnesses, formal witnesses, expert witnesses, etc., and also factor in some specific date of dates so that effective depositions are recorded on every date of hearing so fixed. Well, para 17 would be important. This court is of the opinion, well, the previous paragraph is the submission which can
Yes,
be
yes,
made
this
by
is
the
the,
amicus. This court is of the opinion that the courts in all the criminal trials should, at the beginning of the trial, that is, after summoning of the accused and framing of charges, hold a preliminary case management hearing. This hearing may take place immediately after the framing of charges. In this hearing, the court should consider the total number of witnesses, classify them as eyewitnesses, material witnesses, formal witnesses who would be asked to produce some documents, etc., experts. At this stage, the court should consider whether the parties are in a position to admit any document, including a report of experts or any document that may be produced by the accused or relied on by her or him. If so, the exercise of admission/denial may be carried out under section 294 CRPC, for which a specific date may be fixed. The schedule of recording of witnesses should then be fixed by giving consecutive dates. Each date so fixed should be scheduled for specific number of witnesses. However, the witnesses concerned may be bound down, etc., etc. But here he files a list of witnesses. First day, second day, some other witnesses, third day, some other witnesses, and he does not even summon or secure the presence of a witness who has been examined in part.
no, now we'll have to answer. What is the purport of the word new trial in subsection 4 of section 2 and 6? If that is taken note of, then whether witnesses can be brought in afresh. That is what is.
That your lordship has got to ultimately.
ಅದಕ್ಕೆ ಯಾವುದಿಲ್ವಾ?
ಅದಕ್ಕೂ ಇದೆ ಬೇಗ
ಇಲ್ಲ,
virtually.
alteration of charge, I am aware that
ಅಲ್ಲ,
it can be done at any
but
time.
question is virtually does it not tantamount to a de novo trial, which is impermissible under law?
That-
A fresh trial means
Wait.
a de novo trial.
Get back.
Well, there
ಬೇರೆ
are
ಯಾವ್ದು judgment ಇದೆ?
any number of judgments.
216 I am aware, sir. What
260.
alteration of judgment, definitely. Alteration of charge, yes. That is settled principle.
Well,
Yes, can't be. Whether 216(4) would amount to a de novo trial and everything should go on from the,
ಮೊದಲಿಂದ
from-
ಮಾಡಕ್ಕಾಗತ್ತ ಅದನ್ನ
ಅಲ್ಲ,
ಮಾಡಕ್ಕಾಗಲ್ಲ.
say
Well,
for the
what
word
the-
go.
It can't erase the evidence.
That is what that
It
is.
can't erase the evidence that has already been
Answer that.
recorded.
Yes. I'll-
I am in serial number 36.
ಅಲ್ಲ ಇವ್ರು ನನಗೆ ಅಪೋನೆಂಟ್ ಅಲ್ಲ.
ಅಲ್ಲ, ಸೇಮ್ ಜೊತೆನಲ್ಲೇ ಇದ್ದೀವಿ. Because I who has filed that.
ಈ ಕಡೆ ಯಾಕೆ ನಿಂತಿದ್ದೀರಾ?
Lord has- is-
ಜಾಗ ಇರ್ಲಿಲ್ಲ.
ನಾನು ಇಲ್ಲಿವರೆಗೂ opponent
He is my opponent.
ಇಲ್ಲ. I filed that application before the trial.
ತಾಳಿ.
Well, my submission is
application for stalling.
not stalling.
Then-
I object to examine that witness as a fresh witness. Because
Oh, yeah.
my submission is, my lord,
CBI.
how CBI,
Sailing with me.
saying, Lord, 319, your lordship may kindly say, when the additional witnesses.
No,
are brought in-
319, when additional witnesses are brought,
Sorry,
it is to
additional
be,
accused.
additional accused are brought back into the web of
Well, that would be during
proceedings.
trial.
That is for trial. That is during
Not
trial.
Additional report. But if during trial, in addition to the accused who is before court, if the
Now,
role.
when the additional report was sought or placed before the court, at what stage was the proceeding?
It was posted for prosecution argument.
313 statement.
Then
Meeting was over.
that very act is illegal.
My lord, unfortunately,
If you see,
330 statement.
no, Vinubhai's judgment, you see
Yes,
at
my lord.
para 42, The court, Supreme Court says, till the framing of the charges and commencement of the trial, 173(8) is a permissible
Permissible.
exercise.
That's it. But
Beyond that, it is an illegal exercise.
Yes.
Well, it warrants some consideration at your lordship's hands.
That is true. Yes. But
Interpretation.
why 5 years agide? How can the government exercise 173(8) powers?
Have a look at the order. Have a look at what jurisdiction they have under 173(8). It is only the prerogative of the investigator, not that of the government. Kindly have a look at page 258.
No, government has excised this in other cases also.
Yeah, my lord, this, have a look at.
Further investigation. No,
ha-
to the, see, if it is a communication to the CBI on the application of the CBI, is it on an application of the CBI seeking
No.
for
No,
no
No,
moto?
no.
my
My
lord,
lord, writ petition came to be dismissed.
my lord, they sought
lord,
further
special
investigation. That was dismissed.
Wait, senior. Yes, yes.
Special leave petition came to be dismissed. Subsequent thereto, my lord, the government passes this order. May I request your lordship to kindly turn to page 263 for a second?
This is the order.
Yes, my lord.
Accord sanction to the CBI. For further investigation in 302.
Further investigation, government again is a power, so.
No, is this connected to something else? Has this anything to do with that Vinay Kulkarni's case?
Yes.
Yes.
Have a look at.
No, because that division bench has affirmed that.
Other course.
Then I cannot go beyond that.
That is the reason, my lord, we have not raised.
I'm not on that point.
We are not there.
I'm not on that point. That's why I said I suffered an order. That's okay, no problem.
Then division bench has considered all this, Supreme Court has also
Yes,
confirmed it.
that is why I'm not on that point. Now we are on the trial, that's it.
Now we are only on the manner in which the witnesses are examined. But now it is numbered as PW1 and the documents are renumbered afresh.
You serve on the CBI. I'll post
But
it.
the trial is fixed on.
Yavaga? Next date, sir.
8th. Evidence here.
Evidence.
Your lordship may kindly postpone the recording evidence by 1 week. And your lordship may hear and dispose.
No,
it.
because that act I cannot, I cannot
No,
put
I'm
the
not
clock
on
back.
That's why I said I'm not on that point.
Division bench has considered it.
No, my lord. ಸ್ವಲ್ಪ ತಾಳ್ಮೆಯಿಂದ ಇರಿ, sir.
Sorry.
Wait.
I am not on that point at all. Incidentally, since my lord asked me whether.
I know, that's what,
That's
no,
what
I was,
No, certainly I am not on that point. I am ready to face the trial. There is absolutely no difficulty. But the procedure that is being followed by the trial court is certainly not in keeping with the settled legal position. That is all my submission here.
let's see. Let the CBI counsel come.
Please,
I'll take it tomorrow. You serve on him today.
please.
List on, heard the learned senior counsel, the CV Nagesh appearing for the petitioner. 36, you know? What is 36?
My lord, 36, same order.
Allala, who are you there, sir? Co-accused?
I am accused number 1. Co-accused.
Ah.
Meanwhile, I
This will
comply
have
the
to
officer.
decide whether 216 permits
Yes.
all together a new
Retrial.
trial.
Whether 216 permits a retrial in a situation or under the facts and circumstances of this case. But ಇಲ್ಲಿ 330 ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗೋಗಿದೆ ಆಗ್ಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಅಂಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇಫ್ ಎನಿ doesn't matter. My lord, consequent to an order which can be passed by the government, they would take a further investigation and my grievance before this honorable court was not countenanced. An additional report has been filed. Now that is over. That chapter stands closed.
No,
the-
now all the chapters are closed except
Closed.
216, what order is passed
Yes,
now.
yes, yes.
So we'll
That's it.
confine our consideration only to 216.
Does it come within the purview of 216 subclause 4, or he has got to take up the issue as mandated under section 217? That is recalling of witnesses.
Next date is 8th, Alba.
8th.
Then I'll take it on the 5th.
But if there are new witnesses, in addition to the witnesses who are already examined, certainly the prosecution is entitled to examine them afresh.
We'll see.
Certainly they are entitled to. Ill.
Now, 173(8) excise, it is excised, new things are bought in and everything. How do you examine those witnesses who are necessary to prove the report that is there under 173(8)? No, how do you, is it not by bringing in new witnesses?
But I would rather submit from.
No,
the-
it's only.
Yes, from the result of
clarification.
investigation, what they say is 161 statement is recorded again
Hmm.
of those witnesses who were already examined before the court.
No, that chapter is over,
No, no.
because that also was argued, I guess.
Yes.
Hmm.
No, ಇಲ್ಲ ಇದು ಈಗ ಹೊಸದಾಗಿ ಆಗಿರೋದು.
ಹಾ.
ಅದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ನಾನು ಕೋರ್ಟಲ್ಲಿ ಹೇಳಿರೋದೆಲ್ಲ ಸುಳ್ಳು. When I came to be examined earlier, what I have said is incorrect, inaccurate. Now I am going to tell you the truth. 161 statement.
Let's see. Yes.
That is how, my lord, they let him examine. I have no grounds, I have no grievance at all. Let that witness be examined. But it should be in continuation of the evidence which he has already given. Recall him and examine him.
Dino, L. Prasanna Kumar.
Not deny.
I'll take it on Monday.
Please, I'll,
This, you take notice.
please.
This and that, heard the learned senior counsel, Sri C.V. Nagesh, appearing for the petitioner. The challenge at this juncture is limited to the impugned proceeding, whereby the concerned court grants permission to conduct a trial in terms of subsection 4 of section 216 of the CRPC and permits examination of witnesses as contemplated under section 230 and 231 of the CRPC. The learned senior counsel would submit that it is altogether the commencement of a new trial, and therefore this action of the learned of the concerned court runs contrary to law. The learned counsel, Sri P. Prasanna Kumar, is directed to accept copy kutra. Is directed to accept notice for the respondent. We go through the papers and the grounds urged therein and make his submissions Monday at 4 p.m. Monday is all right?
Trial court ಅಲ್ಲಿ 8th ಇದೆಯಂತೆ.
8th ಇದೆ, ಅದಕ್ಕೆ Monday.
ಏನ್ ಮಾಡಿದ್ರೆ, don't bring the witnesses on that day.
Well, that can be done.
That
I will direct deferring if this.
Yes, that's it.
needed.
You kindly postpone it by 1 week. That's all. In the meantime, your lordship could certainly dispose it.
ಆಗಲೇ ಟ್ರಯಲ್ ಶುಡ್ ಕನ್ಕ್ಲೂಡ್ ವಿತ್ ಇನ್ 3 months ಅಂತ ಏನೋ ಆದೇಶ ಆಗಿದೆ.
Supreme-
ಇಲ್ಲ. No, I'm sorry, you are incorrect. I
The
was.
Supreme Court direction is not there to conclude.
No Supreme Court direction, nor the direction of this court. I was the one who argued the matter. What this honorable court has said is, we request the trial court to dispose the case itself within 3 months. Request the court.
ರಿಕ್ವೆಸ್ಟ್ ಬೈ ಹೈಯರ್ ಕೋರ್ಟ್.
ಮತ್ತೆ
As good as a direction.
ಆಯ್ತಲ್ಲ, at
ಅಲ್ಲ,
his
ಅದ್ರ ಮೇಲೆ
instance-
Supreme Court judgment
ಅಲ್ಲ,
ಇದೆ, ಅದೇನು ನಾನು ಹೇಳೋ
that
ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
request, at his instance, the matter is adjourned more than 3 months.
Not
Now keeping
me.
the witnesses present,
Somebody.
third list, fourth
But
list.
what is this procedure?
I'll just not check. I do not know. I am not representing.
True,
Prasanna.
but how is this?
ಏನು ಅದೇ ಪ್ರಸನ್ನ, ಈಗ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ, ಸಪೋಸಿಂಗ್ ಯು ರೆಕಾರ್ಡ್ ಇಟ್ ಆಸ್ ಎ ಫ್ರೆಶ್ ವಿಟ್ನೆಸ್, ನಾಳೆ ಮತ್ತೆ ಅದನ್ನ, ಇಫ್ ಇನ್ ದಿ ಇವೆಂಟ್ ಐ ವರ್ ಟು ಸಕ್ಸೀಡ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ಬೀಯಿಂಗ್ ಪರ್ಸ್ಯೂರ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ಮೈ ಸಬ್ಮಿಷನ್ಸ್, ಅದು ತಪ್ಪಾಗಲ್ವೇ ಅಂತ ಅಷ್ಟೇ, ಇದೇನಿಲ್ಲ.
Then you take a week's time. I will defer this
ಅಷ್ಟೇ.
by a week. This
ಅಷ್ಟೇ.
action of recording of.
ಡೈರೆಕ್ಷನ್ ಇರೋದ್ರಿಂದ
ಅಲ್ಲ, ಅದಕ್ಕೆ I am also,
ಇರ್ಲಿ ಹಾಗೆ
between
ಇರ್ಲಿ.
that date only I will decide it. That's not an
Please.
issue. Then 8th ಇದ್ರೆ 8th ಒಳಗೆ ತೀರ್ಮಾನ ಮಾಡೋಣ.
ಆಗ್ಬೋದು.
Then I'll take it on 5th. That is Monday.
Please.
Monday at 4 p.m. we'll take it. Be only on this issue.
This is the crux of the matter.
Only on this
Yes,
issue.
sir.
Let's not go back to the division bench, go back to the order,
Yes.
all that. Yes.
Yes.
Hmm. We'll decide it on that. Just get ready and tell.
Please.
Yes, sir. Monday, 4 p.m.
36, I may be permitted to comply office objection. There are some.
ಇದ್ರಲ್ಲೂ ಇದೆಯಾ? ಇಲ್ಲ,
That may be
ಇದ್ರಲ್ಲಿ
connected to this.
Connected ಬೇಡ. List both 1 and 36 in not tagging but in seriatim on 4th. Office objections to be complied with, serial number 36 ಅಲ್ಲಿ, complied with by the next date.
Okay.
Yes, sir.
Please.
Monday we will hear it, and if need be, we will defer it on Monday.
Please.
Yes.
ಅವರು ಸಮನ್ ಸರ್ವ್ ಮಾಡಿದೀವಿ, ಬಂದಿದ್ದಾರೆ, ಇದೆಲ್ಲ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
ಇಲ್ಲ, ನೋಡೋಣ.
5th ಗೆ we will do it.
ಮಂಡೇ ಏನಾಗುತ್ತೆ ನೋಡ್ಕೊಂಡು ಐ ಥಿಂಕ್
ಅಲ್ಲ, 5th
I don't
ಗೆ
know
if
whether
it's-
my learned
fifth-
friend Mr. Prasanna Kumar.
on the 5th, if I am convinced either ways, we'll do it. Yes,
Certainly, my lord.
yes.
My lord, I don't know whether my learned friend is aware of what had transpired before the trial court on the previous date of hearing.
ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಐ ಡೋಂಟ್ ನೋ.
ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ
ಅಲ್ಲ,
ಅಂತ
that is
ನಾನು
why I
ಹೇಳ್ತಾ
have asked him.
ಇಲ್ಲ. ಹೇಳ್ತೀನಿ ನಾನು ಏನಾಯ್ತು ಅಂತ, ನಿಮ್ಮ ಕೊಲಿಗನ್ ಕೇಳಿ ಹೇಳ್ತಾರೆ.
No, why precisely I asked, has this anything to do with Vinay Kulkarni's case? Supreme Court has directed conclusion. That is why I asked.
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಇಲ್ಲ.
ಅದರಲ್ಲಿ, yes.
ಇಲ್ಲ, ಯಾವ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. It is only, my lord, we questioned the additional charges which came to be framed by the trial court pursuant to the additional report which came to be filed by the investigator. My lord, while disposing of that criminal petition, my lord, the dishonorable court, a coordinate bench of the dishonorable court would say, we request the learned judge to finish the trial at the earliest within a period of 3 months.
Yes, we'll.
So with
Monday.
that order,
Please.
there is no other direction
So-
or any such order.
There won't be any need for any adjournment, postponement there. Before that, we'll finish it.
ಅಲ್ಲ ಅದು ಆದ್ಮೇಲೆ 3 months ಆಗಿದೆ ಅವರಿಂದ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದ್ದೀನಿ ನಾನು ಅದೇ ಇಷ್ಟಪ್ಪ ಇರೋದು ಅವರೇ
ಅಲ್ಲ ಇಲ್ಲಿ ಸಾಹೇಬ್ರು ಜೋರಾಗಿ ಅದು ಡೈರೆಕ್ಷನ್ ಅಲ್ಲ ಬರೀ ರಿಕ್ವೆಸ್ಟ್ ಒಂದ್ ಕೂಡಲೇ ಅವ್ರ ಪಾಪ ಎದುರುಕೊಂಡು ಇಲ್ಲ ಸಾಹೇಬ್ರು ಹೇಳ್ತಿದ್ರೆ ನಾನು ಯಾಕೆ ಸುಮ್ನೆ ಕನ್ಫ್ರಂಟ್ ಮಾಡೋದು ಅಂತ ಹಾಕ್ಸ್ಕೊಂಡಿಲ್ಲ.
You are unfair.
Why not?
You are unfair to the court. You are unfair.
No, no, it's not.
ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಒಂದು just a minute,
Yes,
not take more than a minute. ವಿಟ್ನೆಸ್ ಸಮನ್ಸ್ ಬರ್ತಾನೆ, ವಿಟ್ನೆಸ್ ಬರ್ತಾನೆ, ಎಕ್ಸಾಮಿನೇಷನ್ ಇನ್ ಚೀಫ್ ಆಗುತ್ತೆ, ನಿಲ್ಲಿಸ್ಬಿಡ್ತಾರೆ 3 ಸಾರಿ. ಆ ರೆಕಾರ್ಡ್ ಬೇಕು, ಈ ರೆಕಾರ್ಡ್ ಬೇಕು ಅಂತ. They must keep themselves ready when once the trial commences. That is what the Supreme Court has
Yes,
said.
yes. Even in the latest judgment, they should be ready on it for a day-to-day basis.
ಮಾಡೋದಿಲ್ಲ. ಆಮೇಲೆ next day, the court would direct the prosecution to keep that witness present the very next day. So that his examination in chief is concluded, cross-examination is done. ಕೋರ್ಟ್ ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ, ಕೆಳಗಡೆ ಕೂರ್ಸ್ಕೊಂಡಿರ್ತಾರೆ ಅಯ್ಯೋ ಅವನ್ನ. ಬಂದಿಲ್ಲ ವಿಟ್ನೆಸ್ ಇವತ್ತು ಅಂತ ಅಂತಾರೆ. ಅರೆ ನಾವು ನೋಡಿದ್ವಲ್ಲಪ್ಪ ಬಂದಿದ್ದಾರೆ ಮಿಸ್ಟರ್ ನಾಯಕ್ ಅವರು, he is also there. He said, ನಾನೇ ನೋಡಿದೆ, ನಾನು ಮಾತಾಡ್ಬೇಕು ಅಂತಿದ್ದೆ, ಮಾತಾಡ್ಲಿಲ್ಲ ಹೆದರ್ಕೊಂಡು ವಿಟ್ನೆಸ್ ಹತ್ರ ಏನಂತಿರೋ ಅಂತ. ಬಟ್ ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು CCTV ಕ್ಯಾಮರಾ ಇದೆ ಕೋರ್ಟಲ್ಲಿ, ಅದನ್ನ ಕರೆಸಿ ಐವೋ ಜೊತೆ ಬರ್ತಾರೆ, ನಾನು ತೋರಿಸ್ತೀನಿ ಅಂತಂತಾನೆ. ಅವಾಗ ಐವೋ ಓಡೋಗ್ಬಿಡ್ತಾರೆ, ಅದನ್ನ ಅಲ್ಲಿ ಇರೋದೇ ಇಲ್ಲ. ಆಮೇಲೆ ಏನಾಗ್ತಾರೆ, ನೋನೋ ಇದೆಲ್ಲ ಮಾಡಬಾರದು ತಪ್ಪು, ಎನಿವೆ ಐ ವಿಲ್ ಇಶ್ಯೂ ಎ ಬೇಲೆಬಲ್ ವಾರಂಟ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್ ಅಂತ. ವಿಟ್ನೆಸ್ ಅಲ್ಲೇ ಕೂತಿರ್ತಾನೆ ಬೆಂಚ್ ಮೇಲೆ ಆಚೆ ಕಡೆ. ವಿಟ್ನೆಸ್ ಓಡ್ ಬರ್ತಾನೆ, ನನಗೆ ಯಾಕೆ ವಾರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ನಾನು ಇಲ್ಲೇ ಇದ್ದೀನಿ, ಅಯ್ಯೋ ನಾನು ಹಿಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡಿದ್ದಾನೆ ಇಲ್ಲಿ, ಕೋರ್ಟ್ ಒಳಗಡೆ ಹೋಗ್ಬೇಡ ಅಂತ ಅನ್ಬಿಟ್ಟು ಅಂತ. ಇದೆಲ್ಲ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಗೊತ್ತಿಲ್ಲ ಇದು. ಸೊ ನಾವು ತಳ್ತಾ ಇದೀವ.
ಅಲ್ಲ ತಾವು ತಳ್ತಾ ಇದೀರಿ ಅಂತ ಹೇಳಿಲ್ಲ. ಇಲ್ಲ
ವಾರಂಟ್ ಇದೆ, ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ ಇದು.
ಐ ಡಿಡ್ ನಾಟ್ ಇವನ್ ಸಜೆಸ್ಟ್ ದಟ್.
ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಏನು
Fifth will take it. ಅವತ್ ಬೇಕಂದ್ರೆ we'll defer it. If I have to, if it's a decision, complicated decision to arrive, we'll see.
ಐ ಹ್ಯಾವ್ ಅಂಡ್ ಜೊತೆ ಇನ್ನೂ ಒಂದು ಲಿಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳ್ತಾರೆ, ಫಸ್ಟ್ ಐ ವಿಟ್ನೆಸಸ್, ಆಮೇಲೆ ಸರ್ಕಮ್ಸ್ಟಾನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್, ಆಮೇಲೆ ಎಕ್ಸ್ಪರ್ಟ್ ಎವಿಡೆನ್ಸ್, ಆಮೇಲೆ ಮಿಸ್ಲೇನಿಯಸ್ ಎವಿಡೆನ್ಸ್ ಏನಾದ್ರು ಇದ್ರ ಮಾಡಿ ಅಂತಂದ್ರೆ, ಫಸ್ಟ್ ಇವ್ರು ಕರ್ಕೊಂಡ್ಬಾರ್ದು ಯಾರು ಅಂತಂದ್ರೆ, ಗೋವಾದಲ್ಲಿ ನಾವು ಅಲ್ಲಿ ಭೇಟಿ ಮಾಡಿದ್ವಿ ಅಂತ.
Miscellaneous evidence.
ಹೌದು, ಐ ವಿಟ್ನೆಸಸ್ 7 ಜನ ಇದ್ದಾರೆ, 7 ಜನಕ್ಕೆ ಲಿಸ್ಟ್ ಕೊಡ್ತಾರೆ, 7 ಜನಕ್ಕೆ ಸಮನ್ ಸರ್ವಾಗುತ್ತೆ, 7 ಜನ ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ತಾರೆ, ಮಾಡೋದಿಲ್ಲ. That is unfair.
No, all that we will lay down, what is to be done.
Please,
Yes.
please.
Because the criminal trials judgmentally, Supreme Court says what is to be done in
This will
trial.
be a guidance. Your lordship's order in this case, being a law, my lord, this would be a guidelines for the trial court, what procedure they need to follow in a situation of this type.
Idu then yesterday what you submitted, those are all things that are to be.
164, ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಒಂದು ಏನು ಡ್ರಾಫ್ಟ್ ಕ್ರಿಮಿನಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿದೆ 164 ಮಾರ್ಕ್ ಮಾಡೋ ಹಾಗಿಲ್ಲ, 161 ಮಾರ್ಕ್ ಮಾಡೋ ಹಾಗಿಲ್ಲ. ದಿ ಓನ್ಲಿ ಲಿಮಿಟೆಡ್ ಪರ್ಪಸ್ ಫಾರ್ ವಿಚ್ ಯು ಕುಡ್ ಯೂಸ್ ಇಸ್ ಓನ್ಲಿ ಫಾರ್ ಕರಾಬರೇಷನ್ ಅಂಡ್ ಕಾಂಟೆಂಟ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್
That tomorrow will
ನಾಳೆ
answer.
ಕೊಡ್ತೀನಿ.
Yes, yes.
ಐ ವಿಲ್ ಗಿವ್ ಇಟ್.
These are little-
ಸಬ್ಮಿಷನ್ಸ್ ಆನ್ ದಟ್ ಡೇ.
2026.
ಅದು ಡ್ರಾಫ್ಟ್ ಕ್ರಿಮಿನಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ವಿಚ್ ಆಲ್ ದ ಸ್ಟೇಟ್ ಹೈಕೋರ್ಟ್ಸ್ ಹ್ಯಾವ್ ಗಾಟ್ ಟು ಫಾಲೋ.
That will, tomorrow that will answer. Yes. Yes.
Number 2,
Kindly pass over.
Passover, what Passover today? 490 and 500. Serve on the counsel who represents the respondent in the trial proceedings. You tell Vinod Kumar. Counsel to serve on the counsel who represents the respondent complainant in the trial proceedings and file an acknowledgement to that effect by Monday. List the matter on 8th in the fresh matters list. Yes. Next.
My lord, I am appearing in serial number 88, my lord.
88, sir.
Yeah, connected with this same
Connected with 3,
case.
171E.
Yeah, yeah.
Ah,
I appear.
88, sir. 1 minute.
88, my lord.
He appears for 88, not I
Ah.
appear.
Yes, sir.
The petitioner is A1, my lord.
Huh.
In my case,
88 file to.
88 to Kodimad. Oh, you're appearing in 88, so we'll take that file. Yes. Co-accused, huh?
my lord,
Co-accused.
He's accused number 1. I
Ah.
am accused number 2.
Charge under 171 E and F, my lord. That is bribery and undue influence. The only material is that some amount has been seized the previous day. And they assume that it must have been for the purpose of bribery or undue influence.
Election.
There is no voter here, there is no
Hmm.
bribery. There is no. And A1 case is, the money doesn't belong to him. He seized from A2, who appears to be office bearer of the party at some earlier point of
What
time.
was the amount?
4.8 crores.
4.8 crores.
Yes.
Ah.
But seized from the house of A2.
Of
I
accused
have
number two.
nothing to do with it.
A1. I am a businessman, but that money was.
We'll hear you, sir. Ah. Yes, sir.
Petitioner is member of parliament
Hmm.
and he is a candidate.
Hmm.
And he has nothing to do with the,
Accused number two.
that was.
Nothing to do with the money.
Yes. In fact, this honorable court, even otherwise section is very clear, my lord. Offense of bribery is not made out if money is recovered from somebody previous day. There must be a offer of bribe and acceptance. That is not there. There should be two people. Here there is no voter involved. No voter is, attempt is made to vote. And it must be a bribery for the purpose of inducing him to vote for a particular candidate or restrain him. On all those things not there. They simply assume the money has been recovered. It must have been kept there for the purpose of using it for bribery next day. So that's what they assume. There is absolutely no material, my lord.
Yes.
The accused number two, my lord, is belongs to his aid.
Huh?
And immediately after the money.
Accused
was-
number two belongs to?
Accused number two belongs to his party worker.
Huh.
And immediately after money was located, accused number one sends a message to the election commissioner, the person in charge election commissioner, asking him not to register a case.
No.
No, it is there in
No,
the,
I'll get back to this. Yes. Ah.
it is there. He was asking, my lord, your
Then
lordship.
file your objections.
I'll file, my lord. Your lordship may see this page 44, my lord, 43 and 44
Of which petition?
of 1811.
There's petition?
Yes,
No, 18,
116.
page?
Both has, my lord. Page 44, my lord.
44. WhatsApp.
These are WhatsApp messages sent.
Please help, so and so.
Yeah.
Not to register ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Yeah.
Please help IT team, please help, we'll be grateful. He made a phone call also. The
ಅದೇ,
complaint,
please help ಅಂತಾರೆ, ಅದು not to register a case ಅಂತ ಹೆಂಗ
Live.
how did you assume that?
complaint, my lord, the person files a complaint.
Huh.
Complaint in the complaint.
Who
is
files a complaint?
The IAS officer who received this call.
Who received the call?
One Manish Mudigal is an
he is not
IAS
the
officer who receives this call.
Huh.
And he says that the petitioner herein makes a call to him, sends a message, makes a call to him and asks him not to take any action and help him in this entire episode. And those things, my lord, is extracted in the complaint as well.
How do you get that?
It's his statement and
What
then
statement?
the Manish Mudigal statement is also there. It's there, his statement.
Manish Mudigal receives a call, is it?
Yes, he receives a call. He receives initially, my lord, he receives the information about existence of 10 crore rupees in the place which is intended to distribute for election purpose. So he passes on to the flying squad.
So what is 171E? Just see, IPC. Punishment for bribery.
Yes, sir.
Huh?
Yes, sir.
Bribery is defined under 171B.
171.
171B defines bribery. 171E punishes bribery.
Yes, ma'am.
Now you just see, whoever gives a gratification to any person with an object to inducing him to any person,
Yes.
where is the person here?
No. That I will, in the investigation, my lord, which discloses the money has been kept for the purpose of inducing the
ಯಾವ crime register ಮಾಡಿದ್ದು?
crime was registered in the during this
Huh?
election, my
Panka,
lord.
In fact, there
This
is
is-
one ruling, my lord, of this honorable court.
I have myself held, yes.
So this is by Justice Dixit.
ಅದು
Kindly take this.
Yes.
There must
You
be a
would-
voter.
you know, relevant for Henry.
And further investigation is happening pending in this case, my lord, that
ಏನ್ further investigation? 171 ಈಗ.
that is what you are. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ, ಪರ್ಮಿಷನ್ ಕೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರೆ ಬರುತ್ತೆ 173
ಹೌದು.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಬರಲ್ಲ.
ಇಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ, ಪರ್ಮಿಷನ್ ಕೇಳಿದ್ದಾರೆ. ಅದು.
ಹಾ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಯಾವಾಗ್ಲೂ ಇವರು ನಿವೇದನೆ ಅಂತ ಇದ್ದೇ ಇರುತ್ತೆ ಕೊನೆಗೆ. ಸೈಕ್ಲೋ ಸ್ಟೈಲ್. ಎಸ್.
Sir, bribery is extracted at page 5.
Please help. I will be very grateful to you. Regards, so and so.
Regarding the judgment, sir.
Hmm.
Page 5.
Idu, this one.
Ah.
That's what.
Ah.
No, the definition itself is clear.
Yes, paragraph,
171B, I have myself
Yes.
interpreted
please.
in several cases in
Yes.
the last sitting.
Yes.
Page 129, my lord.
Paragraph
120,
9.
you file your objections.
I'll file.
Again, what is this, what's the stage now? Charge sheet ಅಷ್ಟೇ ಅಲ್ವಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಒಂದೊಂದು ದುಡ್ಡು
No, my
ಒಂದು ಭಾರಿ ತೊಂದ್ರೆ ಆಗುತ್ತೆ.
And
No,
further investigation.
Offense has been issued.
ಹಾ.
My lord, this cognizance is taken, my lord, by a magistrate, my lord, who is strictly not authorized.
Not the
Because
special, not the
admittedly,
special
the
court,
petitioner,
Special court.
not the
all-
special court?
not the special court, ordinary court, my lord,
Yes, sir.
magistrate of the, he has no jurisdiction at all.
I'll examine them.
What exam?
Well, I have not seen.
These are to be before the special court.
Yes, yes, my lord. That's correct.
Everything has to be before the special court. How can you take cognizance in committal order either?
Yeah.
To commit the case to the sessions.
Stay over. Request from that, stay.
Hmm.
That order, the cognizance order may go, my lord. It has to be placed before the,
Where
the
is?
charge sheet has to be placed before
That's,
the
first you file your object. Where is the order of cognizance?
page 157.
Cognizance. Page ಗೊತ್ತಲ್ಲ? Now your page ಗೊತ್ತಾ?
The genesis of this case is only before the special court.
Correct.
How did the magistrate take cognizance?
Page 2021, my lord. Page 2021.
Yes.
At 21 bottom. Additional civil judge and JMFC,
20.
not special court,
2-1, sir.
page 21.
Bottom,
Register and put up made out sounds.
21. man. Two together.
In my case, my lord,
18116.
No,
sir.
where, charge
No,
sheet
it is-
admiral, where is the cognizance? Final report.
Page 20, my lord. Page 20.
20, sir.
Page 20, my lord.
I am annexure A.
Yes, my lord.
Is that the order taking cognizance?
Yes, my lord. Page 20.
Registered and put up made over ಅದನ್ನ?
Correct.
At the next page ಅಲ್ಲಿ ಇದೆ. 21.
ಇಲ್ಲಿದೆ.
21. Only about 21.
page 21, my lord.
Bottom,
Bottom.
Yes, sir. This is
It
not,
has to go.
just to go. At Manipatra.
that has to go.
Alone.
It can be remanded back to the
Yes.
cognizance order has to go, my lord. It has to.
Other
Yes,
things,
before-
you have anything else to submit?
Even
Ah,
on
then merits and let him file his
there is
objection.
Nothing.
One
Yeah.
minute, sir.
Yeah.
Heard the learned senior counsel, B.V. Acharya, appearing for the petitioner and the learned senior counsel, Prabhuling Navatgi, appearing both these petitions, 18116 and 20186. You are in 20186? ಅಲ್ಲ, ತಾವು ಯಾವ್ದ್ರ?
18116. sir.
18116, ಅದು correct ಆಗಿ
18116.
ಹಾಕೊಳ್ಳಿ.
Yes.
The learned senior counsel, Shri B.V. Acharya, would submit that though an amount of rupees 4.8 crores is recovered from the hands of the accused number 2, it has nothing to do with the petitioner and nothing to do with the ingredients of section 171E that the petitioner is now charged with. Apart
E and
from
F, my lord.
E
E
and
and F.
and F.
Please,
As
but-
according to the learned senior counsel, the ingredients of bribery that is obtaining in section 171B is clearly not met in the case at hand. The learned additional SPP would seek to file his statement of objections on that score. The learned senior counsel, Shri B.V. Acharya would further, and the learned senior counsel Prabhuling Navadgi in unison would submit that the order of taking of cognizance is by the learned magistrate, which power, which jurisdiction he apparently lacks. The order of taking of cognizance reads as follows. The order itself indicates that it is the magistrate who has taken cognizance of the offense, and the matter had to be placed before the special court if cognizance had to be taken after filing of the final report, as it is the designated court. The special court, i.e. the court of session, is the designated court to deal with the cases arising out of the people's representatives. So in that light, there shall be an interim order of stay of further proceedings before the concerned court till the additional SPP would file his statement of objections.
Yes. Further investigation is happening, my lord, that should not.
All, everything, further investigation, 1 minute. Yaudr mail further investigation.
There are some money trail, my lord, which needs
It's
to
all
be.
right. Now you have filed the final report where?
That is, that,
Where?
not in the competent court, my lord,
All
but that
right.
doesn't mean, my lord, that.
No. Let everything get be stalled. Yes. They all, the so and so, and all further proceedings taken there too. ನೀವು ಕಾನೂನು ಗೊತ್ತು, ಇದು ಯಾಕೆ ಮಾಡೋದು?
Magistrate ಅದನ್ನೇ. Magistrate ಅದನ್ನೇ ಮಾಡಿ.
ಅವ್ರು ಅದನ್ನ ಹೇಳಬಾರ್ದು. ಎಸ್. Next. Office objections. 2022. Finally, 2 weeks' time is granted to comply with the office objections. List the matter on 22nd August. Interim order in Lala, 22nd August. Eva, where's your file? Where is your file? Oh, thank you. For 2 weeks. First list, second list. Special court matter. Second list. Yes.
5.
23. Finally, 2 weeks' time is granted to do the needful. List on 22nd. Next.
6. 2
Yaud
weeks
madam?
time may be granted.
Which one?
Serial number 6, my lord.
Interim order, yeah?
No.
Correct.
2 weeks time may be granted to comply with the office of.
2 weeks' time finally granted to comply with the office objections. 22nd.
7.
Chief, office objection was complied on 7th of June itself,
Already complied.
on 7th of June.
Learned counsel submits office objection has been complied with office to verify. List the matter on 8th in the fresh matters list.
Interim
Idea interim order.
Interim order.
So I'm going to list the matter on 22nd. Interim order subsisting shall continue to the next date of hearing. Ilwa? Yes, Bhargav, idea interim order.
I think it's granted on
Aye.
5-1.
8. Appearing for petitioner, my lord. 171 H of IPC, my lordship.
Interim order ilwa?
No, my lordship.
Yes, comment.
My lordship, the allegation is that, my lord, 14 persons were involved in election campaign without the permission.
No, he will have serious objection for grant of stay in this now.
Office objection.
My lordship,
Office objection.
that is with.
Comply. 8, yes.
My lordship, till last date of hearing, I have produced the order sheet, my lord.
What order sheet?
Before filing of this petition, last date Ali.
Office objection at serial number 6.
Please, my lord.
What is that?
Before filing of this petition, the last date till then I have filed, my lord. I have produced the order sheet.
Office objection stands overruled. List the matter on 8 in the fresh matters list. ಏನಾಗಲ್ಲ 171H.
This the last case.
Huh?
Our the last case. This is the
ಇರ್ಲಿ
last.
ಅವತ್ತು next week ಮಾಡು. Fresh
Yes.
matters, yes.
9. Much obliged.
ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬಂದಿದೆ ಅಂತ ಅವ್ರು ನೋಡ್ರಲ್ಲ, ಇಟ್ಸ್ ಅ ವೆರಿ ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಪಾಯಿಂಟ್ ಫಾರ್ ಹಿಮ್ ಟು ಆನ್ಸರ್. Because the petitioner. Yes.
For the petitioner,
Ravindra Prasad,
please, your lordship, petitioner is a member of.
office objections.
Your lordship, two submission. One is with regard to charge sheet, entire charge sheet has not been filed. Is the
Why
one
have you
update.
not filed?
I have filed entire of this. It is in page, your lordship, 12. What they have submitted by the respondent number one, same as it is, it has been produced. Your lordship.
ಆಮೇಲೆ ಇನ್ನೊಂದೇನು?
ಇನ್ನೊಂದು ಒಂದು ಡೇಟದು ಆರ್ಡರ್ ಶೀಟ್ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಬಿಟ್ಟು ಅದು ಅಫಿಷಿಯಲ್ ವೆಬ್ಸೈಟ್ ಹಾಕಿದೆ ಇದು.
Office objection stand overruled, accepting the submission of the counsel for the petitioner, list the matter on 8th in the fresh matters list.
Lordship stay.
8th, ಇದೆಯಾ stay?
stay ಇಲ್ಲ.
8th.
Last time, in fact,
Office objections.
objection was overruled, Manoj, it was not noted. The
One minute.
objection is, Manoj, one, the address does not tally with the FIR. Because in the FIR, no address is mentioned, it only says Bangalore city, I have given my residential address. That is one. Second is, Manoj, in 30 Manoj is the FIR, which does not have any address as such. But the second objection is in para 3, Manoj, aggrieved para. Manoj, I have referred as first respondent police. In the cause title, Manoj, I have indicated RMC yard police station. That is the second objection.
Office objections, accepting the submission of the counsel of the petition, office objections stand overruled. List the matter on 22nd, interim order subsisting shall continue till the next date of hearing.
Okay.
Next.
11.
Needful has been done today, Madam. I had to pay process, paid the process.
You'll pay or you paid?
Paid.
Counsel of the petitioner submits, needful has been done, office to verify.
There's an interim order, Madam.
Interim order subsisting shall continue to the next date of hearing. List on 22nd for admission.
Grateful.
Interim order ಇರೋದೆಲ್ಲ admission ಗೆ ಹಾಕಿ, ಇಲ್ಲದೆ ಇರೋದು ಮಾತ್ರ fresh matter. Yes. ಯಾವ್ದ್ರಿ? ಅದು interim order ಕೊಟ್ಟೆ. 22nd. Yes, next.
12 and 13, my lord, one and same.
12 and 13.
Same, my lord, as against
It has come for steps, sir.
accused number 1 to 3 and.
Proceedings against accused number 1, 2, 3 and 5 has been passed by this honorable court. 12 is.
Already quashed.
Yes, my
Covered,
lord.
your lordship.
ಯಾವ್ದು ಕೊಡಿ?
Page
90.
78 alleged. Criminal petition number 4524 of 2022.
Co-accused,
Yes.
12 and
2, 3 and 5 against still partial.
12 nothing.
serial numbers?
12 nothing.
12,
12 and 13.
12 and 13 ಎರಡೇನಾ?
Yes. ಈಗ ಇಬ್ಬರೇ ಉಳ್ಕೊಂಡ್ರೆ ಈ ಕೇಸ್.
Yes, Jagdish.
12 is covered, my lord. 13.
12 is covered. ಆಯ್ತು.
So 141, page number 141.
12. Page 78. Both the learned counsel appearing for the petitioner and the additional SPP in unison would submit ಅಂತ ಮಾಡಿ. Yes, next.
13.
13 rows.
141, page number 140.
Covered.
Covered.
Yes.
Page 141.
The 135 is first order. 135.
Justice Sunil Dutt Yadav.
Pardon?
ಇಲ್ಲಿ ತಮ್ದು ಇದೆ.
Justice Sunil Dutt Yadav.
Yes, madam.
Madam, red flag ಹಾಕಿದ್ದೇನೆ. Both in unison. Yes, next.
14.
Appeal for the petitioner. Lordship, similar office objection, your lordship. For the same incident, 2 FIRs has been filed. That is serial number 9, your
Office
lordship.
objection stand overruled. List the matter on 8th.
Along with serial number 9, your lordship. Both are of same incident.
ಎರಡು ಅವತ್ತೇ ಬರುತ್ತೆ. Yes,
Connect ಮಾಡಿ.
ಬೇಡ.
15.
Serial number 15, your lordship. appearing through VC, your lordship, covered by judgment. So IPC 188, IPC, your lordship.
Accepting the submission of the counsel to the petitioner, office objections overruled, list the matter on 8th. In the fresh matters.
Fresh matter list.
Yes, next. $439.
Cancellation.
Huh?
Cancellation of bail.
Cancellation of bail.
Yes, sir.
Yeah, new ಹಾಕಿರೋದಾ?
Please.
You're for the complainant?
Special
State.
paper.
Special.
Date, yes.
They have sought for cancellation of bail.
Yes. Sir. Yes. Sir.
Now the
It's ripe for hearing?
ready.
Yes. Sir.
Ready for.
Hmm.
May I request the court to kindly peruse the order granting bail. Is that
Page.
page? This matter, there is some development. Now the husband has been granted bail, regular bail. He is accused number 1.
All right.
The wife was initially not named in the FIR. But subsequently it turned out the investigation revealed that she has a bigger role to play in the entire episode. And she has succeeded in getting an anticipatory bail.
Which is the challenge here?
Here, grant of
Nothing
regular
to do
bail.
with the wife, right? Alla, illi, what bail granted to the respondent you have challenged?
Of
That's
course.
yes.
So that matter is now pending before the Supreme Court.
Bail granted to the wife.
Why?
How will that? It's all right.
Anticipatory bail granted to, ಇದು ನಮ್ದು regular bail.
Yes, sir. ಹೇಳ್ಬಿಡಿ.
And the subsequent development is on 29/7. Charge sheet has been filed in the instant,
In this case.
in this case. That I'll place that also.
All right. No, you submit, sir. Cancellation of bail you have challenged. If you want time, I will grant time.
Ready the merits smell ready the.
Then
No issue.
those are,
Next
they have
week- next
filing
week-
of the charge sheet or the wife being granted bail has nothing to do with it.
I thought I should place the charge sheet also with.
Has that got anything to do with the granting of bail?
Definitely, because the finding is that no prima facie case is made out, not even the ingredients of the offense.
Are made out while granting bail.
That
Where is
is
bail order?
kindly turn to
Regular bail.
regular bail,
364A is the offense.
364. May I request the court to kindly peruse the page 36 for a minute.
Yes, sir.
Para 15 at page 35. In order to appreciate the factual aspects of the case, firstly, the court has to consider whether the ingredients of section 364A is made out. For the sake of convenience, the provision is extracted, which reads as follows. Section 364A.
Yes, sir.
Whoever kidnaps or abducts any person or keeps a person in detention after such kidnapping or abduction and threatens to cause death or hurt to such person, or by his conduct, kindly mark it, by his conduct
Yes.
gives rise to a reasonable apprehension that such person may be put to death or hurt, or causes hurt or death to such person in order to compel the government or any foreign state or international intergovernmental organization or any other person
to do or abstain from doing any act or to pay a ransom shall be punishable with death or imprisonment for life, and shall also be liable to fine. On perusal of the aforesaid section, it would clearly indicate that in order to attract the rigors of aforesaid provision, the prosecution is required to establish the following aspects. A. Kidnapping or abduction of any person or keeping him under detention. B. Threatens to cause death or hurt to such person. C. Causes hurt or death to such person in order to compel the government or any foreign state or any governmental organization or any other person to do or to abstain from doing any act or to pay ransom. Under section 161 of the CRPC. Sorry. The first and foremost aspect which is required to be established is that there should be an act of kidnapping or abduction. In the instant case, admittedly, the victim is not a minor, nor is alleged to have been kidnapped from the country. However, ingredients of abduction as defined under 362 of APC as best could be pressed into. At this juncture, at the cost of repetition, the allegation which has been leveled in the complaint is to be looked into. Admittedly, the victim is also known to the complainant and also accused number 2. Absolutely, there is no count that the victim was working in the house of the petitioner for many years. It is contended that the petitioner's son had ravished her, and as such, separate complaint was filed. However, nothing as such has been narrated in the complaint, and at all that is stated is that accused number 2 had insisted the complainant to send his mother, namely the victim, with him on 29/4/2024. It is stated that the victim was allegedly called by the petitioner hearing. The learned counsel for the petitioner was vehemently argued that the basic ingredients of 364A is not at all attracted. It is sufficient that the victim was not lured, abducted, or kidnapped on some false pretext as required under the provisions of, and immediately after the alleged incident also, there were no demand for ransom or any threat being given to the victim. By pointing out the said aspects, he has argued that the basic ingredient has not been met by the prosecution. Though the said submission seems to be proper, the court has carefully appreciated the material which has been furnished by the prosecution. Admittedly, in the above case, 2 remand applications came to be filed by the prosecution in 2 separate dates. The first remand application was filed on 5/5/2024, and it is noticed at that point of time, the victim was traced and also she was accompanied by investigating agency and was kept in safe place. It is also relevant that the remand application indicates that on 5/5/2024, her statement was not recorded and she was subjected to counseling. It is also stated that her statement under section 164 of the Criminal Procedure Code was also required to be recorded. I have bestowed my anxious reading to the second remand application, which came to be filed on 8/5/2024. It is pertinent to note that on the same day, the police custody of the petitioner was completed and he was remanded to judicial custody as per the request of the investigating agency. In the said remand application, it is stated that the statement of the victim under section 164 CRPC was yet to be recorded. The court has also appreciated the fact that the entire remand application, no whisper is found with respect to recording of the statement of victim under section 161 CRPC. I have also bestowed my anxious reading to the CD file and also the statements which have been furnished by the prosecution. The record indicates petitioner was remanded to police custody from 5/5/2024 to 8/5/2024. And it is stated in the statement of objections, more particularly in para 17, that the victim in her statement recorded under section 161 of the CRPC has disclosed the commission of rape by petitioner's son. It is also noticed that as per the objection statement, para 10, it is stated that the complainant's mother was forcibly taken and kept in detention by the petitioner and others on 29/4/2024. And also, the prosecution has contended that the complaint indicates a danger to life of the victim. However, the said fact is also not forthcoming in the complaint, and all that has been stated is that the victim was insisted upon by accused number 2 to accompany him as per the directions of the petition. As rightly argued by the learned senior counsel, the aforesaid fact is required to be established only during the course of trial. At this stage, it is pertinent to note that the victim has not given any statement against the petitioner herein. Kindly mark it. Now, this is the foundation for this. Now, by this date, on the day the judgment was, 161 statement had been recorded. The victim had given and as specifically indicted, and on 8/5, 164 statement has also been recorded. And both the statements are already placed before the court. Without even a reference to those two statements, the court comes to the finding there is no such this thing. And more importantly, now one of the basic ingredients of 364A, that the conduct of the accused gives rise to an apprehension that the life of the victim is in danger or is likely to be subjected to her. That is not even noticed. Now, this aspect, the Honorable Supreme Court had occasion to deal with it, and one set
ಕೊಟ್ಟಿದ್ದೀರಾ? Objections. ಇದೆಯಾ ನೋಡಿ?
I think it's given in a connected matters in this.
Connected ಯಾವುದು?
Till number 23, madam. There are series of.
All ಎಲ್ಲ ಬೇಲ್ದ?
Yes.
ಅದೆಲ್ಲ ಬೇಲ್ ಕೇಳ್ತಾ ಇರೋದು, ಇದು ಬೇಲ್ ಕ್ಯಾನ್ಸಲೇಷನ್.
ಓ, ಇದು ಕ್ಯಾನ್ಸಲೇಷನ್. ಆಲ್ ರೈಟ್. ಅದರಲ್ಲಿ ಇದೆಯಾ?
ಎಲ್ಲ
ಕೊಡಿ, ಅದು ಕೊಡಿ.
ಇದು ತಗೊಳ್ಳಿ, ಫ್ರೆಶ್ ಸೆಟ್ ತಗೊಳ್ಳಿ.
Yes, sir.
May I request the court to kindly see the first one. S.K. Ahmad versus State of Telangana.
Yes.
Kindly come to para 12. Page number 9.
Yes.
Para 11, the section is extracted. Kindly come to para 12. We may now look into section 364A to find out as to what ingredients of the section itself contemplates for the offense. When we paraphrase section 364A, following is designed. 1. Whoever kidnaps or abducts any person or keeps a person in detention after such kidnapping or abduction. 2. Threatens to cause death or hurt to such person, or kindly mark the next phrase. By his conduct gives rise to a reasonable apprehension that such person may be put to death or hurt. Now, this is what the learned trial court has missed. That by his conduct gives rise to reasonable. In fact, this was pointed out in the subsequent, in the same case, when subsequent applications came up for consideration. Now the learned judge realized the mistake and has, he is no longer holding that view in the subsequent.
Oh, their bail is rejected, is it?
Yes, bail is rejected. So this goes to the root of the matter. The entire order is vitiated for non-application of mind. So
Now
this-
charge sheet is filed for 364A.
Yes. (29.7). the
Charge sheet is filed.
Charge sheet is.
Yes, sir. Ashana?
One more legal infirmity in the order. The trial court proceeds on the basis only of the two remand applications that were made, without considering the case diary that was already submitted and the statement under 161 of the victim and statement under 164 of the victim, where on both the occasions she has specifically indicted the petitioner directly as playing a role.
All right. Yes, anything? Yes.
The legal position is fairly well settled. Consideration.
Before my learned friend. Now, after abduction, the victim
Abduction or kidnapping?
abduction, she's not a minor,
Huh. All right, kidnapping, yes.
not a case of kidnapping.
Yes. Yes, sir.
She was kept in detention in the house of accused number 7, who is an utter stranger to the victim, but who served as officer on special duty to the petitioner hearing. I'm sorry, the accused number 1 hearing. It was in his estate. This lady was kept in detention. And now the charge sheet where FSL report has also proved the fact that the place where the lady was kept, murder has been done, and the hair recovered from the scene of occurrence discloses that she was physically present there.
No, I asked abduction, not with regard to a minor. 362 deals with abduction.
Yeah.
It's not a case of minor.
That's right.
That is why the whether it was a case of abduction or 364A is kidnapping for ransom.
Or abduction for ransom.
Kidnapping for ransom. The kidnaps or abducts, both. Yes.
So this is another factor.
Williams.
This is, may I read section
Williams.
William Stephens judgment, Justice Woka's judgment, page 21. Kindly come to para 10
Page 20. Page 20.
at page 24.
Now, would this become applicable to the parameters of grant or cancellation of bail?
No, because the learned judge proceeds on the footing that the ingredients of 364A
And that we'll see. Yes, we'll
are not
answer it.
disclosed.
Yes.
So therefore, it is necessary. Kindly come to para 10 of
Yes.
William Stephens case. The first ingredient of section 364A is that there should be a kidnapping or abduction of any person, or a person should be kept in detention after such kidnapping or abduction. If the said act is coupled with a threat to cause death or hurt to such person, an offense under section 364A is attracted. If the first act of kidnapping or abduction of a person or keeping him in detention after such kidnapping is coupled with such conduct of the person kidnapping which gives rise to a reasonable apprehension that the kidnapped or abducted person may be put to death or hurt, still section 364A will be attracted. In the light of this legal position, now we refer to the evidence of etc. etc. So this is another basic ingredient which the Honorable Supreme Court has highlighted,
Yes.
which has
Yes, sir.
yes, I just pass on the list of dates
Pudi.
just to give a factual matrix. Please. List of dates. Okay. List of dates. Huh? Again. ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ.
Yes.
Sir, on 21/4, even before the elections, a video went viral which had depicted
No,
that the son of the
synopsis I'll go through. That's all right.
yes,
For legal submissions, Madi.
one no, the aspect which I wanted to highlight. On 29/4, it is the accused number 2 who comes to the house of the victim and says that the first accused had asked him to secure her presence to go to his house.
Yes.
Now, since she was a former employee, she had left the job nearly 4.5 years ago after she was raped by the son. Now, after that, she was summoned by the first accused. So, readily she went with the accused number 2. Instead of taking her to accused number 1, the second accused takes her to the house of A8, that is the wife. Where A8 gives her a dressing down for remaining at home, because by then it was apprehended that she may lodge a complaint against her son. So it is in the, and thereafter she asked this lady to be taken to an unknown place. So A2, A3, A4, A5, all of them conspire and take her to the house of A7, who is the former officer on special duty of the first accused. Otherwise, there is no connection whatsoever between this victim and the. So it is in those circumstances that she was kept in the house of A7. And finally, she escapes on 4th May, after the election. On 4th May, she escapes and approaches the police, and by which time the son who got apprehensive that because of the the video going viral, that she is likely to be harmed. He lodges a complaint on,
Victim's son,
sorry,
the
the son,
victim's son.
victim's son.
Hmm. Yes.
First, he makes a phone call and the second accused gives a false pretext why she is not immediately available. And that is when he becomes suspicious and lodges a complaint. Her phone was not working because A8 had asked her phone to be snatched away from her. And that has been subsequently recovered from the house of A4. So it is in these circumstances, detention is proved, the abduction is proved, and even A7 in whose house she was kept, he has also given a specific statement that that lady was kept in his house at the instance of A8 and yes, A1. So it is in this backdrop, the complaint came to be lodged. Now, after the victim came out, she narrated the gory details of what she had been subjected to during
In that period,
entire.
while she was in captive.
She was kept captive, and also what happened earlier, why she was being taken away, was to prevent her from making a complaint against the son of accused number 1. Now, these facts are fully established by the evidence now gathered, and charge sheet has brought out in great detail all those facts. So
Yes.
this is the factual matrix.
I will go through that.
Yes,
Asha,
only matter of this nature, a bail should
we
not be
can-
granted.
Granted bail should be cancelled.
It has to, if the grant is invalid.
Yes.
Yes. May I request the court to kindly Yunus versus us. 2013 1 SEC page 365. One para at page 372. The allegations as they appear in the charge sheet dated 30th June leave no room for doubt that the accusations are of a very serious nature. In broad daylight, at 11:10 a.m., an elected representative of the people was attacked without any fear of the repercussions. The attacks resulted in serious injuries to him. In the aforesaid attack, at least 2 of the accused were in possession of guns. The MLA is alleged to have received gunshot injuries as well. The allegations constitute an open challenge to civil society. Kindly mark it. Constitutes an open challenge to civil society. The persons involved in the alleged incident cannot be accepted to remain disciplined if enlarged on bail. It is likely that they would threaten the witnesses, which would severely prejudice the outcome of the trial. In fact, it has been noticed in the impugned order passed by the High Court that accused 8, after his release on bail, had picked up a quarrel with the MLA on 1/3/2012, and an entry of the said aforesaid fact was recorded in the station general diary. The aforesaid factual position has been noticed in para 10. Same was emphatically highlighted by the learned additional solicitor general. It is also apparent that if the trial concludes by returning a finding against the accused, they would be liable to be subjected to extremely severe punishment. As of now, the period of their custody is trivial in comparison to the punishment prescribed for the offences they are said. So in the aforesaid view of the matter, we are satisfied that the main accused are clearly disentitled for the benefit of bail. He is the main accused in the case. Therefore, he is not eligible to be granted. And in the compilation that is filed, kindly turn to page 103.
Yes.
After reviewing the entire case law from para 7 onwards, the entire this thing is kindly come to page 103, para 11.
Yes. Yes.
Applying the law laid down by this court in the aforesaid decisions to the facts of the case on hand, and as observed herein above, we see no reason to doubt the credibility or trustworthiness of the prosecutrix. She is found to be reliable and trustworthy. Therefore, without any further corroboration, the conviction of the accused, relying upon the sole testimony of the prosecutrix, can be sustained. So, para 20 also.
25, page 1.
No, that's another judgment. And in the subsequent judgment,
That's a conviction case. Case of conviction.
that's
Page 10.
in the subsequent judgment,
Hmm.
para 24 and 25 may kindly be,
Hmm.
page 115. The fact that the accused is the son of sitting MLA would disclose the domineering influence he would wield, not only in delaying the proceedings but also in pressurizing the witnesses to either resile from their statements given during the course of investigation or pose threat to them from deposing against accused on their failure to act according to his dictate.
It is cancellation of bail.
Yeah.
439.
Yes.
Bail granted is cancelled.
Then the relevance of
Offense of 376D. Yes.
the relevance of statements under 161 and 164. Kindly come to the next paragraph. Last 4 lines. The prosecutrix had also named Deepak, having participated in the incident of gang rape, in her statement recorded under section 161 and 164 of the CRPC, and had also named him in the FIR. It is only on the strength of the application filed by the complainant under section 190, 193 of the CRPC, the trial court took cognizance against Deepak.
No, facts are very gory in this.
Yeah.
There, here bail should not have been granted. In
It-
this case,
it- In our case also,
facts are very gory here. It's 376D, gang rape and POCSO.
no, here,
Here we'll
the
see.
lady,
That we'll see.
she is of the age of his mother. And she holds his feet and requests him not to indulge himself on,
No, that is not against him.
no.
That is, you're talking of the video.
Yes, it is to prevent that complaint being lodged.
That will see,
Therefore, it
yes.
is more heinous. My very respectful submission is not one victim. Hundreds of them are there. And this is the first case. Even before the complaint is lodged, an attempt is made to destroy the evidence, to silence the victim, and to prevent this thing, the
Got it.
loss.
Yes,
So therefore, the accused is not entitled.
yes, sir. ಮತ್ತೇನಿಲ್ಲಲ್ಲ ಮತ್ತೇನಿಲ್ಲ. Yes.
ಸರ್ ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ ಅಂತ ಕೇಳ್ತಾರೆ ಸಾಹೇಬ್ರು.
ಇನ್ನೇನಿಲ್ಲಲ್ಲ
ಇಲ್ಲ.
ಅಷ್ಟೇ.
The settled legal position, the consideration applicable for cancellation of bail is totally different from considerations applicable where the grant of bail by the court is challenged. I'm sure your lordship would certainly agree with me. Here it is not a case of the prosecution seeking for cancellation of bail, but what is questioned before your lordship in this petition is they have challenged the order of grant of bail. But that is how, my lord, the Supreme Court has said in more than one case. Let me invite my lord's kind attention to the law laid down by the Supreme Court in 2020, volume 18, Supreme Court cases 693. Now in my compilation, serial number 2,
Yes.
may I request your lordship to kindly turn to paragraph 9 of this judgment. It is well settled that the consideration applicable for cancellation of bail, my lord gets it, my lord?
Yes, yes.
It is well settled that the consideration applicable for cancellation of bail and consideration for challenging the order of grant of bail on the ground of arbitrary exercise or discretions are different. While considering the application for cancellation of bail, the court ordinarily looks for some supervening circumstances like tampering of evidence, either during investigation or during trial, threatening of witnesses. The accused is likely to abscond and the trial of the case getting delayed on that count, etc. Whereas in an order challenging the grant of bail, well, this is what has happened in this present case. Whereas in an order challenging the grant of bail on the ground that it has been granted illegally, the consideration is whether there was improper or arbitrary exercise or discretion in grant of bail. The appellant has challenged the very grant of bail on the ground of arbitrary exercise of discretion, ignoring the relevant materials to be considered in the application for bail. Since the High Court proceeded under the footing as if the appellant had filed the application only for cancellation of bail for which the consideration is different, the impugned order is liable to be set aside and the matter is remitted to the High Court. But may I just request your lordship to kindly have a look at the first information report that has been filed by the son of the alleged person who is said to have been abducted. Well, at page 61, may I just request your lordship to kindly turn to page 61. Para 2.
Yes.
Well, bail came to be granted at a point of time when the investigation was still in progress. He was in judicial custody. The petitioner, the respondent before the lordship was in judicial custody. 2024ನೇ ಸಾಲಿನ ಸಾರ್ವತ್ರಿಕ ಲೋಕಸಭಾ ಚುನಾವಣೆ ಸಮಯದಲ್ಲಿ ಎಲೆಕ್ಷನ್ಗೆ 3-4 ದಿನಗಳ ಮುಂಚೆ ಮತ್ತೆ ಹೊಳೆನರಸೀಪುರಕ್ಕೆ ನಮ್ಮ ಊರಿನವರೇ ಆದ ನಮಗ ಪರಿಚಯದ ಹೆಬ್ಬಾಳ ಕೊಪ್ಪರದ ಸತೀಶ್ ಬಾಬಣ್ಣ ಇವರು ಮನೆಗೆ ಬಂದು ಭವಾನಿ ಅಕ್ಕ ಕರೆಯುತ್ತಾರೆ ಎಂದು ಹೇಳಿ ನನ್ನ ತಾಯಿಯನ್ನು ಹೊಳೆನರಸೀಪುರಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋದರು. ಚುನಾವಣೆಯ ದಿವಸ ಬೆಳಗ್ಗೆ ನನ್ನ ತಾಯಿಯನ್ನು ಬಾಬಣ್ಣನವರು ವಾಪಸ್ ಕರೆದುಕೊಂಡು ಬಂದು ಬಿಟ್ಟರು. ನನ್ನ ತಂದೆ ಮತ್ತು ತಾಯಿಗೆ ಪೊಲೀಸರು ಬಂದರೆ ಏನು ಹೇಳಬೇಡಿ, ಅವರಿಗೆ ಸಿಗಬೇಡಿ, ನಿಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಆಗುತ್ತದೆ ಎಂದರು. ಬಂದರೆ ನನಗೆ ತಿಳಿಸಿ, ನಾನು ಬಂದು ಕರೆದುಕೊಂಡು ಹೋಗುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು. ದಟ್ ಇಸ್ ಬಾಬಣ್ಣ. ದಿನಾಂಕ, that has nothing to do with the incident in question. That was prior to the incident in question. The incident question is on 29th of April 2024. ದಿನಾಂಕ 29/4/2024 ರಾತ್ರಿ ಸುಮಾರು 9 ಗಂಟೆಗೆ ನಾವು ಮನೆಯಲ್ಲಿ ಇದ್ದಾಗ ಸತೀಶ್ ಬಾಬಣ್ಣ ಇವರು ನಮ್ಮ ಮನೆಗೆ ಬಂದು, ನಿಮ್ಮ ತಾಯಿ ಪೊಲೀಸ್ನವರಿಗೆ ಸಿಕ್ಕಿ ಹಾಕಿಕೊಂಡ್ರೆ ಕೇಸು ಆಗುತ್ತದೆ. ಆಸ್ had happened on the previous occasion, he gets a message from the wife of the respondent and not from the respondent. ದಿನಾಂಕ 29/4/2024 ರಾತ್ರಿ ಸುಮಾರು 9 ಗಂಟೆಗೆ ನಾವು ಮನೆಯಲ್ಲಿದ್ದಾಗ ಸತೀಶ್ ಬಾಬಣ್ಣ ಅವರು ನಮಗೆ ಬಂದು, ನಿಮ್ಮ ತಾಯಿ ಪೊಲೀಸರಿಗೆ ಸಿಕ್ಕಿ ಹಾಕಿಕೊಂಡರೆ ಕೇಸು ಆಗುತ್ತದೆ, ಮತ್ತೆ ನೀವು ಸಹ ಜೈಲಿಗೆ ಹೋಗಬೇಕಾಗುತ್ತದೆ. ರೇವಣ್ಣ ಸಾಹೇಬರು ನಿನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಬರಲು ಹೇಳಿದ್ದಾರೆ ಎಂದು ನನ್ನ ತಾಯಿಗೆ ಹೇಳಿ ನಮ್ಮ ತಾಯಿಯನ್ನು ಒತ್ತಾಯ ಮಾಡಿಕೊಂಡು ಅವರ ಹೀರೋ ಹೋಂಡಾ ಸ್ಪ್ಲೆಂಡರ್ ಬೈಕಿನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ನನ್ನ ತಾಯಿಯನ್ನು ಎಲ್ಲಿಗೆ ಕರೆದುಕೊಂಡು ಹೋದರೆಂದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. But other than the statement said to have been made by this Satish Babanna to the son of the alleged victim, that the respondent had asked him to bring that lady who was a maid servant in the house of the respondent. Except in this, there is no other allegation against him. But the next question would be whether this allegation would constitute an offense which is made penal under section 364 capital A is the basic consideration. But may I just request your lordship to kindly have a cursory look at section 364 capital A. That is what the learned trial judge would say. It does not satisfy the basic ingredients that would constitute an offense which is made penal under section 364A. Well, it may constitute some other offense. Being kidnapped or being abducted.
62, what he says.
Yes, my lord. So it may constitute some other offense. Now, at the moment, we are only concerned whether it would constitute the offense which is made penal under section 364 capital A is the question. May I request your lordship to kindly have a cursory look at section 364 capital A now.
Yes, I am there.
Your lordship has.
I am there.
I'm sorry. Whoever kidnaps. Well, in the instant case, kidnapping is not there because kidnapping has been defined under section 362. It is relatable only to a minor from a lawful guardianship or beyond the bounds of the country. Now, or abducts. But let us proceed with an assumption for the sake of argument, though not conceding for a moment that there is abduction. Well, I shall take your lordship. What is abduction? How abduction has been defined under law? Your lordship would certainly get it. Well, that your lordship would get under section 362, abduction.
62.
362
is
abduction.
abduction.
How it has, deceit should be there. Well, deceit means, it is just like this. I'm sure your lordship would certainly agree with me. I am there. Somebody will come to me. Look here, your relation has met with a road accident. Though no such road accident has taken place. I am taken out of the place where I was staying. Then, my lord, he came to be taken out. That is a deceit. An event which has not happened. But here, it is not a case of the non-happening of an event. She was a maid servant in our house. Accept it as true. Revanna Sahabru, it is not a deceit as such. Now we will see. Abducts any person or keeps the person in detention after such kidnapping or abduction. Well, that person should be kept in detention. The person so abducted must be kept in detention and threatens to cause a death or hurt to such person. It will not stop there, my lord. Let us read till the last sentence. Threatens to cause death or hurt to such person, or by the conduct gives rise to a reasonable apprehension that such person may be put to death or hurt, or causes hurt or death to such person in order to. Well, all these things are relatable to what the statute would say now. In order to compel the government or any foreign state or international or intergovernmental organization or any other person to do or abstain from doing any act or to pay any ransom shall be punishable. But a threat is to this person who has been kidnapped. But the demand should be made upon any other person, not upon this lady who is in my custody. The demand upon any other person is for doing certain act or to abstain from doing that act or for ransom. Well, it may be a simple case of abduction if it is accepted to its face value as true, or a case of kidnapping. Now, it will certainly not constitute an offense under section 364, capital A would be my first submission. Well, this is what the learned judge would say, that prima facie, the allegations made in the first information report and subsequent material evidence which the investigator had collected during the course of investigation of the crime, as on the date of the consideration of the bail application, do not prima facie indicate the commission of an offense which is made penal under section 364A is a finding of the trial court. But in fact, this honorable court would also give a similar finding in this very case itself. But serial number 4 of my compilation. Prima facie view, well, enter in the page 9 of the order, in this very case.
Oh, Justice Dikshit.
page 9, my lord, internal page 9 of the order. In my compilation, page number 31.
Yes.
B. That his lordship would quote from internal page 5, the submissions are made. And even William Stephen's case in para 10, which my learned friend has referred to, has been referred to. Then, my lord, kindly go to page 7, internal page 7 of the order. His lordship would quote section 364A of the
Yes,
IPC
yes.
at clause C. Now kindly go to D now. This would be important. There is force in the submission of so and so that the provisions of section 364A of the IPC do not appear to be invocable in the case at its present stage. Although new facts that may arguably emerge during the progressive investigation may warrant its attraction. There is not even a whisper that the argued risk to abductor's life is at the instance of the petitioner, that is the wife. Forget about the husband. Even otherwise, no assumption of the kind can be made against the petitioner who is not named by the complainant or by his mother in her statement under section 164, 161 and 164 statement that are furnished in a sealed cover. Much discussion in this regard is avoided, lest the ongoing investigation should be affected. If the said provision is found to be prima facie not invocable, then the remaining offences alleged against the accused obviously do not attract the capital punishment. Life imprisonment or imprisonment for 10 years also. Companion section 365 is also a species of the offence of abduction / kidnapping, and it prescribes a maximum punishment of only 7 years. Therefore, it cannot be gainfully argued that in a matter like this, no bail or anticipatory bail or regular can ever be granted as a thumb rule. The oft-quoted slogan of Krishna Iyer in state of Rajasthan versus so-and-so, that bail is the rule and jail is an exception, has not yet been rendered much ado, signifying nothing. It still animates our criminal jurisprudence subject to all just exceptions, such as cases of terrorism, PMLA, treason, attack and defense, police personnel, etc. Of course, there are exceptions. So these exceptions is also true. However, such a case has not been made out by the respondent here. That being the position, the contention that the case involves a heinous offense that should abhor the request for bail, regular or anticipatory, does not merit acceptance. And this is what a coordinate member of this honorable court would say. Well, my learned friend has referred to William Stephens, which has been referred to by the learned trial judge himself. May I just request your lordship to kindly turn to please.
We will go to Stephen itself.
Stephen itself. Kindly go to paragraph 15. My learned friend invited your lordship's attention to paragraph 10. I would like to request your lordship to kindly have a look at paragraph 15. In fact, the trial court would refer to that. Stephen's case, my lord, the William
Yes.
Stephen's case, I have produced.
I'm at page 101.
Para
para
17,
15.
my lord, para 17.
That's at page 102.
Yes. Para 17. My lord, of this paragraph, paragraph 15, from the bottom about 5 or 6 instances above, in a given case, if the threats given to the parents are close relatives of the kidnapped person by the accused are established, then a case can be made out that there was reasonable apprehension that the person kidnapped may be put to death or hurt may be caused to him. However, in this case, the demand and threat by the accused have not been established. The demand and the threat must be upon some other person other than the person who has been kidnapped or abducted. It is not the case of the prosecution that any one of the accused, let alone the respondent before your lordship in this petition, has put a threat upon some other person, either requiring him to do what he was not required to do or forbear from doing what he is required to do. In fact, may I just request your lordship to kindly turn to paragraph 28 in the order which is impugned in this petition at page 52. in page 52.
Yes.
To sum up, it is pertinent to note that the allegation which has been leveled against the petitioner hearing is of abducting the victim. However, the ingredients which are required to be established at this juncture, as laid down by the Honorable Apex Court in the judgment reported in 2024 SCC Online SC 196, William Stephens versus State of Tamil Nadu, is not made out at this juncture. It is noticed from the records that although the allegation leveled against the petitioner is of abducting the victim, no materials have been produced to indicate his active role at this juncture. It is made clear that the observations made are only for the purpose of ascertaining the prima facie case, and no observations are made with respect to the merits of the case. In the instant case, the victim has been rescued, and also her statement has been recorded. Even otherwise, as per the remand application, the petitioner is not required for custodial interrogation in sought for remand into judicial custody. Though a serious allegation is leveled against the petitioner's son, the same cannot be a ground to reject the bail petition unless it is pointed out that he would be a menace to the society. Now, the basic question is, number one, whether he has the jurisdiction to grant bail. Number two, whether the order so passed granting the benefit of bail to the petitioner is perverse. But may I just request your lordship to kindly have a look at section 439. But even in a case which involves a death sentence, the court has the jurisdiction to grant bail.
That's it.
Even the magistrate can grant bail. Sessions court can grant bail. High court can grant bail. Then the question is, they can't say that the court has no jurisdiction to have entertained
That
bail.
is not the grounded.
That
Jurisdiction is not the ground.
ground also. But what is
Irrelevant considerations is the ground
That's
for
right.
grant of bail. Yes. Heard the learned senior counsel, C.V. Nagesh, Professor Ravi Kumar appearing for the state, and learned counsel, senior counsel C.V. Nagesh representing the respondent. Heard reserved.
Well, the next matter,
Next,
I have questioned, my lord, the registration of the FIR and for quashing of the FIR.
ಯಾವ್ದು ಇದ್ರದ್ದು?
ಇದೇ ಕೇಸಲ್ಲಿ
ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅಂತಾರೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕೋದೇನು ತೊಂದರೆ ಇಲ್ಲ.
ಅಲ್ಲ, ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲಿ?
ಇಲ್ಲ, ಸ್ಟೇ ಇಲ್ಲ.
ಇಲ್ಲ, ಸ್ಟೇ ಇಲ್ಲ ಅಂದ್ರೆ ಇಟ್ಸ್ ಬೆಟರ್ ಯು ಫೈಲ್ ಅ ಫ್ರೆಶ್ ಪೆಟಿಷನ್.
But I will seek for amendment. That is what the Supreme
No,
Court
if
has said.
interim order is there, generally what I do is, interim order is there, I permit
What the
amendment.
What the Supreme Court.
No,
has
no, I
said.
am aware. Supreme Court says filing of the charge sheet in the teeth of the pendency of the petition would not make the petition infructuous, it can be amended, all that
My lord,
fine.
if my lord were to agree with me, my lord, that the first information report needs to be quashed, then my lord, the rest of the investigation that has been done, which culminated in the filing of a charge sheet also goes, is the law laid down by the Supreme Court.
That will. All right, other will take it another day. Yes.
As my lord pleases.
ಯಾವ್ದು serial number 17 ಅದು?
ಹೌದು.
Notice
Even
ಆಗಿದೆ.
without seeking for an amendment. That is how the
That
Supreme.
is true.
That is how the
Amendment is
Supreme
not
Court is.
mandatory, that is.
Well, again, the same point.
No,
where it
why I generally say is, if
Yes,
the
yes.
charge sheet also is challenged,
No,
grounds are different. No, if it is, even charge sheet is filed, and if it is challenged, grounds are different.
Well,
You
how
can
the-
hear it whole hog and just.
how the Supreme Court in several of the judgments commencing from the case of Pavitra and Mr. Bhatt has said is, where the first information report, the registration of a crime has been challenged. What needs to be seen by the court is whether the allegations made in the complaint,
that is
coupled with
correct.
the
That's
documents,
not a-
if any filed
that is
along
not
with
a
the
problem.
complaint, constitutes any offense or not. If my lord is persuaded to accept my submission that the registration of the crime itself as against me is bad for an offense under section 364A, and ultimately, if the court were to agree with me, if the first information report goes, well, the charge sheet also becomes near. Anyway.
We'll hear it, please. Office objections ಏನೋ ಇದೆ?
We have furnishing of the order sheet and ಹಾಕಿದೆ.
ಹಾಕಿದ್ದಾರೆ. The advocate on record would submit that the heard the learned senior counsel sounds ಮಾಡಿ. The advocate on record would submit that the office objections are complied with. List the matter on objections ಹಾಕ್ತೀರಾ?
Will file.
They have filed.
Already filed, huh?
Yes.
Filed.
Already,
Filed,
list
filed.
on, list next week.
Yes, my lord.
Yes. List on 8th.
Please.
Yes.
23 is correct. 23.
ಏನ್ 23?
That is for seeking bail for other accused in the same matter.
ಅಲ್ಲ, ಬರೀ ಕರೀತೀನಿ, ಒಂದ್ ನಿಮಿಷ, wait. The 23 argument ಆಗಿದೆ. ಇರೋದ್ ಪರವಾಗಿಲ್ಲ. Visible ಹಾಕೊಳ್ಳಿ. Next.
18?
awaiting police report. Post immediately after service of notice upon, post immediately after the service notice upon the second respondent, interim order, continue ಮಾಡಿ. Next. 19. 2 weeks time to do the needful. List the matter on 22nd. Interim order subsisting will continue till the next date of hearing. Interim order ಇದೆ ಇದ್ರಲ್ಲಿ? But then needful, why steps are not taken? Yes. By oversight. Yes, we will dismiss it henceforth. The steps are not taken. Yes, 22nd.
20.
2 weeks time is granted to comply with the office objections. In the event the stand complied, list the matter on 22nd in the fresh matters.
21.
Interim order ಇದೆಯಾ?
Two is a government servant,
Government servant.
election
Flying-
official.
Flying squad, sometimes the flying squad, my lord, that they engage, the election commission engages council.
If I can serve on the.
Oh,
ಮಾಡಿದಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
ಆಯ್ತು ಸರ್ವನ್ ಶರದ್.
I'll do.
The last occasion they have appeared in some other case.
Flying squad election ಆದ್ಮೇಲೆ ಮುಗೀತವ್ರು.
Last-
They will report to you and go away. ಆಮೇಲೆ ನೀವೇ ಡಿಫೆಂಡ್ ಮಾಡ್ಕೋಬೇಕು.
No, we have no problem, unless if there is.
ಇದು 171
ಇಲ್ಲ, 125.
125 RP. Yes.
Election speech.
Council Shri Sharad Dodwad is directed to accept notice for the second respondent petitioner to serve set of papers upon the aforesaid council. List the matter on 22nd. 22nd Thursday, ಅಲ್ಲ? List the matter on 22nd. Interim order subsisting shall continue till the next date of hearing. Next.
22.
Covered by ಇದೆ.
ಇದೇನು?
Covered by.
Covered by.
92
What-
page
what
number.
covered by?
Same case,
ಯಾವ್ದು?
same case ಅಲ್ಲಿ cost, ತಾವೇ cost.
Pass ಆಗಿದೆ.
ಯಾವ್ದದು?
Page 92, ma'am.
Epidemic disease.
1 minute, 1 minute.
Page 92.
92 ಆ?
Yes.
92.
Five nine one zero, criminal petition.
Huh?
Criminal petition 5910.
5910. ಆಮೇಲೆ ಯಾವ್ಯಾವ್ದು ಇದೆ ಇಲ್ಲಿ?
ಬೇರೆದು
ಫಾಲೋ
ಇಲ್ಲ.
ಮಾಡಿರದ?
ಬೇರೆ
5910 is followed.
Follow ಮಾಡಿ.
Page 94. ಆಮೇಲೆ just quote the orders that are followed. Next.
3.
Connected ಏನು? Connected to that matter.
16.
ಹಾ. ಇದ್ರಲ್ಲಿ asking bail,
Yes, ಹೌದು.
that is rejected there.
Bail is rejected. Yes.
Charge sheet is filed, they can go back.
Would it not be better if it is taken up next week?
Twice it was urgent, my lord. My problem, accused number
Ah.
6, my lord, his father died. He is the only son. That the only allegation is that he transported the victim from point number B to point number C. After, my lord, she was picked by accused number 2. That is the only allegation. That accused number 2 picked the victim from Hebal to Saligram. From Saligram to Parmos, I transported. That is the only allegation.
Against, you are appearing in which, sir?
Number 6, my lord.
ಅಲ್ಲ, 23
Yes, accused number.
or 23.1?
Yes, 23, my lord. Ajay and others. Sujay and others.
Sujay and others.
So that at least, my lord, accused number 6 may kindly be considered because the father died during the, after filing of the case. And my lord, he was granted some time to attend the funeral ceremonies.
Interim bail ಕೊಟ್ಟಿದ್ರಲ್ಲ?
Kottidru now he has already surrendered now. The only thing is, my lord, the mother is almost about 80 years and she is admitted.
Why is it rejected?
But only on the ground that there is overact on the part of the accused. My lord, page number 67, my lord. Page number 67.
No, charge sheet is already filed in
Blood, that's
all these
okay.
cases.
Blood, what applies here, blood,
So
is
charge
section
sheet-
365.
Charge sheet ಎಲ್ಲರ ಮೇಲೂ ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ.
Blood, what applies?
Direct
blood,
evidence, 138 witnesses have been examined. record
But
statement.
so far as I am concerned, accused number 6 is concerned, absolutely nothing, but kindly similar to paragraph 34. and
No, are you aware of the charge sheet or you have seen it?
We are aware, we are
Tell me the
aware.
charge sheet. Tell me.
Copy.
You don't have the copy of the charge sheet?
Place it. Only on 29/7 it was filed. By next date, we'll place the charge sheet.
Because there it's cancellation of bail. Here it is grant of bail, which has been
Page
rejected.
Well, there is a
67.
direct indictment of all the accused.
ನಿಮ್ಮ ಹತ್ರ charge sheet copy ಇಲ್ವಾ?
Not yet received, Lord.
Yes, sir.
Page
20
67.
60?
In criminal petition number 5923 of 2024, page 67, paragraph 34. The court has carefully appreciated the materials available against accused number 3 to 7 as deciphered from the records, as already discussed above.
You are accused number?
6, accused number 6. Of course, he was not named in the FIR earlier.
ಅದು ರಿಮಾಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ?
Howdu. As already discussed above, the records indicate that accused number 3 has played an active role in accompanying the victim. Accused number 2 from Saligram to farmers of accused number 7 Rajgopal. The record also indicates that mobile phone belonged to victim was recorded from A2 to A4, which he had handed over to his brother to keep the same in his custody. And later on, it was recorded by the investigating officer. The act of accused number 3 to 5 in aiding and helping accused number 2 to take the victim to the farmers of accused number 7 Rajgopal clearly indicates overt act against them. It is also relevant to note that accused number 6 Kirti is a relative of Sri so-and-so, and as per the statement of victim, the accused number 6 has accompanied her along with accused number 2 to the farmers of Rajgopal. And later on, CDR extracts indicate that he had conversed with accused number 7 towards keeping her in the farmhouse. Now, kindly similar to what happened in the farmhouse is that his lordship has considered while granting the anticipatory bail to accused number
8.
Yes, ma'am. Srimati Bhavan. That we have given the list of authorities that in that kindly see paragraph 14
Yes.
in the compilation given by me.
ಈಗ ಇದು ಯಾರ್ಯಾರ್ದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 6.
But I appear for
3, 4 and
4 and 6.
You are appearing for
3, 4 and 6.
3, 4 and 6. Then the companion petition?
7.
A7. 23.1 ಯಾರು? A2. Yes.
But kindly see the compilation.
23.3, not that is A5.
33?
23.3, A5.
Oh, ಅದು ಇದೀರಾ?
ಹೌದು.
So all these are connected.
23.2 is A7.
ಅದಾಯ್ತು. So A 2, 3, 4, 5, 6, 7 all are here. A8 is granted bail.
A1 is also not granted.
A1 is granted and that is challenged. Yes.
But in the compilation, the first judgment. But page 14 may kindly listen. The victim herself, in her 164(5) statement that was recorded on 18/5/2024, has categorically stated that she was given food. However, from the paradoxical version, one cannot hastily jump to a view that the victim was in the custody confinement of the petitioner's accused, matter being in bail jurisdiction. He has not uttered anything about the so-called manhandling during the confinement. Even in 161 statement recorded on 18/5/2024, there is nothing of the kind. The fact remains that the abductee is back home. Now, FIR Mallard is
One minute. Objections are filed?
Objections are not filed.
I didn't file his objection.
But accused number 6, no, this is my problem. The father died and
No,
mother
that's
is
true. We will
already
give him some
hospitalized.
time. Objection ಹಾಕ್ಲೇಬೇಕು.
The only allegation is she transported the victim from
No.
point B to point
Allegation,
C.
that is fine. I will give 2-3 days time. Let them file their objections. I will consider. Without objections, I will not. ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ?
Last occasion, they have served the copy to me.
ಹಾಕಿದ್ದೀರಾ? ಮತ್ತೆ ಹಾಕಿಲ್ಲ ಅಂತ. Yes, sir.
But FIR refers to 364A and 365. Blood, I respectfully adopt the arguments of Sri Sivanagesh sir. Blood, kindly see 365. But the worst case scenario is 365. But kidnapping, Lord, your lordship, sir, kidnapping will not apply because neither a minor nor a person of unsound mind, and there is no
Yes,
question of
yes.
removing the legal from the legal guardianship. Whoever kidnaps or 365, my lord, whoever kidnaps or abducts any person with intent to cause that person to be secretly and wrongfully confined shall be punished with imprisonment, either of description for a term which may extend to 7 years, and shall also be liable to fine. The statement made by the victim clearly narrates that she was not ill-treated, she was given food and all. Therefore, 364A is completely ruled out. The worst case scenario is 365. But that was mentioned in the, my lord, in the FIR. But I, my lord, again rely on the judgment of the Stephen, which my senior,
Yes.
my lord,
William
referred to.
Stephen, yes.
Yes, ma'am. Lord, in that, my lord, paragraph 10.
When were you taken into custody?
Lord, on 16th of May, 16th of May 2024.
Hmm.
Lord, it is, of course, Stephen refers to 364A. It is not even 364A because at the most, the allegations made against the accused number 2 is referable only to 365. Kindly see the FIR, my lord, at page number 9.
Yes.
It is already read out to your lordship.
Hmm.
ಈ ದಿನಾಂಕ 2/5/2009 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ರಾಜು ಬಿನ್ ದಕ್ಷಿಣಾಚಾರಿ KR ನಗರ ಠಾಣೆಗೆ ಹಾಜರಾಗಿ ನಾನು ಮೇಲ್ಕಂಡ ವಿನ್ಯಾಸದಲ್ಲಿ ಐ ವಿಲ್ ಸ್ಕಿಪ್ ಆಲ್ ದಟ್. ಐ ವಿಲ್ ಕಮ್ ಸ್ಟ್ರೈಟ್ ಅವೇ ಟು ಮೈ ಲಾರ್ಡ್ 10th ಲೈನ್. ದಿನಾಂಕ 29/4/2024 ದಿನಾಂಕ 29/4/2024 9 ಗಂಟೆಗೆ ನಾವು ಮನೆಯಲ್ಲಿದ್ದಾಗ ಸತೀಶ್ ಬಾಬಣ್ಣ, ದಟ್ ಇಸ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2, ಇವರು ನಮ್ಮ ಮನೆಗೆ ಬಂದು ನಿಮ್ಮ ತಾಯಿ ಪೊಲೀಸ್ನವರಿಗೆ ಸಿಕ್ಕಿ ಹಾಕಿಕೊಂಡರು ಕೇಸ್ ಆಗುತ್ತದೆ ಮತ್ತು ನೀವು ಸಹ ಜೈಲಿಗೆ ಹೋಗಬೇಕಾಗುತ್ತದೆ, ರೇವಣ್ಣ ಸಾಹೇಬರು ನಿನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಬರಲು ಹೇಳಿದ್ದಾರೆ ಎಂದು ನನ್ನ ತಾಯಿಗೆ ಹೇಳಿ ನನ್ನ ತಾಯಿಯನ್ನು ಒತ್ತಾಯ ಮಾಡಿಕೊಂಡು ಅವರು ಹೀರೋ ಹೋಂಡಾ ಸ್ಪ್ಲೆಂಡರ್ ಬೈಕಿನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿರ್ತಾರೆ. ನನ್ನ ತಾಯಿಯನ್ನು ಎಲ್ಲಿಗೆ ಕರೆದುಕೊಂಡು ಹೋದರೆಂದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ನಿನ್ನೆ ದಿನಾಂಕ 1 ಮಧ್ಯಾಹ್ನ ನಮ್ಮ ಊರಿನ ಸ್ನೇಹಿತರಾದ ಸೋನ್ಸೋ these allegations are not necessary. Now the allegations against respondent 346 is that after accused number 2 Satish Babanna picked the victim from Hebal to Saligram, from Saligram to Malad Pala Hosur, that is the farmhouse of accused number 7, I transported her in a car. That is the only allegation that the judge says is overtime. But in my respectful submission is, even going by 365, no case is made out. And the father died, my lord, and it's already on record. Mother is almost, my lord, 86 years old. She is hospitalized. Therefore, my lord, 346, my lord, I respectfully pray for, my lord, release on bail.
All 346 mothers are
3-4. Okay, I'm sorry.
6 matra.
Allen collateral sympathy illa. The allegations against 346
In the later ways.
I am not I. Scott Millard, I.
Yes, sir.
We'll place the charge sheet before the court. That may be called tomorrow.
All right. Produce ಮಾಡಿ. We'll list it tomorrow.
Please.
ಎಲ್ಲರದು ನಾಳೆ ಕೇಳೋಣ. ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡ್ಬೋಣ.
Please.
Charge sheet is filed against all for
All-
364.
Yes, all.
A1 to A8.
One accused is absconding.
One accused is absconding.
Yes.
Which
He's not-
accused is absconding?
Either.
ಇದ್ರಲ್ಲ. ಅಲ್ಲ, 8 accused, how many accused?
18 accused.
All 8 are here.
Nine accused.
A9 is absconding.
A9 is absconding.
The main accused
And-
are on bail.
And the phones of all the main accused, they are not traced till this. In spite
Not
of,
traceable.
not traced.
Yes, we'll see. Tomorrow we'll take it at 4 PM.
Very well.
You produce the charge sheet. Let me see the charge.
Please.
Heard ಎಲ್ಲರದು ಹಾಕಿ. All these together tomorrow at 4 PM. ಬರ್ಕೊಂಬಿಡಿ. ಯಾರ್ಯಾರ್ದಾಗ all senior counsels ಯಾರ್ಯಾರ.
Serial number 75 is another matter. It's not.
Connected to this?
Not exactly connected to this, but It is for quashing.
Quashing is it?
Yes.
Quashing we'll see, we'll consider later. ಇದು bail ಅಂತ ಅಷ್ಟೇ ಇವತ್ತೆಲ್ಲ ಕೇಳಿದ್ದು.
It's coming up for the first time.
That we'll see.
I pray for.
Because
time
it is
to-
bail.
Yes. I pray
I've
for
heard
time.
these matters because it is bail. Bail should be
Number 20.
either this way or that way closed. No keeping bail petition pending.
Very well.
Yes. Office objections. 2 weeks' time is granted to comply with the office objections. In the event the stand complied, that's the matter on 22nd.
For the petition in serial number
22nd, 22, 20? You are,
Petitioner in
comply. Interim order ಇದೆಯಾ?
ಇಲ್ಲ.
22nd, yes.
25.
Rakshit,
Petitioner, my lord. The R2 is none other than the state,
state flying squad,
by flying squad.
ಅದು flying squad ಅದನ್ನು?
ಹೌದು.
Then same, Sharad Dodwad is directed to accept notice for the second respondent petition to serve set of papers upon the aforesaid council. List the matter on, interim order ಇದೆಯಾ?
It's covered, my lord.
Stay ಇದೆ.
First ಅವ್ರಿಗೆ ಬನ್ನಿ.
Stay ಇದೆ.
Yes, list the matter on 22nd. Yes, we'll close it on that day.
There's an interim order, my lord.
Interim order subsisting will continue till the next date of hearing.
26.
Covered by. Number 57 covered by.
20?
26. Covered by.
Office objection, covered by, ಬೇರೆ ಏನಾರು ಹೇಳ್ಬೇಕಲ್ಲ?
No, because.
Office objections, same
Same. Okay. 3432, criminal petition number 3432.
Order will be released only after compliance with the office objection. Covered ಅಂತ comply ಮಾಡಲ್ಲ. ಯಾಕೆ ಹೋಗೋದೇ ಇಲ್ವಾ ಆ ಕಡೆ ಫೈಲ್ ಮಾಡಿದ್ಮೇಲೆ? ಫ್ಲಾಗ್ ಹಾಕಿದ್ವಿ. Yes. Next.
27.
2 weeks to comply with the office objections. In the event the stand complied, list the matter on 22nd.
28.
I am for petitioner in this case, my lords.
Same
This
order.
offense is 171G, my lords.
He's challenged
Comply
the
with the,
FIR. He's challenged the FIR. Charge sheet has been filed.
ಮತ್ತೆ challenge the charge sheet, sir.
Yes, my lords.
Stay
Yes,
there.
my lords.
Yeah, ಮಾಡಿ. Yes. Next.
29.
2 weeks time to comply with the office objections. Same order. 22nd. 30.
Paper petitioners. But the relevant portion of the order sheet is legible.
Council submission ಏನು?
But the relevant portion is legible. Is
ಅದೊಂದೇನಾ?
ಅಷ್ಟೇ.
Heard Land Senior Council, office objection, accepting the submission, office objection stand overruled on 8th. Urgency.
Where B report has been filed, my lord, that against which, my lord, now protest petition has been filed by the
So
complainant.
what?
But now the cognizance has been taken, therefore. my lord,
So what?
From urgency, my lord, day after tomorrow matter is there.
Day after tomorrow matter ಇದೆಯಾ?
Therefore, my lord, kindly see, my lord, the allegation is against, my lord, accused number 2 and 3. That, my
Comment.
lord, being a council, misused the papers, my lord, blank sheet and, my lord, the wakalat given. That is the allegation. I am only signatory in the Lok Adalat, my lord, where I am also a party in the.
Tomorrow. ನಾಳೆ.
Please, very-
Tomorrow, 4 PM. Yes.
31.
Lordship, the office objection wherein we have claimed the council submission in this matter. Respondent number 2, we've made a party. View of the fact that we would want to produce the documents of respondent number 2 as collateral as opposed to withdrawing
note.
ours, your lordship.
Why have you made,
He's not just the husband of the petitioner, also 99% owner of the property wherein the attachment has taken place.
Archana, what's the problem?
Yeah, your lordship, the petitioner is the wife.
No, not on the merit, wait, man.
They've only asked why we've made R2 a party. R2 would be a necessary party in view of the fact that our prayer to substitute the properties of.
What are you
respondent number
challenging?
two. Your lordship challenged the order of the,
Is he a party there?
he's a party there, your lordship. He's accused.
Of his objections overruled. Accepting heard Senior Council ಮಾಡಿ overruled.
Urgency is the
What
day after
urgency?
tomorrow, your lordship. They're proceeding to pass
Tomorrow.
orders tomorrow.
Yes. Yes, next.
32.
Post immediately after service of notice upon the respondent. Interim order ಇದೆಯಾ?
Sentence has been suspended.
Huh?
Sentence has been suspended.
Suspend. so and so, rest after 2 weeks. Immediately after service of notice. Next.
Furnished, madam. Taken steps and furnish the copy.
A week's time is granted to comply, to do the needful. Intermodal idea. Intermodal idea.
Intermatter.
Agidiya.
Suspension. of contempt.
Council submit needful has been done, office to verify. Yes, next. Revision petition, all right, yes, yes.
Revision.
Next.
34.
This matter, my
Yes.
lord, I have gone through the order. I think what relevant, my lord, probably the depositions before the trial
Yeah,
court need
the-
to be looked into it.
Why?
This is that matter, my lord.
Same
31
matter,
319.
My lord,
Special
I have
situation.
been served with copy of 1 to 5, respondent 1 to 5. And
One case, my lord, of Delhi
This is
High
what-
Court.
Without,
One case of Delhi High
without
Court.
turning someone hostile, you can't cross
I
examine.
may not depend upon our coordinate bench's judgment much because, my lord, I have got a stronger judgment of
Strong-
Delhi
Oh,
High
sir.
Court, which, my
Can
lord,
say this.
directly relies upon Prafulla Chandra Sarkar.
Ah.
What Delhi High Court, my lord, says is this: while interpreting section 154, the word hostile, adverse, all these things are irrelevant. Let us simply look at it by its words.
We'll answer
Section
everything. I
154
thought
does
this was
not say.
tomorrow. I thought this was tomorrow anyway.
No, my lord,
It's all right,
today.
yes.
my lord, may I file Wakalat for you?
Yarige, sir?
1 to 5.
R12?
Or 1 to 5, my lord, the
I may
accused
be
before the
permitted to
court.
come on record for R1 to 5. I've
R6
been
is the
served with
complaint.
copy.
One moment, sir. one
Last
moment.
night I was
Ju-
served
Just,
with
just a
copy.
moment. R125, 6 year complainant,
De facto complainant.
yes. Learned, our ಹೆಸರೇನಾ?
Yeah.
Learned Counsel CH-17 accepts notice for respondents 1 to 5. Registry to print the name of so and so is appearing for respondent 1 to 5. Yes. Defer ಮಾಡಿದೀವಲ್ಲ.
Defer ಮಾಡಿದ.
My lord,
ಒಂದು
I
ವಾರಕ್ಕೆ
have- I
defer
have a very serious threshold objection.
Yes, sir.
If you may seek my lord's kind indulgence to submit of that.
Yes, sir.
My learned friend at the very outset has no locus standi to represent the state now because he has not been appointed a special public prosecutor for the High Court matters. His appointment is confined only to the trial court.
There is no such confinement as such, my lord. The notification doesn't read it.
Jurisdictional issue.
The notification never reads, my lord. Otherwise, my lord, it can't be there, my lord, when a special prosecutor is appointed under 24(8). Can it be confined, my lord, only for one court, my lord? That has become a practice, my lord, to appoint special prosecutors for different courts. But, my lord, in my humble view, 24(8) doesn't say that. If a prosecutor is appointed special prosecutor under 24(8), my lord,
So trial court in the apex ವರ್ಗು ನೀವೇ ಅಂತ.
unless and until, my lord, the government confines my appearance only for High Court, only for, my lord. Otherwise, also it is an anathema to section 24(8), my lord. How can there be, my lord, limitation of special prosecutor? One special prosecutor for trial court, one special prosecutor for High Court, my lord. Can it be that way?
But that 24 does so. There is an order for appointment of regular public prosecutors and another provision specially meant for appointing of special public prosecutor. It does speak of, it does mention of both. My lord,
So you'll have to answer this.
That would be another question, my lord, I think.
Not by saying anathema, you have to get something else.
My lord, anyhow, that will be another question, my lords. My lords, maybe this.
Nextly, my lord, another objection is he has not been authorized to file this revision petition. That must be an authorization.
301, my lord.
My lord, on the top of all this, it is an interlocutory order.
It's an
This is an interlocutory order. And criminal revision petition does not lie.
Is not
He has
an
filed a criminal revision petition into this honorable court. On how many scores his petition is not sustainable?
Yes, sir.
301 may
No, no.
kindly be, my lord.
Scores more than one to
I-
dismiss it.
My
Yes.
lords may be delivering a judgment, my lord, on more than one score as such.
We'll see, yes, sir.
My learned friend is always anxious to take sustenance from 301. I shall read this. Yes, para 33, Swami. Para 33 of the case law. Section 24(1) CRPC deals with the specific power of the government to appoint public prosecutor. Section 24(8) confers the powers on the state government to appoint a special public prosecutor for any case or class of cases. To give an example, there can be a batch of cases under the Prevention of Corruption Act against a number of persons arising out of different FIRs, but involving similar transactions. To have a proper trial, the government is entitled to appoint a special public prosecutor. The word case is given a meaning to include the appeal. It will be denuding the power of appointing authority. The law does not so countenance if the government by a notification appoints an eligible person, clearly stating that he shall conduct the trial as well as pursue the appeal arising out of it, there will be no difficulty. Therefore, much stress can't be given on the words without any written authority as used in section 301. It can only mean that the public prosecutor once engaged. May I proceed, Ma'am?
I've read, sir. Yes.
Under 301, he can't make any submission to sustain of his appointment.
Because 34, the apex court says, fourth respondent was not appointed by the state of Karnataka to argue the appeals before the High Court. He was not authorized to represent the prosecution.
I'll clarify that. I'll clarify. I'll clarify, my lord. Firstly, the locus. I was, my lord, reading 301 for a different purpose.
Now you read for this purpose.
This purpose, my lord, on the locus, my lord, especially my notification.
Hmm.
301, my lord, I was proposing to read for a simple reason
Hmm.
that once 301, I can take, my lord, any action, any measures which I feel, my lord, in the interest of, my lord, meeting the justice. Now, my lord, for every small thing, should I keep asking the government, should I do this? Am I permitted to do this? If I feel, my lord, while
In your
conducting
confines there, you need not ask. But if you want to step over and above that, I guess that's what the apex court says, unless you
my lord, I'll go through this judgment.
Clarify.
I'll make my submission.
Anbalagan. Judgment Anbalagan.
Yes, unbalagan. I'll go through this.
Yes, sir. Nale?
Jagdish Nale.
One issue, my lord,
is there in this.
one issue, my lord, which I've gone through this paper. The two issues for consideration of treating the witness as hostile. One, it has to be earlier statement, or it has to be about the truth.
Yes.
To find out whether he's saying truth or not, there should be a foundation. That foundation has to be looked into whether he is cross-examined the other witnesses. The order sheet, order, my lord, the impugned order at least discloses some of the witnesses who have deposed against only one accused. Even for them, the prosecutor is not cross-examined. So that is one of the ground where the sessions judge has held that this you can't be picking and choosing things. So when there is no foundation.
Now, well, after I went through the papers, your motive appears to be cross-examining the investigating officer for a particular purpose of drawing a political motive to it. Beyond that, there is nothing.
I will clarify this.
Yes.
My lord, on the cover
There
of
can be not, what do you want to say in the cases? Investigating officer, because the court has said he has washed off his hands, because the pressure came from a political entity or whatever. Now you want to bring in all the investigating officers saying you want to elicit evidence from him that yes, because of this man, I left all the other 5 and put in accused number 6. That is where you're wanting to ask CW 35, right?
CW 35, 36 and 37.
CW 35, 36 and 37 who are investigating officers to elicit that by putting leading questions.
Yes.
What is a leading question?
No, my lord, I may not.
No,
even
it is where you elicit evidence of your choice. That is the question that you put, that you can't do unless you turn the witness hostile.
May I just, I'll just, my lord, just pass on, my lord, this only one line.
Trial court, my lord.
Kindly, my lord, have paragraph.
For permission to put questions.
Kindly have, my lord,
which can
page
be
number.
put in cross-examination.
Yes, exactly. That is what.
But that prayer was made only on behalf of CW
35, only 35.
On behalf of two more police officers.
Shyam Sundar sir.
My lord.
Your request before the court was to put questions to CW 35 only. that application is considered.
Yes,
That is rejected.
yes.
Saying that unless you treat him hostile, you say you don't want to treat him hostile, but you want to put leading questions, elicit evidence. Why he dropped 1 to 5? Because of the pressure of the political entity. That's all your intention. Correct.
On the cover of it, it looks so, my lord, and I'll satisfy your lordship. On the wrapper of it,
Very
my lord, it may
outset,
appear
Swami,
so.
charge sheet was
course.
filed.
My
Don't-
lord, kindly have only
We-
1 minute, my lord.
We
My
will
lord,
not
kindly
judge
have
your,
the paragraph
we will
number.
not judge your argument by the wrapper. Yes.
Certainly, my lord, I'll take, on the cover of it, my lord, it may look soiled. It may look, my
Even
lord,
to
pick
this
and choose,
day-
but it is not so. I will say, my lord, why. I'll dilate and say, my lord, why I did not choose to cross-examine the other witnesses. Insofar as the other witnesses, my lord, as long as, my lord, they are beneficial to the 319 case, my lord, not necessarily the prosecution case, my lord, I need not to cross-examine them, my lord.
Now,
All that I'm-
accused 1 to 5 are brought back into the web of
Yes.
proceedings under 319.
319.
You proceed against them.
I am, my lord.
Yeah, do that.
To do that, my lord, to do that, there is only one investigation. There has not been, my lord, a
See,
different
we'll answer
investigation.
whether turning someone hostile is imperative for putting leading questions.
Precisely, my lord. Kindly, my lord, have page number 5, my lord. Only 2 sentences, my lord, on page number 5. The pagination is in the bottom. Page number 5, my lord. Second paragraph from top. My lord, the extraction of, my lord, extraction. AIR
I'll-
ಅಂತ start
I'll
ಆಗಿದೆ.
take it tomorrow.
So great.
Yes,
So great.
we'll take it tomorrow.
Lord,
We'll answer.
I'll answer, my lord, the concern of the amicus curie that I may be trying to, my lord,
Marcus,
pick and choose. Pick
be
and
sure.
choose.
Mm.
The IO,
Yeah, secondly-
IO had put a dead end to my learned friend's case. Charge sheet was filed into the committal court only against accused number 6. As against my client.
No, the court has
As-
observed.
My lord, in respect of 1 to 5, B report was filed.
No,
Notice
true.
was-
See,
yes,
that is
he was-
what the court has said.
Complainant was notified of the B report.
That's
They
all-
never, they
that's
never
all right.
contested it. They never contested.
Now
the
this
B report.
319 order has become final.
Yes, it was not challenged. It was not challenged.
Now all that is history.
How-
B
how
report
can we
not
revive?
contested.
How can he revive? When
No, this
case-
order has become
no, no.
final.
Case reached the stage of adducing of evidence in respect of ASA, they came up in examination chief.
Correct.
They
No
in-
problem.
They developed their case.
But
As
this,
to make out
this
the
has
case
become
against
final.
case.
This has become final.
Accused number 6 is, my lord, once he is to be sent out to accommodate these 5 accused persons, what order the session judge was supposed to make? Charge had been framed, evidence had been adduced, then he would proceed to discharge the accused.
But this is not
acquit.
challenged. What can be done? 319 order is not challenged. It's
Two
become
such
final.
orders, two such orders were not challenged.
The prosecution should have challenged, not I.
No, 319 orders.
You had
So
to
319 order, you are accused 1 to
orders.
5.
challenge.
Sir, you are accused 1 to 5. You are brought back. You should have challenged it.
I was not. At that stage, I was not. There were no accused at all.
Huh?
Talking
They
about
came to
discharge
be
of the
accused
accused.
under 319. So
That is what I'm telling. You should have challenged that order. Yes.
My endeavor is only to do justice to 319 case, my lord. That's all. As an officer of the court.
That will see first locus.
So great.
Ah.
I'll answer locus, my lord, and I'll answer also, my lord, the amicus curiae, my lord, sustainable remark that I may be doing a pick and choose business. In fact, I am That is not. what the trial court observed in page 50.
Trial court, my lord, keeps observing things, my lord, and I'll
Serious.
clarify.
Just for the sake of observation?
I'll clarify. my lord.
All right.
Any observation of the trial court, my lord, is not an obiter, neither it is a dicta. Therefore, my lord, I will not hang by that. If my lords had observed something, my lord, yes, I am bound by that.
Yes.
I'm
The Supreme Court ಹೇಳ್ಬೋದು. High Court keeps observing.
ಇಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಕೋರ್ಟ್ ಹೇಳಕ್ಕಾಗಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಸ್ my lord, the honorable courts have said anything observed by the trial court, don't go by the observation, only by the judgment.
Yes. Sir.
So great. Tomorrow, my lord, only if your my lord's boards permit, my lord, otherwise day after tomorrow or Monday, my lord, because this matter may take some time. This matter may take
Will
some
take
time.
time.
Monday, my lord, because I will go through the evidence because that's for some of the observation made by the trial.
Monday, I don't know, 200, 300 will
Maybe
be there.
Tuesday,
I don't know.
Tuesday.
We'll post it on Monday. Let's see. ಈಗ defer ಮಾಡಿದೀವಲ್ಲ?
Yes.
Defer ಆಗಿದೆ. In fact, my lord, if it, I think the next date, 9/8.
Yes, marked time there, we are 9th of.
9/8.
this.
9/8.
So then we'll have this on 6/8.
It
So
could be
great.
had on
6/8.
other day.
6/8, sir.
6.
List on 6/8. at 3:30 PM for the hearing. Yes,
35.
what maintainability?
But the order impugned has already been affirmed by your lordship, not in a petition filed
ಇನ್ನೊಂದ ಮತ್ತೆ
by the co-accused. I just cannot pass on the order.
ಕೊಡಿ.
I just.
ಕೊಡಿ.
Page 13, same order. Dated 7/10/21,
Co-accused ಆಯ್ತು.
and the
Sir.
trial has concluded, it's listed for judgment on 8th.
ಮತ್ತೆ ಈಗೇನ್ ಬಂತು?
ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ ಇದರಲ್ಲಿ.
Close ಮಾಡೋಣ? Yes. The petitioner is before this court calling in question the so and so. one ನಿಮಿಷ. Calling in question the proceedings in special CC 54 of 2014 with particular challenge to an order dated 7/10/2021 by which ಏನ್ ಮಾಡಿದ್ರೆ 7/10 ಗೆ?
But application filed.
Oh, by which the application filed by the second respondent, who is given pardon,
Accused number 4.
is tendered pardon ಅಂತ ಮಾಡಿ ಅದನ್ನ seek the following prayer. The learned counsel P. Prasanna Kumar representing the CBI submits that qua other accused, this court in terms of its order dated 16th June 2023 has dismissed the challenge to the very order that was the very order that is subject matter of challenge before in the subject petition. This court has held as follows. Reasons in the level. I have given my in the whenever. In the light of the very order being challenged and the challenge being rejected, the petition would also meet the same fate of it being rejected. It is accordingly rejected. Next.
6 adjourned. Even I. 7.
Petition in this case, not done. 38 proceedings not done.
37.
Not done. 45 lakhs not check amount not.
106 days delay.
Please not.
Suspension sentence. Notice ಆಗಿಲ್ವಾ ಇನ್ನು? I'll continue 2:30. 2:30 continue. Yes. In any case, want any adjournment? Everybody, because second list is I may not be able to complete.
Next matter 38.
I want time, sir.
No.
You will
we
take
don't
it.
want time.
2:30. Yes, admission matters. Anybody wanting adjournment?
39, your lordship.
See,
A week's time
everybody,
will be
page wise.
Page 6, 37 to 40. 39, your lordship.
39,
Yes, your lordship. Appearing for petitioner, 1 week of time.
2018. Finally, I'll grant 1 week time. That day, no
Instead of,
adjournment.
Santosh Gogi, Sharad Gogi's name may be shown, your.
Registry to delete the name of Santosh S. Gogi and print the name of Sharat S. Gogi as appearing for the petitioner. List the matter on next 8th. List the matter on 8th. Made clear no further adjournment would be granted in the matter.
38, I have made an application for amendment. My learned friend has no objection, permit me to amend and your lordship may call it on any other date.
No objection? 38 al barkonbi. Heard senior
Interim order to
counsel.
continue.
Heard so and so on.
my lord.
Huh?
Appearing for odd to.
Balakrishnan. Balakrishnan.
Balkers.
You have objection for adjournment.
Press time, my lord.
Race time, grants time, yes. Wait, sir, one babrag man.
There is one more matter, my lord. Along with this, it may be tagged.
ಯಾವ್ದದು? ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ?
There is.
One more matter ಯಾವ್ದು?
3 matters. 2 filed by.
All right, so and so, heard the learned senior counsel. The learned senior counsel would submit an IA 1 of 2024 is filed seeking amendment of the petition. The learned SPP 1 has no objection to allow the application. In that light, for the reason so and so, application allowed, the petitioner, the advocate, the petitioner shall amend file an amended petition by the next date of hearing. We'll take it on 22nd then. List on 22nd.
Interim order to continue.
Interim order subsisting shall continue till the next date of hearing. In all three cases ಇದೆಯಾ?
ಇಲ್ಲ.
ಮೂರರಲ್ಲೂ ಇದೆಯಾ?
ಬೇರೆ ಬೇರೆ accused ಇದ್ದಾರೆ.
ಅಲ್ಲಲ್ಲ, ಮೂರರಲ್ಲೂ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್.
Same, same,
Yes.
same. ಇದೆ ಎಲ್ಲದರಲ್ಲೂ. ಇದೆ. ಅದರಲ್ಲೂ ಇದೆ.
ಬೇಲ್ ಯಾವುದು? ಇಂಟ್ರಿಮ್ ಬೇಲ್ ಅದಲ್ಲ.
ಇದೆಯಲ್ಲ. ಅದ್ರೊಳಗಿಲ್ಲ.
ಅದಲ್ಲ, ಎಲ್ಲ 22nd ಹಾಕಿ. But what order is there in 38?
Whenever interim order is there, you will have to.
Interim order subsisting in any of these cases shall continue till the next date of hearing. Yes.
Page 741 to
ಒಂದ್ ನಿಮಿಷ, 39 ಏನೋ ಹೇಳಿದ್ರು, ಅದಾಯ್ತಾ? 40 ಏನು ಇರ್ಷಾದ್? ಸೇಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಲಾಸ್ಟ್ ಸೇಮ್ ಆರ್ಡರ್. 39 ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದೆ ಅದೇ ಆರ್ಡರ್. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೋದು.
43.
42. 1 minute.
Serial number 43, my lord. Kindly have it and next 43.
41 ಯಾರು ಹೇಳಿದ್ರಲ್ಲ? ಎಸ್. ಟೈಮ್ ಬೇಕಾ? ಹಂಗಾರೆ ಇರಿ ಬೇಸ್.
43, my lord.
43, yes.
Next week, my lord.
Same order.
Interim order may be extended.
Same order, yes. Same order ಅಲ್ಲ.
Serial number 42.
ಏನ್ ಲತೀಫ್?
And for the respondent, I'll file my objection.
Same, other 2 weeks ಕೊಡಿ. 42, list on 22nd, objections if any by the next date. Interim order ಇದೆಯಾ?
ಇದೆ.
Interim order subsist.
Lordship 40, serial number 46.
Wait, VC, please wait. Yes.
Like they have
22nd ಹಾಕಿದ್ದೀನಲ್ಲ? Yes, sir. Interim order, next.
45.
40?
5.
5 ಏನು?
I pay for the petition, that's not accommodation.
22nd,
Please. Interim order.
22nd. ಏನು ಮೊಂಬತ್ತೇವ್ರು ಏನಿದೆ? ಆಯ್ತು, ಫೈನಲಿ 22nd. Interim order subsisting will continue to the next date. Yes.
My lord, serial number 22, my lord, list 2.
Wait, have to go back 22 and wait. List 2, wait, madam. Yes. 46.
46.
46, Jaisham. 16 matters. Oh, this is back to me. All right, 22nd.
Your lordship.
Interim order subsisting. I had granted that order. Deferment. It's still deferred. Yes,
Lordship,
list on 22nd,
serial number
interim order of
46.
any kind. Sir, wait, sir.
Sorry, your lordship. It's in
You have
serial
the
number
luxury of sitting
46.
in the office and making a mention. Please wait till the people who are waiting here.
Yes, sir.
Yes.
Serial number 49.
40?
9.
46, yeah, 22nd ಹಾಕಿದ್ವಿ. 47, 48. ಏನಿಲ್ವಾ?
57.
47.
57.
ಒಂದ್ ನಿಮಿಷ. ಕರೀರಿ ಮೇಡಮ್.
Page 10, 48 to 53. Serial number 49, my lord. I'm for the petitioner. A short accommodation.
22nd, same order. Yes.
Interim order.
That will extend. Yes. Next. ಯಾವುದು? Tomorrow ಯಾಕೆ? Next week.
Next page.
Interim order ಇಲ್ವಾ? 22nd, next. ಹಂಗಾರಿ, yes.
Page 12.
57.
57.
Senior appears not for the petitioner.
57, sir ಇದೆ.
Definitely.
195 capital A.
Oh,
Stay ಇದೆ.
yes, stay ಇದೆಯಲ್ಲ?
22nd, my lord.
ಆಯ್ತು, 22nd interim order. ಅಲ್ಲಿ ಹರ್ಡ್ ಅಂತ ಮಾಡಿ interim order. Next. No, ಹಂಗಾರೆ 53 ಪೂರ್ತಿ 22nd. 53 ಪೂರ್ತಿ 22nd. Interim order subsisting will continue to the next date of hearing. Yes.
Page 30.
Next.
64. Page 30, 65 to 73.
In 73, there is already an order not by this honorable court to list these petitions after disposal of a connected my lord similar SLP. ಅದಾದ್ಮೇಲೆ ಬರ್ಬೇಕು, ಈಗಲೇ
ಇಲ್ಲ, ಇದು I have got them listed, ಯಾವ್ದಿದೆ ಅಂತ ಅಷ್ಟೇ. We'll post it on 22nd. 73 list on 22nd.
Interim
That
order.
page, nobody else?
Interim order is there.
Interim order subsisting will continue.
Page 14, 74 to 81.
Serial number 75, my lords, appear for the petitioner. Date has to file their objections, my lords, in this petition. There is no interim.
ಇದೇನ್
order.
ಕ್ವಶನ್ ಕೇಳಿರೋದಾ?
Crashing, so in respect of other crime, my lords, we
Yes.
call it on 8th, my lords.
In
There's no interim
respect of other crimes,
Different. There's 2 FIRs, my lords.
all right, yes.
22nd.
22nd, yes.
There is no interim order, my lords, in this.
ಪರವಾಗಿಲ್ಲ. 22nd.
Great.
60 and 65. 60 and 65. Registered complainant ga? Petitioner. 60 and 65. Registered to delete the name of so and print the name of Venkatesh Dalwai as appearing for the petitioner as he undertakes to enter appearance for the petitioners. Yes, next. Intermodal will continue. Next. 22nd.
Page 15, 82 to 86.
Not 84,
Ah,
not as against connected matter, not which has been allowed by this honorable court.
ah.
Not SLP not is being filed, not this, there is an
SLP
interim
is
order
filed?
being filed.
Being filed.
ಹೋಗಿದೆ ಅಲ್ಲಿದೆ.
ಇದನ್ನು ತಗೊಂಡೋಗ್ಬಿಡಿ ಅಲ್ಲಿ.
ಅದಕ್ಕೆ ಒಂದು 2 ವಾರ ಇರ್ಲಿ.
22nd. Yes.
My lord,
What is this matter?
This
I
Mooda,
represent the petitioner in this case, my lord.
Oh, that might, oh, yes.
Yes,
On
my lord.
site ke CBI has come in. All right, yes, sir.
not one side, that was ಅವ್ರದ್ದು ಒಂದಿತ್ತು, ಉಳಿದವರೆಲ್ಲ ಅದೇ ತರ ಆಗಿದೆ.
ಸರಿ ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ.
My lord,
22nd, yes.
Page 60, 87 to 94. Page 70, 95 to 101.
yes, sir.
98.
90?
98 and 98 point.
Sir, all further hearing and final hearing will come on 22nd.
This is criminal appeal, in fact, against acquittal.
All right.
Later on.
ಹಾಗಾದ್ರೆ ಒಂದು ಕೆಲಸ ಮಾಡುವ. Further here, wherever criminal appeals are there, let them come on 29th. Yes. Only criminal appeals on 29th. All remaining matters, whichever are not adjourned. You have the dictating orders, madam? My dictating orders. ಕೀರ್ತನ ನಾಗರಾಜ ಅದು 22nd ಹಾಕಿ ಅಲ್ಲ, ಇದು ಪೆಂಡಿಂಗ್ ಇತ್ತು ಮ್ಯಾಮ್ ರಿಟೇಟಿಂಗ್ ಆರ್ಡರ್ಸ್. ಆಲ್ ರೈಟ್, ಸರಿ. ಎಸ್, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎನಿಬಡಿ ವಾಂಟಿಂಗ್ ಟೈಮ್?
Second list in serial number 55.
20 minutes.
ಪೇಜ್ ವೈಸ್ ವೇಟ್.
This 2 page, 1, 4, page 2, 5 to 13.
6, my lord.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೇಳಬೇಡಿ,
Serial number
ಅದರ್ ದೆನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
second list.
Second list, other than fresh matters, whatever you want, take time.
Serial number 20.
That is fresh matter, then wait.
Just one mention, Manoj.
Then I'll have to give everybody, ಆಯ್ತು ಕೊಡಿ. Yes.
Serial number 35, my lord.
ಅಲ್ಲ, page wise, first ಇಂದಾನೆ ಕರೀರಿ.
Page 6, serial number 35.
1 minute.
Page 1, 1 to 4, page 2, 5 to 13. Page 3, 14 to 20. Page 4, 21 to 26.
Manoj, serial number 20, Manoj.
20. Yes, madam, what is
They
that?
appear for the petitioner, Manoj. The respondents have filed their impleading application.
Ah.
I may be permitted to file my objections to that, Manoj.
Last time also. Huh?
Objection for anything, my lord.
All right,
The interim order may be extended.
all right. At the request of the learned counsel appearing for the petitioner, list the matter 2 weeks bit on date, kodi objections?
13th, Manoj.
13th of August, my lords.
Not 13th, madam. Not 13th, 20th.
20th.
Yes, list on 20th.
Serial number 20.
Order subsisting will continue till the next date of hearing.
Great. Serial number 22, my lords.
20.
22, my lords.
Ah,
Kindly have this matter on 9th, my lords.
My
We
lord,
have to
I'm
file
appearing for the
objections,
petitioner
ma'am.
in this man, this matter, will be taken up on 7th or 6th, my lord.
9th of
9th.
August, my lords. 9th of August.
ಆಯ್ತು, 9th ಹಾಕಿ. Rest on 9th.
25.
9th ಆಗಲ್ವಾ?
Council, my lord.
8th.
7th, my lord. 8th is going.
ಎರಡು ಬೇಡ, we'll take it on 20th.
My lords,
Yes,
20th.
list on 20th.
My
My lords, it's a request. 20th,
No more requests. Yes, next.
25, my lord. Serial number 26, my lord. 25. I am for petitioner.
26.
Please, my lord.
Yes, sir.
Yesterday we have received the objection.
26 at the request of the counsel for the petitioner. List this matter on 21st. Rejoinder if any, rejoinder, criminal petition, yes.
25, my lord.
Rejoinder ಅಲ್ಲ, ಏನ್ ಬರಿಬೇಡಿ. Yes.
25, my lord.
25.
PF ಕೊಡ್ಬೇಕಾಗುತ್ತೆ, I'll pay it in during post.
ಅದಕ್ಕಾದ್ರೂ ಇರಿ ಸರ್, ಮಧ್ಯಾಹ್ನ ಆರ್ಡರ್ ಮಾಡಿ. PF ಕೂಡ 2 weeks time granted to do the needful. Yes, next.
Please.
All right.
Page 5, 27 to 33, page 6, 34 to 41.
35, my lord. Memo for
30?
withdrawal is filed.
35.
35.
34. Withdrawal, yes. Next.
34 minutes. I am for the petitioner.
Next admission.
Page 7, 42 to 48. Page 8, 49 to 57.
But 57, 55,
50?
55, my lord.
52 ಏನು?
Is one of PSA recruitment scam case where not done.
52,
I am for the rest.
20th. You are what woman?
I'm the respondent number 2. I got a notice.
Shweta Rao. You want to engage someone?
Yes, sir.
How much time you want? 2 weeks?
Yeah, okay.
ಆಯ್ತು ಯಾವತ್ತು 20ನೇ ತಾರೀಕು ಹಾಕ್ಲಾ? ಆಯ್ತು. List on 20th, the respondent appears in person, seeks 2 weeks time to engage the service of a counsel. List on 20th. Yes.
For this 55, the quashing is sought not in a police sub-inspector recruitment scam.
ಯಾವ್ದು sir?
55, no?
ಹಾ.
Not, my objections are ready, but I'll serve a copy on the other side. I've informed the petitioner
ಹೇಳಿದ್ದೀರಾ?
counsel also.
List on 21st
Please.
at the request of the counsel appearing for the respondent. Yes. B group and bada. B group and further hearing will not take, we'll do it another day. Yes.
Serial number 48 and 52 also connected matter to 46, my lord. First list.
Where is? ಊಟ ಮಾಡಿ.
Connected.
Serial number 50, my lords.
ಯಾವ್ದು?
Serial number 50.
Court officer? Court officer? Mute ಮಾಡ್ಕೊಂಡ್ ಕೂತಾನೆ. 46 ಒಂದು ಉಂಡಿ ಹಾಕಿದ ಬೈದ. Court officer? ಎಲ್ಲಿ ನಮ್ದು No, he is not.
Court officer?
She's checking, right? Sanjeev.
ಸೆಟಲ್ಮೆಂಟಾ ಇದಾರ ಇಲ್ಲಿ? ಅದು ರೀಚ್ ಆದಾಗ ಹೇಳಿ. Why 2:30 you're making mention of pending cases unless you want time? Yes, sir. 4 o'clock. Foxo? ಏನು? ಎಲ್ಲ ಯಾವತ್ತು ಹಾಕಿದ್ವಿ ಮೇಡಮ್? ಎಲ್ಲ 9th. ಆಲ್ ಪೋಕ್ಸೋ ಕೇಸಸ್ 9th. ಕಸ್ಟಡಿಲಿ ಇದ್ದಾರಾ? ಇನ್ನೊಂದ್ಸರಿ ಬರಕ್ಕೆ ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ. ಹ? ಏನು? ಯಾರು ಬರಕ್ಕೆ ಹೇಳಿದ್ ನಿಮ್ಗೆ? ನೋ ನೋ ನೋ. I had not, I will direct when the parties are directed to be, I will tell you when I will tell you when the parties are necessary to be present. No, no, no. All 9th will do it. 9th ad ready agi, whoever wants to come will see, yes. No problem, sir. Parvala. Spokesman case settlement, sir. Yes. We'll do it, 9th.
This one, number 37.
List 1. Huh? Delay ಮೇಲೆ ನೋಟಿಸ್ ಬೇಡವಾ ಇದಕ್ಕೆ? ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ? ಆಯ್ತು. Emergent notice to the respondent, keeping open the continuation of delay, keeping open consideration of IA 1 of 2024, the sentence so and so shall stand suspended. ಅದೇ ಒಂದು ಕಂಡೀಷನ್ ಇದೆ ಮೇಡಮ್, ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ವಿ, ನೋಡ್ಕೊಳ್ಳಿ. Yes, 38.
41.
ಕೊಡಿ. Yes, Jagdish. Harvard bench. You want to see it? See it. Stay ಇದೆ ಇದರಲ್ಲಿ. List on 8th. Dismiss for non-prosecution ಬೇರೆ ಆಗಿತ್ತು. Yes, so list on 8th in the fresh matters list. I'll close it. Yes.
42, 43, and then 44.
ಇದರಲ್ಲಿ ಇರ್ಬೇಕು ಬಿಡಿ, ಎಂಟ್ರಿ ಮಾಡಿದೆ.
44.
22nd, entry mode subsisting shall continue to the next date of hearing. 46 adjourned.
45, 46 adjourned. 47.
Vacating stay. Compounding. ಏನು offense? ಎಲ್ಲಿ ಅವರು? List on 8th, interim order subsisting shall continue till the next date of hearing. Yes.
48.
ಆಯ್ತು, we'll take it on ಯಾವತ್ತು ಹಾಕಿದ್ದಾರೆ? 22nd. Yes. Interim order subsisting shall continue till the next date of hearing. 20? ಬರ್ಲಿ. Yes.
49 adjourned. 50.
Next week. Then ಚಿಕ್ಕದು ಅಂದ್ರಲ್ಲ. List on 22nd.
51.
Sanction. Huh? ಏನಿದು? ಒಂದು ನಿಮಿಷ. Retired, lapsing. That is what I have quoted lapsing. You ready? Learned counsel, Shri B.B. Patil seeks 2 weeks time to file statement of objections. Objections, if any, by the next date, list on 29th. Interim order subsisting shall continue to the next date of hearing.
52.
29. 22nd, yes. Interim order subsisting shall continue to the next date of hearing.
53 adjourned. 54.
No representation. List on 29. Interim order subsisting shall continue to the next date of hearing. Yeah? 47. ಇಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿದ್ರು ಇವರಲ್ಲ ರೆಡಿ ಇದೀರಾ ಪಾರ್ಟೀಸ್ ಆರ್ ದೇರ್ ಮತ್ತೆ ಮಾಡಿದಾರ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಂಟಕ್ಕೆ ಇರಲಿ.
ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅವರೇ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಎಸ್ ನೀವು ಇಲ್ದೇನೂ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ದೀನಿ ನಾನು ಎಸ್ ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ 8th ಎಸ್ continued. Where were you? Yes. Matter also has gone rushing. Interim order is extended, sir. We'll take it on. The other matters I have posted it on 22nd. Idu jote is my interim order. I have extended it. Yes.
55.
Same 29th. Interim order stands extended to the next date.
56.
It's covered. What do you? Yes, Jagdish.
Notice was not given.
Disaster management. Without notice, you can't do under 51B.
30 days not given.
Huh?
30 days notice was not given.
Oh, not given. That's what I've held in this. Toast covered. Both the learned counsel for the petitioner submits that the issue in the list stands answered by the judgment rendered in criminal petition 7702 of 2023. Counsel, Sri Additional SPP, Sri Jagdish would not dispute the position. As no notice under section, no notice as required under section 51B or 16 under. Notice under 60, section 60 of the Act has not been issued to the petitioner. Therefore, the issue stands answered by what this court has held in criminal petition 7702 of 2023. ಅದು ಮೇಲೆ ಕೋಟ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್ held sounds. Yes, next.
57 adjourned. 58.
Batch of matter, sir. ಯಾವ batch? 59, sir. Yes. No representation. List on 29th interim order. ಈಗ ಬನ್ನಿ 59.
Yes, I appear for the petitioners.
Batch of matters ಇರೋದು ಇದರಲ್ಲಿ. ಅದು ಅಲ್ವಾ ನಿಮ್ದು? You had lunch? Yes. Yes.
59.
Lord, I appear for the petitioners.
All are served. Interim orders ಇದೆಯಲ್ಲ?
Interim orders ಇದೆ. All are 171H, my lords. Judgments also I have produced along with the petition.
We'll see. We'll take it. We'll take it on
Yes.
22nd.
Please,
List on 22nd interim order subsisting shall continue till the next date of hearing.
in all matters, my lord.
Huh?
In all matters, my lord, there is a.
Yes,
interim
sir, in
order.
all matters.
Yes, grateful.
60 adjourned. 61.
Mic on, ಮಾಡಿ.
Lordship, in this case, we have engaged the services of senior counsel, Mr. Satish Dadmani.
If that is a submission, we'll dismiss it right away.
Short accommodation, Your Lordship.
That's better. Yes. List on 22nd.
Interim orders, Your Lordship. Grateful.
petitioner in this case, my lord.
You're appearing for him or you filed wakalat?
Toxic.
Ah. Intermodal ilva?
There is an intermodal
Idea.
subsystem.
Is my
Once-
intermodal.
171 E
I
and
think it was
B.
not extended on 19/1/2020.
1 minute, sir. RP Act 155 non-compliance.
ಅಲ್ಲ ಅದು ಮಾಡಿದೆ.
Yes.
155 compliance ಇದೆ.
ಇದೆಯಾ? ಅದಕ್ಕೆ ನೀವು ಫೈಲ್ ಮಾಡಿ ಅದನ್ನ. Both the matters, madam?
No, my lord, both are distinct in nature.
No. You're appearing in both the matters, I
Matter
said. Yes.
62.63.
Heard the learned counsel, Srimati Kirtana Nagraj appearing for the petitioner. List on 22nd, interim orders subsisting shall continue till the next date of hearing. The additional SPP to secure instructions with regard to compliance with section.
They
One-
produce order sheet itself.
Order sheet ಆಗಿದೆಯಾ?
ಹಾಕಿದ್ದಾರೆ.
ಮತ್ತೆ ಸ್ಟೇ ಯಾಕೆ ಕೊಟ್ಟಿರೋದು?
On the.
Permitted
ground-
ಅಂತ ಇದೆ.
ಇಲ್ಲ page 26 ಮೇಲೆ.
But
Type copy
that's not
page
a
27.
distinct order. Still no application of mind in this order.
ಎಲ್ಲಿದೆ?
Page 27 ಅಲ್ಲಿ. Type
Perused
copy.
requisition, perused acknowledgement, perused requisition, prima facie case made out, permission granted.
It's not a speaking order, my lord.
So it's, how much can you speak, madam?
My lord, in fact, even in the requisition, they do not say that the complaint is
no.
attached.
It is enough if the magistrate should speak so much.
Even then,
It's better than saying permitted.
indeed, even then to satisfy 171H, 171B has to be
On the
satisfied,
merit of the matter.
especially in the,
171B deals with bribery.
yes, my lord.
Bribery is not proved,
It is
not
not,
even prima facie.
not even prima facie.
That is why interim order is granted.
Yes, that
That's
is
why
the-
we'll extend it also. Sir, permitted and the 2 extra ಜಾಸ್ತಿ ಬರೆದ್ರೆ ಆಗಲ್ಲ. ವಿಜೇಶ್ ಪಿಳ್ಳೆಯಲ್ಲಿ ಏನ್ ಬರ್ದಿದೆ ನೋಡಿ.
Yes.
Separate order sheet should be maintained. Reason should be recorded.
ಇದರಲ್ಲಿ order sheet maintain ಮಾಡಿದ್ದಾರೆ. but
ಅದೇ
not-
ಆರ್ಡರ್ ಇಲ್ಲ ಅದು. ಶೀಟ್ ಇದೆ ಅಷ್ಟೇ.
That's an extension of the complaint itself, my lord. When we applied for the order sheet as a certified copy also, this was not available.
ಅವರೇ ಹಾಕಿದ್ದಾರೆ.
ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಸ್ ಇನ್ಸರ್ಟ್ ಮಾಡ್ತಿದ್ದಾರೆ.
ಅಲ್ಲ ಅವರೇ ಹಾಕಿದ್ದಾರೆ ಅದನ್ನ ಅದು ಹೆಂಗೆ?
ನೀವೇ ಹಾಕಿ.
It was along with the complaint it came,
All
not
right.
as a part of the order.
All right. 22nd, yes.
Please, ma'am. 54.
ಅರ್ಜನ್ ಆಯ್ತಲ್ಲ ಮೇಡಮ್ ಇದು 64 ಬೆಳಗ್ಗೆ ಇಲ್ವಾ? 29 ಎಂಟರ್ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ 66
Complaint filed by the Pollution Control Board.
I see.
You're appearing for whom, madam?
Pollution Control Board, your lordship.
Okay.
The interim order granted. The entire genesis of the case is that perhaps they had issued a order under the Water Act for closure of the industry. Perhaps subsequently, the Honorable Division Bench perhaps allowed the petition, directed it to be treated as a show cause notice. The very foundation of the case of PCR perhaps is taken out.
This is an interim order in this matter. We,
Hmm.
1 week time may be
Actually,
given.
next week this should go. Today, all these matters I've listed only if you want time to grant and whichever to be closed, closed. But 8th will close it.
Great.
No, if the very order, if the very reason for registering the private complaint goes, what else?
There's certain submission senior wanted to make in this matter.
All right, no problem. List on 8th. ಇದು ಮಾತ್ರ 8th. Interim order subsisting shall continue to the next date of hearing.
Case number 16. Member of Parliament, 7th time. Who has went to my lord Hindu Karyakarta's function with respect to the my lord
Disfigurement Act.
yes. And criminal,
Notification ಆಗಿತ್ತ?
criminal trespass my lord for the
Stay
again.
ಇದೆ.
ಏ ಇದೆಯಾ?
Yes, my lord. Criminal trespass against the MP my lord when the sitting.
ನೀವು ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು. ಸ್ಟೇ ಇರೋ ಕೇಸಲ್ಲೂ ಅದೇ ಆರ್ಗ್ಯುಮೆಂಟ್, ಇಲ್ದೇ ಇರೋ ಕೇಸಲ್ಲೂ ಅದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
Please.
ಸ್ಟೇ ಇದೆ ಅಲ್ವಾ?
Stay there.
ಹಾ, ಸರಿ.
But my lord, continuation of my lord proceedings is not, in this case is concerned, my lord.
22 ಕ್ಲೋಸ್
As a MP, my lord, criminal trespass for the his conscience.
22nd will close it.
35 years of MP sitting.
ನಾನು
MP.
22nd ಹೇಳಿ.
Please.
35. Yes. 22nd will close it.
This is rake up in the parliament. That is the problem. Every time opposition is wrecking up this.
ಈಗ ಸೆಷನ್ ಆಗೋಯ್ತಲ್ಲ, ನೆಕ್ಸ್ಟ್
ಅಲ್ಲ,
ಬರೋ ಅಷ್ಟೊತ್ತು
of
ಕ್ಲೋಸ್
course.
ಮಾಡೋಣ ಬಿಡಿ.
ಅಲ್ಲ, ಈಗ ಮೆಂಬರ್ ಅಲ್ಲ.
ಇಲ್ಲ, but again,
ಇವಾಗ ಅಲ್ಲ.
I am my lord on 7 times.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದೆ ನೀವು ಎಲ್ಲದಕ್ಕೂ ಒಂದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೋದು. ಈಗ ಸ್ಟೇ ಇದೆಯಲ್ಲ.
Stay ಇದೆ. But my lord, even though I am not MP, after 35 years of my lord, continuation of MP post, my lord, again, my lord, recapping in the my lord
Don't worry.
assembly. That is the
Entry ಮಾಡಿ
biggest-
ಇಲ್ಲ ಅಂದಿದ್ರೆ I would have granted. You have protection, wait.
Please,
20 seconds.
please. Entry model.
Extended, madam. Extended.
Private complaint is filed. Proceedings are complete.
Entry model ಇದೆ. 29th.
Correct.
Just on 29th. Entry model subsisting shall continue to the next date of hearing.
This matter. What's the
Complainant is served.
Served. Served. But the
123A.
statement made is, my lords, I have extracted it to page 6.
ಇದೆ ಇದ್ರ.
Page, ಅಲ್ಲ ಇದೆ ಸ್ವಲ್ಪ ಎಲ್ಲ ಮುಂದಕ್ಕೆ ಹಾಕೋದು. Lords, kindly, paragraph 6, the statement what I have made. For this, my lords, they invoke
ಇಲ್ಲ ಇದು ಅಲ್ಲೆಲ್ಲೋ ಇನ್ವೋಕ್ ಆಗಿತ್ತಲ್ಲ.
Coimbatore ಅಲ್ಲಿ one complaint was filed.
ಹಾ.
Now that is being heard by the
Madras High
Madras
Court.
High Court for IPC offences.
Hmm.
This, my lords, it's
123A,
123A, 125.
that may not come.
Reference to only, my lords, election or election candidate. So, my lords, you wanna
Day
accept?
ಇದೆಯಲ್ಲ, we'll close it next week. Yes. 22nd, entry model subsisting shall continue to the next date of hearing.
70.
Petitioner's call.
Submission. Track sequence.
Entry model ಇದೆಯಾ?
Entry model is there. 499,500, my lord. As a counter blast, my lord, complaint has been filed.
Right.
Vague allegations, my lord.
204 violation. Violation of 204. Process.
Yes.
ಮಲ್ಲಿಕಾರ್ಜುನ್ ಕೇಸ್ ಫಾಲೋ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿರೋದಲ್ಲ.
ಇಲ್ಲ, my lord.
ಇಲ್ವಾ?
Affidavit ಏನ್ ಹಾಕಿಲ್ಲ.
No,
Verifying.
ಅಫಿಡವಿಟ್ ಇಲ್ಲ.
ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ
ಪ್ರಿಯಾಂಕಾ
ಮಾಡಿದ್ರು. ಪ್ರಿಯಾಂಕಾ ಶ್ರೀವಾಸ್ತವ ಕೇಸ್. Affidavit also filed.
ಕೊಟ್ಟಿರೋದು ಅದಕ್ಕಲ್ಲ ಸರ್. You are the complainant.
ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಟ್ರ್ಯಾಕ್ ಸೀಕ್ವೆನ್ಸ್ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಇಂಟಿಮೇಷನ್ ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ತಗೊಳ್ಳಿ ಅಫಿಡವಿಟ್
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಅದಕ್ಕೆಲ್ಲ ಇರೋದು.
No, on merit, my lord, on entry matter was granted after hearing.
ಡೆಫಿನಿಷನ್ ಆಫ್ ಡೆಫಮೇಶನ್ ಬರಲ್ಲ.
ಬರಲ್ಲ.
ಆಯ್ತು, ಟೈಮ್ ತಗೊಳ್ಳಿ, ತೊಂದರೆ ಇಲ್ಲ. Heard the learned senior counsel Arun Sham appearing for the petitioner. Lest the counsel for the complainant seeks 2 weeks time?
2 weeks.
2 weeks time to file statement of objections. List the matter on 22nd. Next time time illa.
Please.
Yes. 22nd interim order subsisting shall continue till the next date of hearing.
71.
Petitioner, Your Lordship. The proceedings against accused number 1 is already quashed and I have even produced the judgment of the, I'm for the accused number 3 in this matter.
Yes. Page?
Page, I've already produced, I mean, in the last date separately.
Yes, Jagdish, note ಹೇಳಿ. Next week, 8th.
This one. Interim order may be extended.
It will be extended. List on 8th. Interim order subsisting shall continue to the next date of hearing.
72.
For the petitioner in this matter, my lord. Offense punishable under section 188 IPC, my lord. The PCR has been filed. That was referred under section 156 of class 3 of the CRPC. And thereafter, the respondent police have filed the
Yes,
charge
government.
sheet.
Charge sheet ಆಗಿದೆಯಾ?
Yes, charge sheet has been filed, which is contrary to procedures contemplated under section 195 of the CRPC.
Charge sheet are filed.
Charge sheet ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಹೌದು.
Like
195 bar.
ಅಲ್ಲ, subsequently it looks like go through my lords, there is a
Go
stay.
through, ಆಯ್ತು. List on 8th.
Complaint seems to have
And
filed.
auto filed before the special court, my lord.
That we'll see. Let him answer.
Yes.
List on 8th. Next 8. Yes.
73 adjourned. 74.
171G has been charged along with 123 of RP Act.
22nd ಜಾಸ್ತಿ ಆಗಿದೆ 29th entry order. Yes, next.
75 then 76.
Petitioner, my lord. Hearing for petition. So kindly.
Samuel served. Yes, ಇದು 22nd.
Interim order.
IPC offenses ಇದೆ.
ಹೌದು.
Yes.
Interim order
22nd.
may be extended.
Entry order ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
57.
Thanks.
Twenty-ninth. Yes, next.
28.
Same.
79.
I'm for petitioner, lords. 79 plus. Plus 188 of IPC, lords. Private company is filed, lords.
ಇದು 188.
Please, lords. Formalization order, lords, in question, lords.
PCR ಹಾಕಿದೆ.
PCR ಹಾಕಿರೋದಾ?
ಹೌದು.
Lords, covered by judgment of this court, lords, page number 30, lords.
$195 bar is also taken note of here. And look into it. 8th. Yes.
Lords, interim order.
8, sir. Entry order ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Next. Yes.
80, my lords, accused number 2, my lords, the proceedings are already quashed by this honorable court. A copy of which is, my lords, at page number 58, my lords, 58.
This petition they have filed in Dharwad. Their copies have not given to.
Copy serve ಮಾಡಿ. Learned counsel Shivraj Bullali appearing for the petitioner submits that que accused number 1, this court has quashed the coordinate bench has quashed the proceedings in criminal petition 1560 of 2024. The petition, they list the matter on 125(3) RP. Yes.
I'll serve a copy.
Yes, next.
81.
81 also similar, my lords. Where,
Same. Serve a copy, sir.
Please, my lords.
Yes.
82.
Criminal revision petition. List 29th ಹಾಕಿ. Revision petitions ಎಲ್ಲ 29th ಹಾಕಿ.
83 also.
Same.
85. 84.
84 adjourn ಆಗಿದೆ madam.
If I had to make one submission with
ಏನು?
respect to 84.2.
What happened?
Your lordship have been pleased to quash proceedings as against accused number 5 in this matter, your lordship.
Accused number 1
Accused number 5. Petitioners are accused number 4 and 6. All 3 were sitting MLAs. The
No, that he said Supreme Court ಗೆ ಹಾಕಿದ್ದಾರೆ ಅಂತ.
in the Hakila.
ಗೊತ್ತಿಲ್ಲ. That's what Prasanna Kumar told me. He's taken time, 2 weeks. Yes. Entry order ಇದೆ ಅಲ್ವಾ? Entry order that is continued.
84 BB Patil name may be deleted.
Registry to delete the name of BB Patil as appearing for the respondent. ಯಾವ್ದ್ರಲ್ಲಿ 84.1 ಅಲ್ಲಿದೆ. Yes.
85.
Entry order ಇದೆ.
ಇಲ್ಲ.
ಇದೆ ಯಾಕಿಲ್ಲ? My entry order. Yes.
Different file.
85. List on 29th.
Different file.
Entry order granted earlier and section. ಏನಿದು? ಮತ್ತೆ ಇಲ್ಲೇ ಬಂತ? ಇನ್ನು ತೀರ್ಮಾನ ಆಗಿಲ್ವಾ ಇದು?
After a long time again it is coming back to lordship.
ಆ?
After a long time again it is coming back to lordship, It was not listed afterwards.
Yes.
The pertaining to SIT council SIT.
ಆಯ್ತು
For the.
ಒಂದಿನ ತಗೋಣ. We'll fix it at 5th September.
Please.
List this on 5th September.
Synopsis, everything is filed.
ಎಲ್ಲ ಆಗಿದೆಯಾ? 5th September.
Please.
I'm filing a memo for withdrawal, my lord. Signature of council on record.
Okay. So and so, Learned Council so and so sub files a memo seeking to withdraw the petition. Disposed as withdrawn in terms of the memo. Yes,
Great.
ma'am.
89.
For the petition. Yeah, seek for a pass over, my lords.
Pass over, we'll have it next week.
No, my lords, the urgency is this, my lords.
What urgency?
My lords, is before the trial court today, my lords. I'm being led by.
Before the trial court? ಏನ್ urgency ಇದೆ? 188 ಆ?
ಇಲ್ಲ ಸ್ವಾಮಿ, 353, 506, 503.
353. ಯಾಕೆ ಸರ್ ನಿಮ್ಗೇನ್ ತೊಂದರೆ ಕೊಟ್ರು?
Forest department of the ಜಗಳ.
ಫಾರೆಸ್ಟ್ನರ್ ಹಾಕಿರೋದು.
Forest department ಮೇಲೋಗ್ ಜಗಳ. India council Navagi is leading this matter.
8, list on 8.
My lords, my
8, sir. List on 8.
it's my request for a short pass over, my lords. He's on his legs. He's just.
All right, fine.
Other two
But even
matters-
then, it's on the 8. No problem.
Let's,
Ask him to come. No.
please.
In his presence, 8. Yes.
Group 90.
Yeah, I pay for the petitioner lordship.
B group, 29th.
I pay for petitioner lordship.
Entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. Yes, next.
No entry model.
No entry model. Yes, continued. Final disposal, final hearing, we have said ಅಲ್ಲ. Madam, ಬೆಳಗ್ಗೆನೇ ಹೇಳಿದ್ನಲ್ಲ. 29th, 22nd and 29th, further hearing, everything. Ah, 29th, yes. All further hearing matters on 29th. Further hearing in the first list, yes. And final hearing. They're all criminal appeals, yes.
Fresh matter still number 1.
For the petitioner in this matter, my lord. The offense under section 420 IPC, the dispute is arising out of the contractual relationship between the accused number 1 and the respondent number 2, my lord. The petitioner is the accused number 2, my lord.
Post the matter for admission on the 4th of September. Interim order subsisting shall continue till the next date of hearing.
On several occasions, matter was listed before his lordship. And the counsel for the respondent to remain.
Is there, sir? Yes. Next.
I'm for the petitioner. In the
Petitioner.
connected matter.
Connected
the
matter.
petitioner.
Yes, Muniraju yaru.
The counsel for the respondent 2, my lord.
Is not come.
He was absent in the previous occasions also.
On several occasions, he
Heard
was
the learned
absent.
counsel appearing for the petitioners ಅಂತ ಮಾಡಿ ಮಾಡ್ಬಿಟ್ಟು there is no representation on behalf of the second respondent even today. Lest this matter as a last chance on the 4th September. In the event the counsel would not be present, the petition would be answered considering the submissions of the counsel appearing for the petitioners.
Much obliged.
Great.
306, my lord. It has come on many occasions.
The respondent number 2, I'm under instruction to submit that a formal objection may be placed on record and the matter may be covered.
My lord, while
Settlement ಗೆ ಬಂದಿತ್ತದ ಇದು?
my lord, not for settlement, an
Then-
interim order has been passed by this court, detail order has been passed,
ಆಯ್ತು.
306.
Objection ಹಾಕ್ಲಿ.
Allah, there is no abatement.
The
Allah, they are-
instruction I have received is
Objection ಹಾಕಕ್ಕೆ ಏನಂತೆ?
Allah, they are not
ಎಲ್ಲ
filing-
ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಡ್ಬೇಕು ಅಂತ.
My lord, they are not filing objections.
They will
What they are
file.
saying-
instruction also, my lord, is
You are entering appearance?
no, my lord. Instruction from the council on record is that a formal oral objection may be placed on record and matter may be
The
disposed.
learned counsel Srimati Kirtana Nagaraj seeks a week's time to file statement of objections, comma, if any. In the event statement of objections are not filed by the next, in the next 1 week, the matter would be taken up and considered on its merit. List on 20th in the fresh matters list.
It has come on the last occasion, 5 times it has come, my lord.
So what?
Would be disposed of, would be disposed of.
We'll do it that day, yes.
What they can do and what the advocate.
20th.
The complainant's advocate is on the video.
I received instructions from them.
She's here saying, yes, 20th.
The same, case will not- They should make this.
He's on the video.
He was the instructing counsel even in the.
That's all right, even otherwise. 20th, interim order illa andidre, it's all right.
Allah, it could be taken up on 8th, my lord, at least.
No. List on 20th in the fresh matters list, yes.
Interim order may be extended.
At the extent, yes. Next.
For 3. Appealing to the respondent. my lords.
Maintenance.
Yes, my lords. My lords, the thing to be considered before this honorable court is the need of the child. That is first. 2, in terms of the ratio of their earnings. There is no dispute about both father and mother earning exorbitantly well. One in the US, the mother is in India. The consideration before this honorable court is earlier they had filed an application before the learned magistrate for 50,000 maintenance per month.
I've heard it.
Yes.
It's reduced to 25,000 by the sessions.
Sessions. My lords, the need of the child. The child is 5 years old. Okay. 2 weeks ago, the child turned 6 years old. The child is 5 years old, my lords. 25,000 rupees maintenance is.
She will save 25,000 in the name of the child. Don't worry.
My lords, I'm already saving that money while the child was.
Mother also will save.
My lords, while the child was in US itself, we started a saving scheme wherein every other month he
The
is.
mother will start another savings.
My lord, she'll only file further more cases. Already
No,
30
no.
cases are pending between the parties.
No problem.
And there are multiple. My lords, if this honorable court is wishing to increase the maintenance, may I make one proposal?
Increase Allah. 25 na 50 ittala munche.
Allah, Swami.
Will restore 50.
My lords, may I kindly make a submission? I will deposit directly to the school. I will pay all the school fees relating. The school also has food and bus and everything included, my lords. I'll pay the complete thing directly to the
Now
school.
who is paying?
My lords, initially I was paying, but I was sending it through her account. Even though there was no order of maintenance, I was paying the school fees. After the maintenance being ordered, every month I am depositing 25,000 to her account. I will directly pay to the school, whatever amount is. As of today, they are trying to say it is 3.5 lakhs. I am ready to pay directly. Maybe tomorrow, if it is next year, it becomes 4, whatever is the inflation rate, I'll pay directly to the school. Kindly, my lords. If that also, it will be the same ratio, my lords. Kindly.
Then
That is my submission, my lords. 50,000 is an exorbitant amount, which is more than what the child needs. She's living in an own house. She has rental income and other things. She doesn't have any dependent except for the child herein. Whereas the respondent herein has the first child from the first marriage.
that's last time I told you.
Yes, he also has a mother to take care.
Again, that also I told you. Don't sing these swan songs.
I am not
Yes.
washing away my hands from not paying the child. While the child was in the US itself, I've started a saving scheme. She took away the child from US to India, conspired to file cases, filed cases also. The moment US police was filing a report where there is no offense made out, while protection order, she had obtained a protection order from the US court as well. While that was subsisting, she doesn't inform the US court, nor the US police, nor the respondent herein, gets the child to India in June. July, she starts filing cases in India, including this maintenance case. And this is not the first time she's done this, my lords. In 2019 also, she moved the child from US to India and filed cases in Noida, again for maintenance and other claims in Noida. And this is the same pattern, my lord. She's been harassing the respondent herein by filing numerous cases. My humble submission is,
50,000, she will stop filing this case.
it will become more, my lords.
More,
Already
we'll
there's
see.
an existence of, I have produced, if your lordships can see, I've produced a document, a list of cases that is being filed against us. Or there'll be cases against the judges. They'll start filing transfer petitions, writ petitions. And my lords, my client is contesting numerous matters also. He's taking care of his mother. He's taking care of his first child. He's taking care of the petitioner's daughter herein, who's the daughter of both petitioner and respondent. We've been paying, including the saving scheme for the education, because the child is a US citizen. He's also paying the US, at US, the saving scheme, which he's been paying while the child was in the US itself. The scheme had started and he was paying since then. He has to save for the future also for the child. At one given point of time, suddenly they come and ask for crores of rupees for a college fee. He cannot get it. So there is a saving scheme that which he's doing in the name of the child, which he cannot withdraw.
What's your income per month?
My lords, mine is about 9 lakhs in the US currency, my lords.
9 lakh US dollars.
Yes, my lords. But when we convert it into purchase power parity with India, it will be just about 3 lakhs. And she's earning 3 lakhs in India itself, my lords.
Hmm.
My lords, admittedly, both are earning well. There is no dispute on that point, my lords. The
That's why
need-
both of you are fighting well.
My lords, I have not filed cases, my lords. In fact, if your lordships can see, I have sent an email to her categorically telling her to let's be done with all these cases. Let's focus on our child. I've produced that email also, my lords.
Hmm.
No, their vengeance, whatever it is that they just don't want to stop filing cases
Anyway,
or,
this maintenance case, I will deal with this.
my lords.
Yes, sir.
My lord, I will just take 2
You
minutes.
don't want to settle the issue?
My lord, I would like to submit to just
No,
2 minutes for submission,
Settlement.
my lord.
You don't want to settle the issue?
No, I want to settle, my lord. Kindly permit me for 2 minutes, actually. She is totally misleading this honorable court. They have filed SLP criminal 4945 before honorable Supreme Court. All these contests were taken by them. It was dismissed by honorable Supreme Court. They had filed writ of habeas corpus 78 by 2021 before this honorable court. And they had taken same contest as it was dismissed. I mean to say they had filed in 3-4 cases at High Court, Honorable Supreme Court. All those contests have been
If you
dismissed.
file, they will also file. Why should they keep quiet?
No, false, I was telling about false and irrelevant contents.
That's all right.
Now
Yes.
coming to this is interim maintenance, my lord. Fees is 50,000, page number 201, my lord. Fees itself is 50,000 per month.
It is not per month, my lords. That's
Wait.
all.
201.
201.
Yeah, my lord. First term fees, second term fees, third term fees, 3 lakhs, 1,02,000, 1,02,000, 1,02,000, 1,02,000, my lord. It may kindly be seen.
Now, who is paying the fee?
This petitioner is paying, I am paying. Yes, my lord.
All right.
Then
what are the arrears of maintenance? Nothing is there?
No, my lords, we up to date paid.
Food services, 52,000. Then bus charge 85,000. And then books, shoe, uniform, and summer camp fees, it makes 6 lakhs.
Summer camp.
And now coming to my lord, this about the income and savings, there is a judgment of this honorable court that savings cannot be allowed. My lord. I would like to refer to judgments because they have just manipulated their savings actually and reducing the income.
What is the income?
Income is, my lord, 9.25 lakhs per month.
Per month?
Yeah, and they have shown it somewhere, I mean to say 3 lakhs.
That is.
Page number 86, my lord, I will start.
9.25 lakhs. So 50,000 is awarded. What is, how much do you earn? 1,62,000.
No, my lords.
How much does she earn?
35 lakhs is her annual income, my lords. Almost about 2,50,000 is her net.
My lord, that is a gross salary actually. And after tax, it will be around 20 lakhs. And my lord, page number 86, paragraph 6.
Yes.
The judgment of.
Anything
this,
else, sir?
The judgment.
Anything else you have to say?
Just
Judgment I will read, you need not read.
This, I mean to say savings will not be allowed. Then they have taken the contention of purchase power parity. This purchase power parity is an idea and theoretical concept, and definitely it is not a law. So that cannot be.
You are guiding your daughter.
Guiding, I mean to say, I am father, so that's why I have.
No, that's what in guiding in filing these cases.
Yes, my lord.
Settlement and agala.
Agadilla, Swami.
No sentimental, my lord. I am
No,
talking of law. Actually,
settlement cannot happen. Yes.
No, I am talking of law, my able Supreme Court.
We will also answer law only, sir, not settlement. No, I asked whether you are guiding your daughter to file all these cases.
Yeah, definitely as a father, I
Yes.
having my duty to, every
Absolute.
fathers have
That is why.
their duty to this guide their.
No, there can be
children.
no settlement. We will answer in law.
And for settlement, we have two mediations have taken place, my lord.
That is why.
And that had,
You go to the mediation or your daughter goes?
my daughter goes.
You don't go.
I just accompany.
They send abusive mails to the mediation center also. When the matter was set down for a private session, my lords, he sends an email saying that because there was a matter pending before the.
All right.
Anyway, my lords.
Don't build a
Lords,
story.
I'm also submitting judgment where purchase power parity, the honorable
Right. Yes.
court has
Hmm.
taken consideration of.
Yes. Alle. Correct. Yes, sir. We'll dictate on another day. 23rd,
Much obliged.
list on 23rd. No arguments that day, only dictation.
My lord, we have to submit written argument.
Detailed argument.
Yes, my lord.
Oh, good, yes. Huh? ಏನಾಗೈತ್ರಿ? ಅದ್ dictating ಅವತ್ ಮಾಡಿದ. Yes. Yes.
Point number 2.
Huh?
Preparing for R2. ನೇ ವಕಾಲತ್ ಹಾಕಿದ ನೆನಪು.
ಹೌದ್ರಿ
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
ಎಂಟ್ರಿ ಮಾಡಿ.
ಏನಿದು?
ಎಂಟ್ರಿ ಮಾಡಿರಲಿಲ್ಲ.
498.
ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ ಅಂತ ಹೇಳಿದ್ರು ಲಾಸ್ಟ್.
Husband?
Husband, absolutely no material. At the time of marriage, he was a court staff.
To
He has
quash-
been court staff.
To quash no material.
To quash also no material.
ಬೇಡ ಬಿಡಿ.
Allah, quash there is material. Quash there is material. To attract 498, absolutely there is no material. Only 15 days she lived with the petitioner. After
15 days.
15 days.
Husband 15 days enough.
15 days.
Ah.
The thing is why she has not joined the husband. He was posted to Chikkodi, JMFC Chikkodi.
Chikkodi problem.
Chikkodi.
Ah.
Chikkodi. The second respondent is not ready to go and join.
Why Chikkodi is not a good, Chikkodi is not a good
Transfer,
place?
then I will join her. Then now he has been transferred to Bangalore. Now she is not ready to come and join. Your lordship could find.
You did not want to go to Chikkodi. You don't want to be in Bangalore. Any problem?
That is the problem.
They were residing together for 15 days. There was
15 days they were staying.
There was a dispute between the.
ನೀವು ಪ್ರಾಜೆಕ್ಟ್
brother-in-
ಮಾಡ್ತಿರೋದು ನೋಡಿದ್ರೆ 15 ವರ್ಷ ಜೊತೆಗಿದ್ದೀರಾ?
ಇಲ್ಲ ಆಗಲ್ಲ. ಅವರೇ ತಂದು ನನ್ನ ಹಾಸ್ಟೆಲ್ಗೆ ಇಟ್ಟಿದ್ದಾರೆ. PG-ಯಲ್ಲಿ ಇಡ್ಸಿದ್ದಾರೆ. ಐ ಆಮ್ ಅನ್ಎಂಪ್ಲಾಯ್ಡ್. PG-ಯಲ್ಲಿ ಇರು ಸರಿ ಆಗತ್ತೆ. ಇನ್ನೊಂದು 15 ದಿವಸ 20 ದಿವಸ ಅಂದ್ರೆ 6 ತಿಂಗಳು PG-ಯಲ್ಲಿ ಇಟ್ಟು PG ರೆಂಟ್ ಕೊಡದೆ ಅವ್ರು PG-ಯಿಂದ ಹೊರಗೆ ಹಾಕಿದ್ದಾರೆ ನಮ್ಮ.
PG-ಯಿಂದ ಹೊರಗೆ ಹಾಕಿದ್ರ?
ಆಮೇಲೆ they have harassed like anything.
ಆಯ್ತು, ಇದು PG-ಯಿಂದ ಹೊರಗೆ ಹಾಕೋದು ರೆಂಟ್ ಕೊಡದೆ 498 ಬರುತ್ತಾ?
ಅಲ್ಲ ಬರಲ್ಲ. ಅಲ್ಲ
ಬರಲ್ಲ.
ದೇ ಬಂದು ಅಲ್ಲ ಅದಾದ್ರ ಮೇಲೆ after 23 in the year 2023, my lord, they have done the complaint has been filed. Subsequent events also there is a material for. I will file my objection statement, my lord. 1 week time may be.
You don't live now with him?
There is
ಏನಾಗಿದೆ? ಏನಾಗಿಲ್ಲ. Nothing has happened except your egos. PG-ಯಿಂದ ಆಚೆ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಅಷ್ಟೇನೇ ಇಲ್ಲ.
1 week time may be granted.
You want to join?
No, I will consult my client.
ಕೂತ್ಕೊಂಡು ಸೆಟಲ್ ಮಾಡಿ. ಯಾವ 498 ಏನೂ ಇಲ್ಲ ಇಲ್ಲಿ.
I'll consult.
ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟರೆ ನೀವು ಸೆಟ್ಲೇ ಮಾಡಲ್ಲ.
Court employee. Venkatnaik is my close friend.
No, no.
I will see that. I will see.
You are friends, but the petitioner is a court employee. Stay ಕೊಟ್ರೆ he will never settle.
ಇಲ್ಲ. Because of this case, there is a little problem. He has to appear before the court and all, take leave and all.
ಯಾವ next date ಯಾವತ್ತು sir?
Both.
Who is he?
Yeah,
Ask him to be there.
Yeah.
Court employee ಅಂದ ತಕ್ಷಣ ಇಲ್ಲಿ ಬರೋದಲ್ಲ. Ask him to be there. Yes.
Sorry. More to it.
4?
Sorry, 13/8.
13/8.
13.
ಒಂದು ವಾರ ಕೊಡು. ಅದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತದೆ ಹಾಕಿ.
ಮಾಡಿ.
By then you want to settle it. You want to go back to PG or house?
I will consult my client.
Yes. List on ಯಾವತ್ತು ಬೇಕು?
12th ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
12th?
ಆಯ್ತು.
List on 12th in the fresh matters.
Fresh matters.
Yes. In the event no objections are filed by the learned counsel for the second respondent seeks time to file statement of objection on the score that is entered appearance only yesterday. In the event no objections are filed by the next date, this court would be constrained to grant an interim order of stay of all further proceedings. 13th ತಾನೇ ಇರೋದು next.
Next.
12th will pass.
Objection. Objection.
ಏನಿಲ್ಲ 498 ಆಗಿದೆ. Yes.
ಇದರ charges frame ಆಗಿದೆ.
Petitioner, my lordship, restrict my petition with respect to the petition number 3, my lordship.
Charge frame ಆದ್ರೆ 3 ಆದ್ರೇನು, 1 ಆದ್ರೇನು, 2 ಆದ್ರೇನು?
Yes, my lordship, at the time of the alleged offense, he was a minor, my lordship. And last hearing date, my lordship,
ಮತ್ತು ಒಂದು ಮೈನರ್.
minor son. And
What is the date of the offense? And what is 354 ಏನ?
yes, my lordship, kindly.
ನಿಮ್ಮ ಮೇಲೆ ಏನಿದೆ ಚಾರ್ಜ್ ಅಲ್ಲಿ ಬನ್ನಿ.
ನಂದೇನಿಲ್ಲ.
17/6/2017 my lordship.
ಅದಲ್ಲ ಮೇಡಮ್.
Lordship, kindly see the.
What is there against him, madam? One ನಿಮಿಷ. You are A3.
Yes, my lordship. It's a family dispute, my lordship.
No, no. A3.
Yes,
You are A3.
A3, my lordship.
Page number 21, it is
I
stated
am
that
there only, madam. A3 ಅವರು ಸಾಕ್ಷ್ಯವನ್ನು ಗಟ್ಟಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡು ಅವರುಗಳು ಪುನಃ ಪದೇ ಪದೇ. ಇವಾಗ 24 ನಿಮ್ಗೆ.
No, my lordship.
Now you are how much? 24 years.
Yes, my lord.
Date of the incident is 17/6/27.
17/6/2019. As per the Aadhaar card.
ಅಲ್ಲ ಆಧಾರ್ ಏನ್ ಬೇಡ ಪರವಾಗಿಲ್ಲ. 17/6/2017. 17 years and something.
Yes,
The offense is that
my lordship. She is the auntie.
auntie.
Of petitioner number 3. More than 3 civil suit is pending. And same cases, my lordship, she filed
There
three case against the same family members.
There is allegation here.
And my lordship, kindly see the annexure.
Merely
Yes,
you don't, ನೀವು minor ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು 10 ವರ್ಷ ಅಲ್ಲ, 17 ವರ್ಷ 6 ತಿಂಗಳು.
correct, my lordship.
Yes.
Kindly see the annexure yes and T, my lordship, page number.
Charges frame ಆಗಿದೆ, I will not interfere. Yes.
My lordship, because my lordship, now he received the.
Interim order ಕೊಟ್ಟಿದೆ ಮೇಡಮ್. ಯಾವಾಗ interim order ಕೊಟ್ಟಿದ್ದು? That's on 26/6 ಗೆ.
My lordship.
By then charge frame ಆಗಿರೋದು ಯಾವಾಗ?
ಅಲ್ಲ.
charges.
2017.
ಮತ್ತೆ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲ, kindly see the annexure, yes, my lordship.
Sir, I will
In
not.
page number 138, my lordship, he received the appointment order, my lordship.
ಯಾವ appointment order?
Bank, my lordship, kindly see the ink page number 138, my lordship, 138 and 139. Offer of appointment of the bank for post of grade A, office scale, assistant manager.
ಏನಾಯ್ತು?
So
ಜಾಯಿನ್ ಆಗಿಲ್ವಾ?
this is the.
ಜಾಯಿನ್ ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ.
ಯಾಕೆ?
Because my lordship, police give a report. Some cases are pending against the petition number 3 here. There are 2 appointment order, my lordship. Annexure T also, my lordship.
He will lose his employment.
138 and 139, 2 appointment orders. my
ಅಲ್ಲ
lordship.
ಮಾಡಿಲ್ಲ ಅಂತಲ್ಲ. It's a different thing. We have the charge sheet. Statement ಏನಿದೆ ಇವ್ರದ್ದು?
No, my lordship.
ಅದಕ್ಕೆ ಓನ್ಲಿ A3 ಸ್ಟೇ ಕೊಟ್ಟಿರೋದ?
ಇಲ್ಲ, entire proceedings, my lordship.
No, we'll only continue it against A3.
Right.
The charges have been framed in the case at hand is what the learned HCGP on instructions and verification of the records would submit. The learned counsel appearing for the petitioner submits that at least against A3 there should be some protection, as at the time of the incident, alleged incident, the third accused was 17 years old, and him having indulged in those acts which are alleged is highly improbable. But the proceedings are on. In the teeth of the, in the light of the proceedings pending, the learned counsel would submit that the petitioner has lost 2 opportunities of employment, as the police verification would reveal pendency of cases. Therefore, the interim order granted shall continue only against accused number 3, and que accused number 1 and 2, the same stands vacated in the light of the charges being framed against those petitioner, against all, particularly against accused number 1 and 2. List on 22nd, 21st. We'll see. Yes. Next.
Number 6.
For the petition. 7A, my lord. Last time they have submitted that they will file a B report, my lord. Till date, my lord.
Final report is ready, my lord. It will be filed within 10 days. Kindly granted.
List on next week, 8th. 8th,
10
list
days.
on 8th, same day, 7th.
10 days, my lord. At least 12.
ಎಲ್ಲ 7 ಇರೋದು ಅವತ್ತೇ B report ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕಿ. Yes.
7.
I appear for the respondent, my lord. In this case, I have filed my statement of objections. An interim order of stay was granted in this, in 138 proceedings on the ground that surfacey proceedings were also initiated by the respondent herein.
Yes.
Various high courts have taken a view, my lord, that that is not a bar in order to continue such proceedings. I'm providing a list of authorities. Madam.
My lord, the proceeding, my lord.
Punjab and
Under
Haryana.
section 14 of the Surface Act, my lord, I have not challenged. The property mortgage is possession is taken by the bank.
ಆಮೇಲೆ ಯಾಕೆ ಬೇಕು ಇವ್ರ ಮೇಲೆ?
My lord, ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅದಾದ್ಮೇಲೆ
ದುಡ್ಡೆಲ್ಲ ಬಂದಿದ್ಯಾ?
ಏನು ಬಂದಿಲ್ಲ.
ಮತ್ತೆ ಏನ್ ಸರ್ಫೇಸಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್?
Please, madam, I have in my statement of objections, I have filed.
Sir.
In my statement of objections, I have filed the second document, my lord, which is an interim order of stay granted by this honorable court, qua possession of the.
So you have not taken possession?
I have taken possession. What has happened is post that I have learned that the petitioners in both the petitions had previously mortgaged the entire extent of the land to Punjab National Bank and Bank of Baroda. Our auction purchase madi, somebody else has taken it. That auction purchaser had filed a petition before this court, wherein I entered appearance and told the R Flatman I have taken possession. This court had granted status quo, my lord. Adana I can't proceed. Aurdu one charge bere ide. Adadmele hing bandidare.
Wrong, my lord.
I believe on the previous occasion an attempt was made to convince this court to discharge it. Admelu I have started taking possession. But flats exchange agide ashte. Discharge deed was executed because they came up with 2 new flats.
Anyway, this is 138.
This is 138.
My lord, this is wrong, my lord. The order possession was taken last time.
List on Tuesday in the fresh matters list.
It's both
We will dispose that day.
connected.
Yes, sir.
They have an interim order.
Interim order subsisting shall continue till the next date of hearing.
I'm grateful.
In this case, my lord, the second respondent has filed the complaint, my lord, against the petitioner, stating that I have forged some document and has.
Correct. Let the respondent come.
No, the lordship
No,
had
madam.
directed the state to get the records, my lord. Last year.
ಎಲ್ಲಿದೆ? ಕೊಟ್ಟಿದ್ದೀರಾ?
On 10/7 it has been sent.
No, on 2/11/2021, my lord.
Monday, fresh matters list. Yes.
To the NDPS Act, my lords.
I'm for responding, my lord.
Yes,
In this
madam.
matter, additional Solicitor General is appearing, my lord. He has requested to
NCB,
get the date.
NCB, my lords.
He has requested to
On
get
the
the
facts
date on
of the-
14th.
NCB.
Please.
We'll take it on 13th. List on 13th in the fresh matters list. Yes. Next.
Third, 3, 4, 5 immoral traffic.
Huh?
Prevention of immoral.
Investigation, you know?
Directed to secure the investigation.
Yes, that's what.
Charge sheet is submitted to the trial court on 9/7/24.
Our ilvalla bidi. List on 21st.
Please.
Yes. Huh?
Respondent. Petitioner was the direct selling agent of the bank. In his name, the amounts were transferred. Although he was not the borrower, his name is mentioned in the charge sheet. And please, in the FIR. And they claim that there are no, and the petitioner has been involved in forging sale agreement, tripartite agreement, and raising 4 demand notes.
When was the agreement entered into, sir?
Sale agreement was entered into on 27/4/23.
23.
Please.
Tripartite agreement with the bank. You are a developer, is it?
No, I'm the representative of developer, my lord. In none of the documents, I'm a signatory, my lord. I'm representing the developer to borrow, to receive the money, purchase money. ಅಷ್ಟೇ ನಂದಿರೋದು.
Representative ಅಂದ್ರೆ ಯಾವ ತರ?
MOU, kindly come to inquiry number 102, 104, my lord, which has been executed by the developer in my favor.
Developer is accused number 1?
No, he's not a party at all.
These 4 documents are forged by the petitioner in
They claim, my lord.
1 minute, which are those documents, sir?
These tripartite deed at Annexure A5 5.
Annexure?
Annexure.
You filed your objections?
No, not yet, not.
File your objections.
Please,
Yes.
please, file my objection.
The learned counsel for the petitioner submits that he is accused number 2 and has nothing to do with the transaction between the developer and the complainant. The learned counsel appearing for the complainant bank submits that the petitioner has indulged in forgery of 4 documents, due to which the bank is now facing what are you facing?
Difficulties. We have dues are to the extent of 70 lakhs, which are.
The
we-
petitioner,
and these amounts
the
are-
bank has now, the loans secured on the strength of those documents have become sticky, STICKY, have become sticky, therefore would seek time to file statement of objections.
But I have no role to play in this one, my lord.
We'll see. Objections, if any, by the next date of hearing. List the matter on
21st.
21st in the fresh matters list.
Please.
Yes.
Please, object.
Not I feel for the petitioner in this matter. Under the Water Act.
Huh.
Not the allegation is not that I have been running a quarry in survey number 11. Not whereas not my survey number is 57.
Yes.
And I have been running with all permissions.
Again, close ಮಾಡಿದಾರಾ?
But
Yes, 33A, 31A. ಅಷ್ಟೇ ಅಲ್ಲ, there is a criminal case has been filed. And all these proceedings are of 2020, 2021. Inspection report is there, photograph is there, page number 26.
ಆಯ್ತು, ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ.
ಹಾಕ್ತೀನಿ.
meanwhile may I pray for
Meanwhile, ಯಾವಾಗ ಹಿಂಗೆ ಇರೋದು? 491. How much time?
ಒಂದು ವಾರ.
1 week. List the matter on 8th objections, if any, by then. 8th ಅಲ್ಲ, 7th.
Much.
I request
ಅವತ್ತು
for
7th in the fresh matters list. Yes. That day.
13.
Here for petition. FIR was registered on 6/4/2024. But on the same day, my mobile phone has been seized.
450, 451. ಏನಿದು? ಅಲ್ಲ, what vehicle? Phone, mobile phone?
Mobile phone.
Yes, sir. You have taken all the screenshots. Then why did you seize?
Lord, there allegation, my lord, that mobile was used for the purpose of online trading and all. Now
All right, you have taken everything from the mobile. What else did you want from the mobile?
Trial court has dismissed, my lord, on account of which.
No, that's all right, but why do you seize the mobile when you take you take the mirror image of the mobile?
Yes, my
And you take the mobile also, why? The petitioner is before this court calling in question an order dated 7/6/2024 by which the application filed by the petitioner under section 451 and 457 comes to be dismissed. The petitioner is the accused. The petitioner is accused who gets embroiled in a crime number 46.
140.
Crime number?
140/2024.
Crime number 140 of 2024 for offences punishable under section 78(1)(a) ಇದರಲ್ಲಿದೆ madam, 12 of the Karnataka Police Act. While so doing, prior to the registration of the crime, it transpires that the premises of the petitioner was searched on a credible information being received that the petitioner is running a betting racket. His mobile phone was seized. The seizure of the mobile phone led to the petitioner filing an application under section 451 and 457 before the concerned court. The concerned court rejects the application for release of the property so seized, i.e. the mobile phone. It is therefore the petitioner is before this court in the subject petition. The learned HCGP on instructions would submit that the content in the mobile phone have all been taken screenshots of, and therefore the mobile phone at this juncture would not be required for any further investigation. The learned counsel for the petitioner would submit the same, that all the screenshots had already been taken. There was no warrant to seize the mobile phone and keep it with the investigating officer all along. While whether the mobile phone could be seized in its entirety or otherwise need not be gone into at this juncture, as the learned HCGP would submit that investigation in so far as the contents of the mobile phone is concerned is already complete. Therefore, the petitioner shall be handed over the mobile phone within 2 days from the date of receipt of the copy of this order, ordered accordingly.
Grateful. Get released from the land magistrate. It's been subject to
Before the consent the concerned court shall release the PF another, PF 46.
46 of 2020.
PF 46 of so and so within 2 days from the date of receipt of the copy of this order. Yes.
Grateful.
Next.
My lord, the grievance, my lords, the respondent number 2 alleges that I have taken her gold dated 8 June 2022.
Based on 21st interim protection granted earlier and section till the next date of hearing. Next.
My lords, investigation.
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ
Protection.
ಸಾಕು.
Brief.
Charge sheet is filed, my lordship.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ, ನಿನ್ನೆ ಹಾಕಿದ್ದಾರೆ, my lordship.
ಇದೇನ್ ಕವರ್ಡ್?
Covered, your lordship.
ಯಾವುದಕ್ಕೆ? ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟ್ರಾ?
ಇಲ್ಲ, your lordship. It is the allegation punishable under section 3941 of Karnataka Money Lenders Act 1961. Your lordship, the complainant is not the debtor. Your lordship, in this matter under the procedure.
ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆಯಂತೆ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಬಿಡಿ. ವಿಲ್ ಕ್ಲೋಸ್ ದಿಸ್.
I may be permitted to place.
ಅದೊಂದು ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್. ಡಿಸ್ಪೋಸ್ಡ್ ರಿಸರ್ವಿಂಗ್ ಲಿಬರ್ಟಿ ಡಿಸ್ಪೋಸ್ಡ್ ಅಂತ ಚೇಂಬರ್ ಕಡೆ ಚಾರ್ಜ್ ಶೀಟ್.
Much obliged.
Yes, sir.
IO report submit, ನಿನ್ನೆ ಮಾಡಿದ್ವಿ.
ಇಲ್ಲದೆ ಇಲ್ಲ.
Kindly see page 17. ಇದರಲ್ಲಿ ರಂಗಪ್ಪ ಕಡೆಯವರು ರಂಗಪ್ಪ ಮುನಿರಾಜು ಮತ್ತು ಮುನಿರಾಜನ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿ. ಸೇಮ್ ಡೇ ಪೇಜ್ 23 ಮುನಿರಾಜು ರಂಗಪ್ಪನ ಮಕ್ಕಳು ಮೊಮ್ಮಕ್ಕಳ ಮೇಲೆ ಇದು ಮಾಡಿ. ಆನ್ 17/7 at 8 o'clock, 8 p.m. supposed to be this incident in which my name is, petitioner's name is brought in. That's at page 17. Kindly see page 17. It gives the names. ರಂಗಪ್ಪನ ಮೊಮ್ಮಗ ಇತರರು 16/7 ರಾತ್ರಿ 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ತಂಗಿಯ ಮಗ ಬಂಡೆಕೊಂಡಿಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ಕಾರ ಹತ್ತಿರ ಇದ್ದಾಗ ರಂಗಪ್ಪನ ಮೊಮ್ಮಗ ಹಾಗೂ ಅವರ ಮಗ ಕಾರ್ತಿಕ್ ಅವನ ಮೇಲೆ ಏಕಾಏಕಿ ಗಲಾಟೆ ಮಾಡುತ್ತಿದ್ದಾಗ ರಾಮಪ್ಪ ಈ ಮೇಲ್ಕಂಡ ಅಸಾಮಿಗಳು ಏಕಾಏಕಿ ಅವನ ತಲೆಗೆ ಮಚ್ಚನ್ನು ಬೀಸಿದ ರಭಸಕ್ಕೆ ಅವನ ಎಡಗೈ ಅಡ್ಡ ಇಟ್ಟಿದ್ದರಿಂದ ಅವನ ಕೈಯನ್ನು ಕತ್ತರಿಸಿ ಅವನ ತಲೆಗೆ, ಕುತ್ತಿಗೆ, ಕಾಲುಗಳಿಗೆ ಮಚ್ಚು ಲಾಂಗ್ಗಳಿಂದ ಕತ್ತರಿಸಿ ಮರಣಾಂತಿಕ ಹಲ್ಲೆ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್.
ಎಸ್ ಸರ್.
DK ಮಂಜು ಅವನನ್ನು ಬಿಡಬೇಡಿ, ಮೊದಲು ಸಾಯಿಸಿ ಆ ಹೊಲೆ ಮಾದಿಗ ಮಗನನ್ನು ಬಿಡಬೇಡಿ ಎಂದು ಹೇಳುತ್ತಿದ್ದಂತೆ. With this, now the provision FIR is filed under 31R, 31S and
BNS
109 and
yes.
ಇದಕ್ಕೂ ಮೊದಲೇ ಈಗ ಒಂದು 5-6 ವರ್ಷದ ಮೊದಲೇ ಪಂಚಾಯತ್ ಎಲೆಕ್ಷನ್ ನಲ್ಲಿ ದಿಸ್ ಮುನ್ರಾಜು ಹ್ಯಾಡ್ ಲಾಸ್ಟ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಪೆಟಿಷನರ್ ಅಂಡ್
6 ವರ್ಷಗಳ ಹಿಂದೆ.
ಆವಾಗ ಒಂದು ಪೇಜ್ 22
ಪೇಜ್ ಇದರಲ್ಲಿ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಕ್ಕೆ ಹೇಳಿ.
page 28.
28, sir.
Page 28. This Muniraju himself had filed a complaint. I mean, FIR was registered under 504, 506 and read with 34 against this BK Manju and 4 persons. In that, only against BK Manju in 2024, charge sheet was filed. That was challenged, my lord. Your lordship may kindly see.
Page 27, interim order is granted.
Interim order is granted. BK Manju ಅನ್ನೋದ್ರದ್ದು ಅವರಿಗೆ
But ಈ crime ಅಲ್ಲ ಅದು.
ಅಲ್ಲಲ್ಲ ಇವ್ರನ್ನೊಂದು ಬಿಟ್ರೆ ಈ ಇದಲ್ದೆ ಹೋದ್ರೆ ಬೇರೆ ಯಾವುದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಅಲ್ಲಿ ಮಂಜು ಒಬ್ಬವನ್ನು ಬಿಟ್ರೆ ಬೇರೆ ಎಲ್ಲರೂ ದೇ ಆರ್ ಫ್ರಮ್ ದಿ ಸೇಮ್ ಗ್ರೂಪ್ ಬಿಲಾಂಗಿಂಗ್ ಟು ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್. ನನ್ನ ಒಬ್ಬವನ್ನ ಅಲ್ಲಿಗೆ ತಂದಿರೋದು ಒಂದು, ದೇ ಗೆಟ್ ಸಮ್ ಮನಿ ಫಾರ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಎಟ್ಸೆಟ್ರಾ. ಸೆಕೆಂಡ್ ಈಸ್ ಆ ಅಫೆನ್ಸ್ ಇದ್ರೆ ನಾನು ಐ ವಿಲ್ ನಾಟ್ ಬಿ ಏಬಲ್ ಟು ಮೂವ್ ಫಾರ್ ದಿಸ್.
But allegations are there.
ಅಲಿಗೇಷನ್ ರಾತ್ರಿ 8 ಗಂಟೆಗೆ ಆಗಿರೋದು.
ಆಯ್ತು, ಯಾವಾಗಾರ ಆಗಿರ್ಲಿ, ಬಟ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ ಟು ಸ್ಟೇ ಇನ್ ದ ಟೀತ್ ಆಫ್ ಎಲಿಗೇಷನ್ಸ್ ಬಿಕಾಸ್ ಕ್ರೈಮ್ ಇಸ್ ರಿಜಿಸ್ಟರ್ಡ್ ಅ ಮಂತ್ ಅಗೋ.
ಅಲ್ಲ ದಿಸ್ ಇಸ್ ಆನ್ 17/7.
ಏನು ಕ್ರೈಮ್ ಇಸ್ ರಿಜಿಸ್ಟರ್ಡ್ ಆನ್ 17/7?
ಹೌದು.
ಇನ್ಸಿಡೆಂಟ್ ಯಾವತ್ತು?
16/7 ಗಂಟೆಗೆ 17/7 1:00ವರೆಗೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ.
Which is
page 10.
17/7, correct.
17/7.
Incident 16/7.
ಹೌದು.
No, ಇದ್ಯಾವ್ದು?
ಆಮೇಲೆ
36/24 ಯಾವ್ದು ಕನೆಕ್ಷನ್?
ನಾನು ತೋರಿಸಿದ್ದು ಅವರವರ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಯಾವಾಗ್ಲೂ ಜಗಳಗಳು ನಡೆದಿದ್ದಾವೆ. ನನ್ನ ದಿಸ್ BK Manju is brought in with this allegation that he is the only non-SC/ST in that.
But when
The complaint in
the teeth of these allegations, how do you?
Of course, my lord, the allegation.
Because 17/7 crime ಆಗಿರೋದು.
ಅಲ್ಲ, ಆ ಎಲಿಗೇಷನ್ ನಲ್ಲಿ ನಾನು 8 ಗಂಟೆಗೆ ಆಯ್ತು, ಆಮೇಲೆ ನಾನು ಬಂದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ದ ಎಲಿಗೇಷನ್ ಈಸ್ ಅವನು ಹೊಲೆ ಮಾದಿಗ, ಅವನ್ನ ಬಿಡಬೇಡಿ ಅಂತ ಹೇಳಿದ್ರು ಅಂತ. ಅದೇ ಅವರು ಪಂಚನಾಮೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಇಟ್ ಬಿಕಮ್ಸ್ ಆಲ್ ಟುಗೆದರ್ ಇನ್ ಎ ಡಿಫರೆಂಟ್ ಮ್ಯಾನರ್.
And who is Chandan?
ಅವರೆಲ್ಲ ಅವರ ಫ್ಯಾಮಿಲಿನೇ, ಅವರವ್ರ ರಿಲೇಷನ್.
Chandan Kumar is the complainant.
ಚಂದನ್ ಕುಮಾರ್ಸ್ he is injured. He is ಅಂದ್ರೆ ಸೋದರ ಮಾವ ಅಂತ ಕಾಣುತ್ತೆ, ತಂಗಿ ಮಗ ಅಂತ ಹೇಳ್ತಾರೆ. ಮುನಿರಾಜು is the complainant.
No, not a case for interference now.
Rangappa.
Chandan
I am seeking
Chandan is in the ICU.
I am seeking interference only with regard to that allegation under SC/ST.
No.
31R and S is something totally brought up.
Let the complainant come. Let's hear the correct picture. Notice ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
Heard the learned senior counsel Jaykumar S. Patil appearing for the petitioner. Though the learned senior counsel has made vehement submissions with regard to grant of an interim order of stay, at least insofar as the offence punishable under the Atrocities Act, a perusal at the complaint would prima facie indicate certain abuses being hurled, as the incident has undoubtedly taken place in a public place or in a place of public view for offences under section 31R and S. The view is prima facie till the complainant would appear and make submissions, or the state would secure further investigation material and place it before the court. List on 19th in the fresh matters list. Yes.
20?
ಅಡ್ಜನ್ ಆಗಿಲ್ವಾ? 20 ಅಡ್ಜನ್ ಆಯ್ತಲ್ಲ? 17. It's 17.
17.
Yes, sorry, yes.
For the petition, for the indulgence.
ಈಗ ಎಷ್ಟು 5% ಕಟ್ತೀರಾ?
5% ಕಟ್ತೀವಿ. Already 6 lakhs rupees DD ತಗೊಂಡಿದ್ದೀನಿ.
How can we tamper with it? ಜಂಬೋ ಭಂಡಾರಿ ನೋಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ.
Please.
The petitioner is before this court calling in question an order dated 2/5/2024 passed by the Court of Sessions rejecting an application on an application filed under section 319 of the CRPC, seeking time to deposit the amount as obtaining under section 148 of the Negotiable Instruments Act. The petitioner is the accused who gets convicted of the offense punishable under section 138 of the Negotiable Instruments Act and is directed to pay an amount of 1 crore 45 lakhs. Sir.
Please.
1 crore 45 lakhs. The order was challenged before the Court of Session in Criminal Appeal 33 of 2024, and the court suspends the sentence and makes it subject to condition that the petitioner would deposit 10% of the fine amount within 10 days. Not being able to deposit the said amount, the petitioner is knocking at the doors of this court in the subject petition. The learned counsel for the petitioner submits that if time beko,
Tomorrow itself I'll deposit my note because 6 lakhs rupees I have taken the DD I have produced before this court also.
total 14 lakh barata.
14 lakh bucks.
The learned counsel would submit that if 2 weeks time is granted, he will comply with the conditions so imposed by the concerned court for deposit of the amount and suspension, which is made subject to the condition, which is made a condition precedent for suspension of the sentence. 2 weeks alagata?
I am before this court from 10% to 5% decrease ಮಾಡ್ಲಿಕ್ಕೆ ಇದೀನಿ ಸ್ವಾಮಿ. 5% ನಾನು ಕಟ್ಲಿಕ್ಕೆ ನಾನು ನಾಳೆನೇ ರೆಡಿ ಇದೀನಿ, ನಾಳೆನೇ ಕಟ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ. ಆಲ್ರೆಡಿ 6 lakhs ನಾನು ಡಿಡಿ ತಗೊಂಡಿದ್ದೀನಿ, 1.5 lakh ಡಿಡಿ ತಗೊಂಡು ನಾನು ನಾಳೆನೇ ಪೇ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಅದು ಕನ್ವಿಕ್ಟ್ ಆದ್ಮೇಲೆ ಎಲ್ಲ ಆಲ್ ಏಲ್ಮೆಂಟ್ ಶುರು ಆಗುತ್ತೆ, ಅಲ್ಲಿವರೆಗೆ ಸರಿ ಇರ್ತೀರ?
ಇಲ್ಲ.
What to do, tell me.
2015 itself he is a cancer patient, my lord. He was practicing advocate actually, in fact.
Learned
now he
counsel
is-
for the ಏನ್ ಹೇಳಿ ಲಾಸ್ಟ್ ಲೈನ್ ಇಂದ ಮೇಡಮ್. Precedents wants. The learned counsel for the petitioner submits that the petitioner is a patient suffering from carcinoma of the lymph and is presently not in a position to pay the complete 10% as is directed by the concerned court. The learned counsel would seek to place reliance upon the judgment of the apex court in the case of Jambu Bandari versus so-and-so, reported in 2023, 10 SAC page 446, where the apex court has held that deposit of an amount of 20% as obtaining under section 148 of the Negotiable Instruments Act is not mandatory for the order of suspension of sentence or continuance of proceedings before the concerned court. In that light, I deem it appropriate to accept the plea of the petitioner that he would deposit 5% of the amount within the next 1 week before the concerned court, and the concerned court to continue the proceedings on such deposit of 5%. For the aforesaid reasons, the following order. The petitioner is permitted to deposit 5% of the amount within the next 2 days before the concerned court, as against the 10% that is directed to be deposited following the judgment of the apex court in the case of Jambu Bandari Supra. In the event the petitioner would default in such deposit, the interim protection that is granted. Illen ಕೊಟ್ಟಿದೀವಾ?
ಇಲ್ಲ ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ sir.
If in the event the petitioner would deposit 5% of the amount, the concerned court shall continue the proceedings on such deposit and not insist on the 10% that is ordered in the that 10% that is ordered in the impugned 10% that is ordered in terms of the impugned order dated so and so, ordered accordingly. Yes.
Oh, best.
Next.
Lord, I have verified, my lord, only they have filed charge sheet already, my lord, 1 to 25. So far as petition 3 hours is completed, they have not filed charge.
Or it's a state, Lord, I lodged it.
My lord, by instructions, my lord, subsequently, my lord, after filing the first charge sheet, my lord, case number 26, the present petitioner was taken to custody, my lord. And the petitioner has only challenged the remand application. Charge sheet subsequently is submitted to the court. Is what my instructions.
So, supplementary charge.
Against the
They have not filed, my lord, I verified supplementary, they have not filed a charge sheet.
That's all right, but allegations is there.
Lord, only based on the A3 statement, my lord, they having, let them, my lord, they have not filed charge sheet, let them place, my lord, I have verified
Kodi
in the
ade.
trial court.
Yes, place the material. List the matter on 12th in the fresh matters list. The Learned HCGP to secure the material that is against the petitioner and place it before the court on the next date. Yes, next.
So, Annexure H, page 175. Is the plaint filed by the first informant was against A6, her own daughter, A1, A3, and A2, and another person, stating that her signature was taken on blank papers and they have converted them into power of attorney and transacted with the properties in question. And she seeks lots the partition of the properties left behind by her husband. This was way back lots on 12/6/2009.
What are you challenging now, sir?
So I am challenging the charge sheet where 39 documents which are collected by the Burali police are suppressed by the DJ police after retransfer of the case. Lots to the Burali.
Now, what stage is the proceedings?
Lots, it so happened, lots, once I came to know that they have suppressed, I filed an application in section 91 seeking direction to the police to produce those documents. That application came to be allowed.
When?
Not that was allowed, lots in 2023. Then they were in the process of compliance and there was a delay and they were not responding. Therefore, not the magistrate issued bailable warrant to the officers.
All right.
At that stage, my lord, suddenly, my lords, summons were issued to the witnesses. And one of the witness my lords appeared and his examination chief has happened.
All right.
But my entire case, that suppression of those 39 documents, which are listed in the charge sheet at page number 100.
How can I interfere at this stage here, sir?
But this, the submission is this. Initially, suit was filed. Then.
No, that's on the merit of the matter. The trial is on.
I came before this honorable court. Initially. Then Lord, this honorable court passed an order.
Yes.
I request you to kindly see Annexure J, page 182.
180?
182. At the FIR stage itself. So this honorable court gave me liberty to file all my documents before the IO. Which lords we complied with.
All right.
Kindly see lords Annexure K, page 185. After the order of this honorable court dated 12th August 2010. Then lords in a month's time, on 10th January 2011, lords, all the documents including the plaint filed by the first informant were been produced before the DJ police. They did not take note of it. In the meantime, my lord, the DJ police transferred the investigation to Diburhalli police. Then in the process of when the matter was being concluded there, kindly see page number 100.
What is the order passed by the court allowing the application?
Allowing the application, awaiting the records from DJ police.
All right, they will produce it.
Allowed, producement that goes in my favor, that's helpful to me. And in the absence of that, but now the learned judge not issues witness summons. Therefore, by only till the documents come, if the matter is
No. Where are the documents?
Kindly see page 100.
Have they produced it before the court?
No, they are not produced. Only part.
When was the order passed?
This order was passed in 2023. I'll just give it.
Just look into it. Where are the documents?
This, my lord, as
By 2022.
challenging the entire proceeding.
Entire proceeding, I'm not going to interfere, sir.
No, I will-
2013 proceeding, I'm not going to
ಅಲ್ಲ,
interfere.
ಇಲ್ಲಿ Supreme Court ಅವರು ಹೇಳಿದ್ದಾರೆ
ಕೊಡಿ.
if there is a subversion of the investigation itself.
Kodi, sir. Yes. At what stage I can interfere anta kodi?
Even if the trial has commenced. What my lord, the
Yes.
Honorable Supreme Court.
Kodi, sir. Yes. Will not send any counsel back. Show me that.
2016 volume 4.
This is after the trial has commenced, further investigation ಕಳಿಸ್ಬೋದು ಅಂತ.
ಅಂದ್ರೆ the
ಅಂದ್ರೆ?
investigation ಇದು documents ಇಂದ ನಮಗೆ suppress ಮಾಡಿ. Kindly see not page 100. of
You
the-
give me a judgment saying this court can interfere after framing of charges and when the trial has commenced. That's all.
And when.
If you are seeking further investigation, it's a different matter altogether.
But these documents, kindly see.
You are seeking quashment of the entire proceedings.
On the ground, not that these
No.
documents are withheld.
What is withheld?
Kindly see page 100
Yes.
of the papers. It's part of the charge sheet.
Yes.
This is dated 23/7/2011.
Yes.
Then, my lords, this is written by the Superintendent of Police, Chikbalapur District, to the Deputy Commissioner of Police, Bangalore East.
2023 ಲೇನೋ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂದ್ರೆ ಯಾವ್ದು?
ಅದು, yes. Annexure Q,
Page
206. Read that. I'll just point.
Written
260,
submission.
260 ನಲ್ಲಿ on 5/2/2022.
22.
How?
What order has passed?
In the order sheet, it is available.
5/2/22.
How?
260.
260. My application, section 91, based on the.
All right. Office directed to issue direction to PI.
Yes.
To documents so shown under so and so. All right.
ಆಮೇಲೆ ಇದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗ್ಲಿಲ್ಲ.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿಲ್ಲ ಅಂತ ಎಲ್ಲಿದೆ?
ಇದೆ ಹಾಗೆ ಕಂಟಿನ್ಯೂ ಬೇಲೆಬಲ್ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಯಾರಿಗೆ? ಇವರಿಗೆ?
ಆಫೀಸರ್ಸ್ಗೆ.
ಆಯ್ತು, ಸರಿ.
So the matter was pending. Then lots on fine day, the learned magistrate issues a witness summons.
To whom?
To CWs 1 to 14. And one CW 1 ತೀರೋಗಿದ್ದಾರೆ.
That is police officers, is it?
ಇಲ್ಲ, CW 2 is the grandson of CW 1 who is no more now. Who is the first informant.
So without getting these documents, witness summons should not be issued.
ನಾನು ಅಷ್ಟೇ ಅದು ಬಂತು ಅಂತಂದ್ರೆ.
ಏನಾಗಿದೆ ಇದು ನೋಡಿ.
Here, my lord, the
39 documents.
No, if these that's all right. If these documents are not brought on record and those witnesses are examined, what? The need of these documents when it gets obviated. What is the next date?
I think 19 September.
Check with it and come. Rest on. I am not going to quash the entire proceedings. Will not interfere. No.
ಅದೇ ಸಬ್ವರ್ಸ್ ಇದು ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪೊಲೀಸ್ ಅವರು ಸುಟ್ಟಾಕ್ಬಿಟ್ಟಿದ್ರೆ.
Documents ಎಲ್ಲಿ ಹೇಳಿ ಅವ್ರು.
ಹೇಳಿ.
Yes. Quashing proceedings ಬರೋದೇ ಇಲ್ಲ. Is list on.
ಅಲ್ಲ, ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಹೇಳಿರೋದೇ ಒಂದು, ಆಮೇಲೆ 4 ತಿಂಗಳಾದ್ಮೇಲೆ FIR ಹೇಳಿರೋದು ಮತ್ತೆ.
ಅದೆಲ್ಲ too late in the date.
That's why I had come to this honorable court earlier.
No, this court has said prima facie investigation is required. Matter is
We are
earlier order.
liberty to
Nothing.
produce documents. We have produced.
No,
Documents.
no quashment of these proceedings. Is the 91 ಏನಾಗಿದೆ ನೋಡ್ಬಿಟ್ಟು will deal with it. Yes, list on 28th August.
Seventh, madam.
7 ಏನ?
7th, file my objections. Witness.
What's the problem now?
Sixth, my lord.
6th, yes. List the matter on 6th in the fresh matters. Yes.
23.
After filing of the petition, the petitioner and the second respondent intends to settle the matter. There's one more matter, my lord, which is not listed today. WP 20645.
Tag this petition along with the so and so number.
20645. I'll just write.
So ಯಾವತ್ ಬೇಕು?
8, my lord.
List the matter on 8th at 2:30 PM to report settlement.
Great.
Yes.
Order. Which court?
2 weeks time to do the needful. Enter order ಇದೆ ನೋಡಿ madam.
2526 adjourned.
Madam,
7.
24.
7.
One submission with respect to serial number
Madam.
29.
24. 2 weeks time to do the needful. ಅಲ್ಲೆಲ್ಲೋ ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ.
7.
Hmm.
27.
27, my lord, I appear for petitioner.
20? Which is yours?
Your lordship, other matters are pending because insofar as 3 accused persons separate petitions have been filed. All the matters will be
26 ah?
27, sir.
3 matters ಯಾವ್ದು?
Insofar as there are three accused persons are there, all belongs to one family, my lord. That's the criminal petition 5231 of 24 and criminal petition.
38.
Yes, there are two.
Yes, sir.
Yes, my lord.
You're appearing for, yeah, sir.
For R2. respondent.
R2. Which are those matters, madam?
Criminal petition 5231 of
Barcode,
24.
madam. Yes. Is already, he's on record. Ibridare? Chandrachud.
Yes, my lord.
You are Chandrachud.
Yes, ma'am.
Registered to delete the name of Sangamesh RB as appear.
Sangamesh, we will continue. He is our senior. Mine
You have
will
two
be-
seniors.
No, Sangamesh is myself, Chandrachud.
Oh, you are Chandrachud. Ibradu Beka. Yes, so
Interim order.
tag these petitions along with so and so. List after 2 weeks, interim order granted earlier stands extended to the next date of.
Grateful.
Next.
I'm appearing for the petitioners, my lord.
Objections.
My lord, last time only before this honorable court only have submitted the
Received
objection. It is there with him, my lord.
I've received the objections,
Hmm.
my lord. My lord, I'm appearing for the petition in this case.
No, nothing on merit. Wait, sir. Put him, madam. What is the urgency?
My lord, the petitioner number.
498.
Yes, your honor.
You are the husband.
No, my lord, I'm.
Accused number 2, yes, sir.
My lord, I have filed my detailed objection, my lord.
Hmm.
My lord, I am the first wife, my lord. After marrying me, my lord, he has got again married.
Hmm.
And for the quashing also, he has filed a petition before the Honorable High Court, Allahabad High Court. They are also, ಹೌದು ಸ್ವಾಮಿ ಅಲ್ಲಿ ಹಾಕಿದ ಡೀಟೇಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಐ ಹ್ಯಾವ್ ಅನ್ನೆಕ್ಸ್ಡ್ ದ ಪೇಪರ್ಸ್ ಮೈ ಲಾರ್ಡ್.
ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಹೌದು ಸ್ವಾಮಿ.
ಆಯ್ತು, ಅದು ಹಸ್ಬೆಂಡ್ ಆಯ್ತು, ಬೇರೆಯವರೆಲ್ಲ ಯಾಕೆ?
ಇಲ್ಲ ಅಲ್ಲೂ 498 ಇದೆ ಸ್ವಾಮಿ.
ಪೇರೆಂಟ್ಸ್ ಎಲ್ಲ ಯಾಕೆ ಬೇಕು ಅಂತ?
Swami, see that, my lord, they were all party to the second marriage of the accused number 1, my lord.
Hmm.
And my lord, see that, my lord, after marrying, my lord, 2016, my lord, he immediately files a petition for divorce before the court in Uttar Pradesh. Thereafter, I approached the Honorable Supreme Court and the same, I got it transferred to the Bangalore court, my lord. And the case was being.
Now, which is that?
Bangalore release, Swami, divorce petition, Swami.
Divorce petition.
How, Swami? During the pendency of the divorce petition, my lord, without obtaining divorce, my lord, he has got married. In the meanwhile, my lord, I have filed a maintenance petition wherein more than 6 lakh is pending before me. My lord, I am a
No,
totally
husband
helpless.
is not before the court, sir.
Husband is not before the court,
others.
but they are all party to the this thing, my lord, in the sense, my lord. Because they have not only cheated me, my lord, but again, during the pendency of my marriage, my lord, they got second marriage, my lord. And even before the Allahabad High Court, they moved the application. My lord, if I will fairly admit, my lord, there is no case against the petitioner number 5, my lord. I fairly admit she was in Oman, my lord. Other than that, my lord.
4. 3, 4 and 5, sir.
No, Swami, ಇವರೆಲ್ಲ ಪಾರ್ಟ್ ಆಗಿದ್ರು ಸ್ವಾಮಿ. ತಂದೆ ತಾಯಿ ಮತ್ತೆ ಬ್ರದರ್, ದೇ ಆರ್ ಪಾರ್ಟ್ ಆಫ್ ದ ಸೆಕೆಂಡ್ ಮ್ಯಾರೇಜ್.
ಯಾರು ಸರ್?
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
1 and 2.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
3 and 4 ಯಾರು ಸರ್?
They are brother-in-law.
Sister-in-law and
Sister-in-law, brother-in-law. But I fairly admit, my beloved sister-in-law was not, neither she was part of the marriage of second marriage, neither she was.
You take care of the mother-in-law and the father-in-law. And the husband, who is the alleged second wife?
Second wife, that also have, I have produced the photographs annexed, which is there, my
My
lord.
lord, petitioner number 1 is 69 years old. Petitioner number 2 is 65 years old. They don't have any role whatsoever. In fact, your honor, in the statement of objections also, there has no allegations that has been leveled against petitioner number 1 and 2, my lord.
My lord, petitioner, the photographs also have annexed the second marriage and the FIR also, which was lodged in Uttar Pradesh, that also have annexed, my lord.
No, there, who are the accused?
They are also, these are the accused. These persons are the accused.
What has, they have challenged it before the court there?
They have challenged before the Honorable Allahabad High Court.
What happened?
What has happened, my lord, while after arguing at length, they confirmed their prayer to not to arrest in view of the Lalita Kumari judgment. They have given up their quashing this thing, my lord.
Yes.
My lord.
And my lord, that FIR also have annexed, my lord, which is translated copy, which is there, my lord. First information report of the which the second wife
Have you
has
seen the objections?
filed.
My lord, I have seen the objection.
ನನಗೆ 6 ಲಕ್ಷ ಕೊಟ್ಟು.
Wait, sir.
ಆಗ್ಲಿ.
Ask your parties to stand behind.
My lord, I've perused the objections, my lord, there is no allegations that has been leveled against petition number petition number 1 to 5. My lord, in fact, they don't have any role. In fact, the complaint of this case also, there is no allegation against petitioners, my lord.
Who are these in the photographs? Father and mother illo illi?
My lord, the cause of action of that case is different, my lord, and the proceedings are already going on. The charge sheet is yet to be filed, my lord.
There, what is the offense in Allahabad High Court?
So me 498 is there. In addition to that, there is section 270, my lord. What has happened, my lord? That accused number one.
ಅಲ್ಲಿ ಬೈಗಮಿ ಇಲ್ವಾ?
ಅದು ಇದೆ 494 ಇದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲೂ ಇದೆಯಾ?
ಅಲ್ಲೂ ಇದೆ
ಎರಡ್ ಕಡೆ ಯಾಕೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಇಲ್ಲಿ ಬೈಗಾಮಿ ನಾವು ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ.
ಇದು 498.
ಬರೀ 498.
ಎರಡ್ ಕಡೆ ಯಾಕೆ 498?
ನಾವು ಒಂದ್ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ. ಐ ಆಮ್ ದ ಫಸ್ಟ್ ವೈಫ್ ಮೈ ಲಾರ್ಡ್. ನನಗೆ ಹರಾಸ್ಮೆಂಟ್ ಐತಂತ ನಾವು ಹಾಕಿದ್ವಿ.
ಅಲ್ಲಿ ಹಾಕಿರೋದು ಯಾರು?
ಸೆಕೆಂಡ್ ವೈಫ್ ಹಾಕಿರೋದು ಸ್ವಾಮಿ ಅಲ್ಲಿ. ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ವೈಫ್ ಹಾಕಿರೋದು ಸ್ವಾಮಿ.
My lord.
ಬೇರೆ ಇನ್ಯಾವ ವೈಫ್ ಎಲ್ಲ ಹಾಕಿದಾರೆ ಏನಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. ನಾವು ಮೇಂಟೆನೆನ್ಸ್ ಆಗಿನ್ ಸ್ವಾಮಿ. ಸ್ವಾಮಿ ಐ ಆಮ್ ಟೋಟಲಿ ಹೆಲ್ಪ್ಲೆಸ್ ಲೇಡಿ. ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ಎ ಸಿಂಗಲ್ NP ಟು ಮೇನ್. ಹಿ ಇಸ್ ಅ ಸೈಂಟಿಸ್ಟ್. ಇಸ್ ಅರ್ನಿಂಗ್ 3-4 lakhs per month. ಕೊಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಹೌದು ಸ್ವಾಮಿ.
The entire complaint has been arrayed only for seeking maintenance, my lord. My lord.
You're not paying maintenance.
My lord, maintenance is for A1, my lord. I'm not appearing for A1.
Parents. All right, we'll see.
My lord, 3, 4 and 5 does not have anything to do. They are brothers and sister-in-law, my lord.
Let the mother-in-law and father-in-law be there. Yes, we'll stay against 3, 4 and 5. Not 1 and 2.
Yes,
My lord, they are 69 and 65 years old, my lord.
No
They
problem.
don't.
Why did you get her married again? Get your son married again. The issue in the list appears to be the accused number 1 getting married all over again during the subsistence of the first marriage. The learned counsel appearing for the petitioner submits that the alleged second wife has, first wife has preferred the subject crime which is pending in CC 34 of 2022, and the second wife, alleged first wife only.
ಅಲ್ಲಿ second wife.
The alleged second wife has preferred, has registered a crime before the jurisdictional police at Lucknow and is pending consideration before the High Court of Allahabad.
Can I interpret my? It is not in Lucknow, my lord. Badaun anta swami. Badaun.
Badaun.
BADAUN Badaun anta swami.
Badaun. In Badaun, and the matter is pending consideration before the High Court at Allahabad. A perusal at the complaint or the summary of the charge sheet would not indicate any offense against petitioners 3, 4 and 5 who are accused 4, 5 and 6, as they are either other members of the family or members of the family who are residing outside residing elsewhere and had nothing to do with the affairs of the husband, wife, or the mother-in-law and father-in-law. In that light, there shall be an interim order of stay of further proceedings, qua accused 4, 5 and 6, petitioners 3, 4 and 5 till the next date of hearing.
My lord, one small submission. My lord, the second marriage has happened after the FIR has been filed. This instant FIR has been filed. It has happened subsequently, my lord.
So what?
My lord,
What difference that does make?
My lord, the cause of action is different. The proceedings are already.
That's all. Yes, so and so. List the matter after 4 weeks. Yes.
Much.
No date.
29.
Post immediately after service.
I undertake to appear for
Learned counsel
Sunil Kumar S.
Sunil Kumar S. undertakes to enter appearance for the respondent registry to print the name of so and so is appearing for the respondent.
Interim order to continue.
Interim orders of objections?
Next date and everything.
Yes, list after 2 weeks. Objections, if any, by then interim order subsisting shall continue till the next date of hearing.
Appear for the petitioner, please.
Post immediately after service of notice upon the second respondent, interim order will continue.
Great. Interim order is there, man.
Continue, sir. Yes.
Great.
Same order.
52,
Same order,
3,
same order.
54.
Petitioners.
Same order.
My lord, my name may be shown. Venkatesh Sarvati may.
ಯಾವ್ದಕ್ಕೆ ಸರ್?
34, my lord.
ಅರುಣ್ ಕುಮಾರ್ ಇಲ್ವಾ?
ಇಲ್ಲ, Venkatesh Sarvati.
Registry to delete the name of Arun, 34 li madam. Registry to delete the name of Arun Kumar YH and print the name of Venkatesh Arbatti as appearing for the respondent. Madam, 38 ಆದ ತಕ್ಷಣ settlement will ತೊಗೊಳ್ಳಿ.
35 dispose, 36. I appear in 36. These are two petitions. One is on a complaint filed by the wife. My lords, in fact, we've even filed a synopsis. My lords have to give us 15 minutes. My lord, that's all I think
15 minutes, not today.
it may take. My lords may then put it on a day little higher in the list so that we have some chance.
No, today it's higher in the list because it was the other day, the
Yes,
special
yes.
bench matters today, so it took off time there.
Could it be on 8th or 9th?
A husband and wife problem, huh?
I said that
My
8
lord,
proceedings which are there, 8
Domestic,
proceedings between them, my lords, that's the matter.
no, it's domestic. I have filed a
Then
complaint.
15 minutes I don't think would be enough.
It should be, my lord. It's
Synopsis
quite
may take
glaring.
about 20 minutes.
It's quite glaring.
And they produce certain additional material, my lords. If we have to see that, maybe half an hour for that material itself, my lords. All WhatsApp chats, everything is being produced.
Oh,
so-
you don't sit, you think I'll read the chats and say, no? Yes.
It may not take, I leave it to my lords, 8th or 9th, my lords.
9th, madam.
9th.
Yes. 9th will give you at 3:30 PM.
My lords, 3, let it come in the fresh matters list. It's more likely to reach in the first list.
3:30, I'll take it at the time. Yes.
Can we mention at 2:30
Ah,
at
please.
least?
Yes. Interim orders ಇದೆಯಾ?
ಇದೆ.
Interim
ಎರಡು
orders are
material
there in
ಇದೆ.
Both the matters.
Yes.
Yes, list the matter on 9th at 3:30 PM. Interim order subsisting shall continue to the next date of hearing.
Great.
That day we finish it off.
Please, we'll try to. Great.
Yes.
37?
Hearing for the petitioner, my lord. The service of notice has been done, needful is done, and the, sorry, my lords, the offense is pertaining to section 409 of IPC.
Interim order ಇಲ್ವಾ?
Interim order ಇಲ್ಲ, my lords.
Certainly, yes. Post immediately after service of notice upon the second respondent. Yes. Non-compliance. Govindaraj. 2 weeks to do the needful. Interim order granted earlier, transaction. Then not at all taken steps, sir. Finally, a week's time is granted to take steps in the event it is not taken by the next date of hearing, i.e. on 7th of August 2024, the interim order subsisting shall stand vacated, automatically vacated. Yes, settlement ತಗೊಂಬಿಡಿ. ಎಲ್ಲೆಲ್ಲಿ settlement ಇದೆ ಅದು ಕಟ್ಬಿಡಿ.
Reporting settlement?
I appear for respondent number 2, my lord.
You are reporting settlement?
Yes, my lord.
Which matter?
Of serial number
39 and
40, 40, my lord.
Offense ಏನು?
Offense is 498, one of these 498.
Yes, ಕೊಡಿ. ಎಲ್ಲಿ settlement memo? Settlement deed
Kindly
ಅಲ್ಲಿ.
pass on. Kindly
Also-
Yes, sir,
pass on.
we'll report.
Yes.
Reporting settlement?
Hmm.
Mm-hmm. 62,
41.
62,
Settlement ಆ? 41 ಆ?
41 second list.
ಹಾ, settlement ಅಂತಾನೆ ಇದೆ, ಕೊಡಿ. ಏನು offense?
498A and
Parties?
parties ನಲ್ಲಿ mediation ನಲ್ಲಿ ಇದಾಗಿದೆ.
ಕೊಡಿ. ಅಲ್ಲೇ ಇದಾರಾ?
Petitioner is second respondent did not come. Advocate is on record. Rupesh B is online. Rupesh B. They have agreed to quash the proceedings as per the mediation.
Agree to cooperate for quashing the proceedings. Agree to quash ಅಂದ್ರೆ?
Cooperate.
The petitioners are before
right.
this court calling in question proceedings in CC 4139 of 2021. During the pendency of the petition, in the light of the parties being before the family court, sorry madam, the parties to the list were also before, ಇಲ್ಲಿ challenge ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅದಾದ್ಮೇಲೆ, parties to the list were also before the family court in MC 6765 of 2023 and have settled the dispute before the mediation, the terms of settlement. ಎಲ್ಲಿದೆ ಇದು?
Class number 5.
A term of settlement is cooperation with the quashment of these proceedings as well. The set terms insofar as they are germane reads as follows, page 9 and either the 9 and 10 flag ಹಾಕಿದ್ದೀನಿ. In the light of the offense, ಅದು ಮಾಮೂಲಿ phrase ಗೊತ್ತಾ madam? In the light of the offense not being against the state and this so and so. Yes, settled. Disposed, quashed.
Please. 43.
Insofar as accused number 1 to 7, my lords have already quashed the proceedings.
ಇದು accused number 1 ನಾ?
ಇದು accused number 8.
8.
ಕೊಡಿ.
Application.
ಅದು ಕೊಡಿ ಸಾಕು. ಕ್ವಾಶ್ ಆಗಿರೋದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿರೋದು.
Settle ಆಗಿ quash ಆಗಿ.
ಇದೇ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದು ಕ್ವಾಶ್ ಆಯ್ತು.
ಆಯ್ತು ಹಂಗಾರೆ ಇದನ್ನೇ. The petitioner is accused number 8. Que accused number 1 to 7, this court on drawing up of a settlement has quashed the proceedings against them. In that light, the proceedings against the present petitioner accused number 8 also stands quashed. This court, while quashing the proceedings against accused 1 to 7, has observed as follows. Madam, settlement ಇದೇ ತರ ಬರ್ಬೇಕು. ಮುಂಚೆ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಯಾವ್ದು ಹೇಳ್ತೀನಿ ಅದೇ ತರ ಇದೇ ತರ ಬರ್ಬೇಕು. ಯಾವ್ಯಾವ್ದು ಸೆಟಲ್ಮೆಂಟ್ ಹೇಳ್ತೀನಿ 498A ಇದೇ ತರ ಬರ್ಬೇಕು. Yes, sir.
Great.
62.
Mm. 62. ಯಾರಿಲ್ವಾ? ಇಲ್ಲಾಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ ಅಷ್ಟೇ. 62, 63 ಇರ್ಲಿಲ್ವಾ? Same list after 2 weeks. Any other settlement?
7.
Yes, 67, nobody?
7.
Other 2 weeks, but list after 2 weeks.
Petitioners.
67.
Yes.
Where
Unless
the
we
parties?
kindly pray time during
The
the
2 weeks,
intervening.
list after 2 weeks, yes.
Much obliged.
Pay for the bill.
Settled.
Please, interappearance for
Offense.
respondent to 354A D.
Kodi. The petitioners are before this court calling in question sounds. During the pendency of the petition, the parties to the list have entered into a settlement and have placed on record a settlement and have filed an application under section 320 of the CRPC seeking compounding of the offense and quashment of the proceedings. The joint affidavit filed in support of the application reads as follows, page 3 and 4. In the light of the offenses not being against so and so, adu gottagata madam, not being against the state and not heinous, I deem it appropriate to close the proceedings by way of acceptance of the compounding application. Disposed, quashed.
Wait.
Next. Totally.
Next matter. Pawan, Venkatesh Talwar.
CRPC. 1 minute. 1 minute, sir. Short 2 weeks. 1 minute, wait.
Yes. Cannot pick, right? Tomorrow.
Yes. One submission.
What's 220?
430 matter is.
430 matter ಇದೆಯಾ?
Dictate.
3 matter ತಗೊಂಡ್ಬಿಡ್ತೀವಿ ಒಂದು ನಿಮಿಷ. What can I do? Huh? Wait, sir. Then 230 3 matter ಇದೆ. I'll take it and then. Yes.
But this is a defamation case.
Special court matter.
ಹೌದು.
ಮೂವ್ ಮಾಡಿದ್ದೆ 230ಗೆ?
But 13th is a date of appearance.
13th.
13th.
We'll take it on 6th.
That's only legal issue is, my lords, after presentation of complaint, they issue a notice without recording its own statement. Under BNSS Act, they have to first record this statement, then they have to give a notice for cognizance. That's
Well
how the procedure is.
All right, we'll 6th will record all that. List on 6th in the fresh matters list.
Very
2:30 move ಮಾಡಿದ್ದೆ ಯಾಕೆ? ನಾನ್ ಮಧ್ಯಾಹ್ನ ಏನೋ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ.
Sorry.
Number 2.
Yes.
One request,
ಅಲ್ಲ 8
serial number 89, my lord.
ಒಂದ್ ನಿಮಿಷ 2:30 ಮೂವ್ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ಒಂದೇ.
I only wanted to bring to lordship's notice today, the court below lords has kept their matter there for
89.
18.
Which one? First list?
Yes, my lord, the MP MLA.
Okay, well, we'll see 1 minute. Yes.
Please.
Number 2. Change correct.
Offenses under section 79 and 188, my lords. Section 155 of CRPC.
Why 2:30 ಮೂವ್ ಮಾಡಿದ್ದೀನಲ್ಲ?
The charges have been plea, it is kept for plea for 8, my lords.
Charges?
Next Thursday, matter has been posted for plea.
Then 6th, yes. You serve on the state by then.
We have
I'll take
already-
on the 6th in the fresh matters list.
Then both the matters are on the same.
Both.
Please.
Bill number 4. Ajay Kat.
Offense under 171H, my lords.
Why 2:30?
My lords, the matter is posted before the trial court on Monday for framing of charges.
On
My lords, please, my lords, the offense, my lords, is by the company which has, my lords, the name of the family Nirani Sugars Limited. The entire, the column number 17, my lords, of the charge sheet would say, the articles are recovered, my lords, from the company and not by the petitioner. And my lords,
Have you served a copy?
please,
here?
my lords, I have served a copy of,
Just Jagdish.
and I'm nowhere related to the company.
Who are you?
My lords, I am a
You're
candidate.
related to the company ಅಂತೀರಾ?
Well, I was not related to the company at all. The company, the articles, my lords, that are recovered is, my lords, from the company. Except for sharing, my lords, the family name.
171 F and H.
171. Item number 61 ಅಲ್ಲಿ same.
ಇದೇನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿ ಇಟ್ಸ್ ಗಾನ್ ಟು ಫ್ರೇಮಿಂಗ್ ಆಫ್ ಚಾರ್ಜಸ್ ಸ್ಟೇಜ್. ಚಾರ್ಜ್ ಶೀಟ್ ತುಂಬಾ ಜಲ್ದಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ ಹಳೇದು.
ಹಾ?
ಹಳೇದು.
ಹಳೇದಾ?
ಹೌದು.
Till 23.
23 ಎಲೆಕ್ಷನ್ ಇದು.
23 election.
Charge sheet is also filed in 23. ಗೆದ್ದಿದ್ದಾರೆ ಅವರು.
ವೈ ಈಗ ಚಾಲೆಂಜ್?
I received.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡ್ಬೇಕಾರೆ we will not entertain.
No, my lords, I have raised certain serious legal issues, my lords.
Oh, serious legal
no,
issue.
My lords, the entire
Will not
charge sheet,
seriously entertain.
my lords, the entire charge sheet would indicate these articles, my lords, are recovered from the company. And my lords, I am nowhere related to the company.
List the matter on 8th in the fresh matters list till such time the concerned court shall defer its proceedings.
I'm grateful.
Yes.
Order seal number 5. Bhaskar M. Deshpande.
Settlement,
Settlement.
ಏನ್ offense?
441, 47, 380. They're all members of
447
committee.
settlement first time ನೋಡ್ತಾ ಇರೋದು ಕೊಡಿ.
Filing joint affidavit.
The
Parties.
petitioners are before this court calling in question proceedings in CC 76 of 2014 registered for offense punishable under 441, 380, 447 and 204 of the IPC. The parties to the list during the pendency of the petition have settled the dispute amongst themselves by drawing up certain terms of settlement and have filed an application seeking compounding of the offense under section 359 of the BNSS. 359 read with 528 of the BNSS seek for such compounding. In support of the said application have filed a joint affidavit. The joint affidavit reads as follows. In the light of the settlement arrived at between the parties and the offense not being against the state or heinous, I deem it appropriate to accept the application seeking compounding of the offense and close the proceedings against the petitioners. For the aforesaid reasons disposed, quashed. Either pen drive al kodi ಒಂದು. Settlement. Yes. ತಗೊಂಡಿಸ್ಕೊಳ್ಳಿ. Yes. Yes, next.
Number 6. Arun G.
Challenge to an illegal remand, that too in the nature of a police custody which is given for 2 days, my lords, in an offense which is punishable for cheating. My lords, this will be violative of Satyendra Kumar Antil and my lord's judgment. My lords, the allegation is 2018 ಅಲ್ಲಿ certain amount which has been given to the accused was not repaid back. He only paid back a portion of it. 2024 ಅಲ್ಲಿ the complaint given. In the complaint, my lords, 318 subsection 4 for cheating. On 31st, the police comes, my lords, picks me up, takes me, my lords, and they get me to sign about 6 documents, including 341A notices, my lords, which they say on different dates they try to serve anta heli. They get it signed, produce me before the court, and ask for police custody. I bring this to the notice of the court, my lords, these signatures that are obtained. Remandally, fortunately for me, my lords, they say, on the basis of the third 41A notice, I have come before the police station. Now, if there are specific cases on the basis of 41A, I have come to the police station, how would they cause an arrest, my lords, which goes contrary to Satyendra Kumar Antil, which makes granting of bail mandatory?
Now, what have you challenged?
My lords, now the order, page 34, my lords. And as an interim order, my lords, I have sought for release on bail. 34 is the police custody which they have given, my lords. Please notice, my lords, these 3 signatures of mine which they have taken, my lords, page 36, annexure DLE. Kindly notice this, my lords, in the bottom, same ink in all these pages, page 36, 37, 38, 39, which is the arrest intimation, and my lords, page 40, arrest memo. Bottom only, same ink, signatures taken, and I am being produced, asked police custody in a case of 420. And in the remand, my lords, they say I appear before them on the third notice. Kindly notice the remand at page 29, my lords.
Yeah, who are the complainants?
My lords, complainant, one Dayanand, my lords, respondent number 3. He says 2018, 50 lakhs, he had transferred it to me. I had assured him of good returns. I only repaid back 5 lakhs. Therefore, it's a case of cheating. 2024 is his complete. Page 29, first line is that remand where they say appear before them. If I've appeared before them, my lords, on the basis of a 41A, how could they cause an arrest, my lords, where bail is an entitlement under Satyendra Kumar Antil? Even sought for summoning of those papers from the investigating agency, my lords. The signatures is absolutely clear. They make us sign into all the 41A, 3 dates ago. On the same day we sign, produced. How?
Copy ಕೊಟ್ಟಿದ್ದಾರಾ?
Copy ಕೊಟ್ಟಿದ್ದಾರೆ. I've had an occasion to discuss with, I have spoke to investigation agency. Issue, my lord, is not as my learned senior friend narrated. Issue is that the multiple people have filed a complaint against him for cheating and
Where are those complaints?
I'll place all those things. I've received it now and I'll place all those things.
And for this man's complaint, whom he says is on 11/9/2018, he had deposited 25 lakhs. Next event is December 23. Next event is 23/7/24. I called him on mobile at 8 PM. He did not receive. And you take the complaint and become settlement houses?
No, it is not, it is
Yes,
not
sir.
just. I'll take your.
How did you arrest him?
No, because he has not cooperated with the investigation. 3
Now,
notices,
when did you serve him the notice?
3 notices have been, I've
When?
been told, my
That
lord.
is exactly why I have written that order. It should reach them and only then. When did you serve them, sir?
No, I'll place all those
When
material.
did you serve the notices to these people? As he says, everything is on the same day.
No, I'll secure those information. I'll place those material, my lord, because I've
Now,
been told that.
we will release him now.
No, but he is in police custody.
No problem.
No, all.
No
Your lordship,
problem. I will release him
no,
now.
this
I will
is-
record all this.
No, may make.
I will record the prima facie harassment by the police for this reason and for recovery of money. You have registered a crime for recovery of money, which is clearly impermissible. How did you even register and arrest him on that score?
No, may make one submission.
Yes, sir.
I've been told, my lord, that these issues are also brought before London Magistrate Court at the time of remanding. The document was summoned by magistrate court.
What document was?
All
summoned?
these documents were summoned by magistrate court and he looked into these documents and thereafter given a police custody. So therefore, my lord, I'll place all the entire CDs and all the documents which have been placed before magistrate court. Your lordship can decide, will I have it tomorrow, my lord, I'll place all those materials.
31/7, all of the same day, same ink.
No, I've seen it now, my lord, and I'll have to verify. I'll verify those and I'll place all
Yes,
those.
police harakiri should stop.
Your lordship, I have tomorrow, my
You
lord,
know,
I'll place
how
all those
did,
things.
where is the evidence that you have communicated this?
I have been told, my lord, it has been communicated.
You've
to
been
him.
told how, sir?
No, I've eager.
Who is the man who issued this notice? Kamakshipalli
Sub
sub-inspector.
notice document put to him. Just now I received and I communicated and I asked him.
Yes, we'll
I'll
take this,
place all those things.
we'll take this matter on Monday as the first matter.
Well, it's one for page 29, they remind, kindly notice the first line in page 29, my lords. Though we specifically pointed out, we were arrested and we were made to sign first line only. They say third notice, I appeared before them at 10 AM. If that is so,
ಹಾಜರಾಗಲು ಸೂಚಿಸಿ ನೋಟಿಸ್ ನೀಡಿದ್ದರೂ ಸಹ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗದ
I have
ಕಾರಣ
come before them according to them.
ಮೂರನೇ ನೋಟಿಸ್ ಅನ್ನು ಜಾರಿ ಮಾಡಿದ್ದು ಆರೋಪಿಯು 10 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಹಾಜರಾಗಿರುತ್ತಾರೆ.
How can that
ಆರೋಪಿಯು
be, Malaj?
ಪ್ರಕರಣದಲ್ಲಿ
If I am there-
ಕೂಲಂಕುಷವಾಗಿ ವಿಚಾರಣೆ ನಡೆಸಿದ್ದು ಆರೋಪಿಯ ತನಿಖೆ ಸಹಕರಿಸದೆ ತಮಗೂ ಹಾಗೂ so and so.
So, my lords, in Satyendra Kumar Antil, they say, if you answer a 41A notice, how would an arrest take place, my lords?
Yes, sir.
No, if you don't cooperate with the investigation,
Third notice
Today,
ಮಾಡಿದ್ದಾರೆ.
according to you, have appeared.
This is the order.
They have not cooperated, therefore he has been arrested.
Third notice, he has come before you.
According
All-
Coming and
He will cooperate with the investigation. What interrogation you want to make in a 420 case,
no,
sir?
there have been told, my lord, that multiple people have cheated multiple people.
Which multiple people?
I'll place all those material. I'll place all those material.
My lords,
Then how
I am taken in this case. They will have to point out how they have
I'll place
taken
all
me.
those
Multiple case you forget, sir.
multiple-
How did you take?
Now he will be released. I am
Your
granting
lordship,
bail.
I have it tomorrow, my lord, I'll place all those material.
No, sir. Yes.
He has cheated
Yes,
innocent
yes,
people, my lord.
this is ridiculous, sir.
He has cheated innocent people.
Can you arrest, my lords? Cheated,
He
can you
cheated
arrest?
innocent people. But ultimately, my
Treated
lord,
innocent people is fine, but this is not the way that you produce. There is no indication of that at all. This is in this complaint.
no, my lord, that
Now you have registered a crime on this complaint,
Yes,
sir.
yes.
The complaint is that 2018 he has given 25 lakhs. ಅಷ್ಟೇನಾ? ಅಷ್ಟೇ ಇರೋದಿಲ್ಲಿ.
that's correct, my
The
lord. but-
complainant appears to be influential, so everything happens.
It is not just
Then what, sir?
complaint, my lord, and I've been told various innocent people have been
ಸುಮ್ನೆ
taken
ನೀವು ಫೋನ್
money.
ಮಾಡಿ ಕೇಳಿದಾಗ ಏನು ತುಂಬಾ ಜನಕ್ಕೆ ಮೋಸ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
That is what they,
ಅದೇ ಅದನ್ನೇ ಹೇಳಿರ್ತಾರೆ.
that is what they have received the various representation saying that he has cheated multiple people.
But since when are you in police custody, sir?
Since
Yesterday.
yesterday. He's
2
going
days, they
few
gave
days.
me to
Till
police
tomorrow he's in
custody in a
custody.
case of cheating, my lords.
Yes, sir.
Only till tomorrow, my lord, let
ಏನ್
us,
interrogation ಮಾಡ್ಬೇಕು?
no, we need to see, my lord,
What
ultimately
new
money
news?
has.
He will cooperate with the investigation. He will cooperate with the investigation, you release him now. This is not correct.
My lord, that the looking at all this material only, my lord, your lordship
What
have it
material,
to-
sir?
Your lordship have it tomorrow, my lord.
No,
I'll
what
place all this
material is there, tell me?
No, I'll have to secure this material. It is, they have moved it and then I understand, my lord, that they have custody, but you will have to have tomorrow, my lord.
Why custody in this case, sir?
I'll place all this material, my lord. I'm now handicapped. Unfortunately, I'm handicapped.
Prima facie, if it's violative of Satyendra Kumar Antil, my lords.
We'll take it tomorrow.
Yes, my lord.
Yes. List tomorrow. Learned additional SPP to secure the entire papers and point out with regard to the grounds that are urged by the petitioner. Yes.
My lords, could I request that the originals which are before the magistrate also
Please,
may be
everything.
summoned so
I'll
that my
place
lords may see whether it's in
The
the same ink,
additional
all the
SPP
files.
shall secure the entire original records and place it before the court tomorrow.
Yes, please, deeply obliged.
Yes.
My lords, in the fresh
So,
mat is,
order upload ಆಗುತ್ತೆ ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ.
I'll get it, man.
You will get
I'll get
everything.
it.
Yes. Next.
be in the fresh mat is tomorrow,
Yes, sir.
deeply obliged.
Number 8. Sorry, 7.
7.
Lords, the complainant who was an erstwhile trustee of Cambridge Educational Institutions files a suit in OS number 25905 of 2020. In that suit, she asked for an order of injunction. we brought on record that she had resigned in the year 1985 itself, which is noted at page number 75 of the orders of the trial court in the suit. The trial court takes note and says that she is already resigned and therefore her application is rejected, where she wants to claim that she is a trustee. Now she raises this very question by filing a complaint before the police.
Which
In the
is
year-
this, which is this order by the coordinate bench?
No, it's the coordinate bench. What this lady files 5 complaints before different police
Heard
stations.
the learned senior counsel D.R. Ravi Shankar appearing for the petitioner. 1 emergent notice, 2, 1 and 2 emergent, copy ಕೊಟ್ಟಿಲ್ವಾ? ಇದು ಯಾಕೆ ಮಾಡ್ತೀರಾ?
What is? ಇಲ್ಲಿ ಸರ್ ಮಾಡ್ಬೇಕು ನೀವು ತಗೊಂಬಂದ್. What is this?
ಯಾಕೆ ಶರವಣ್ ಗೊತ್ತಿಲ್ವಾ? What is this?
ಅವ್ರು
First time you are moving a matter at 2:30?
ಅವ್ರು ಮಾಡಿದಾರೆ ಅನ್ಸುತ್ತೆ ಅದಕ್ಕೆ.
What, sir?
What is this? No.
Yes. Anyway, 5 complaints ಅಂದ ತಕ್ಷಣ ಅದಕ್ಕೆ I will entertain. Otherwise, I would have asked his response.
Though 4 complaints were quashed, they went to Supreme Court. Supreme Court said if you have got anything, you file a protest petition in the investigation which is permitted. Again, they register complaints.
They heard the learned senior counsel D.R. Ravi Shankar appearing for the petitioner. The learned senior counsel would submit that the very complainant had registered 4 complaints, all of which had been quashed. The matter was taken to the apex court. The apex court disposed the appeals by permitting the complainant to file a protest petition in the matters which are pending before the learned magistrate. That is not done, is it?
That was done. Then the magistrate.
2:30 move ಮಾಡ್ಬಿಟ್ರೆ becomes very difficult even for me to go through it.
Sorry, my lords.
ಈಗ urgency ಏನಿದೆ?
Not the urgency is the police now is coming and sitting in the doorstep of the school. Now they want to arrest, saying that the 1985 document is a forged document.
That will see. Yes, list ಬೇರೆ ಏನು ಬರಿಬೇಡಿ madam. Heard the learned senior counsel D.R. Ravi Shankar appearing for the petitioner, 1 additional SPP, 1 and 2 additional SPP, 3 emergent notice, list the matter on Monday in the fresh matters list. Till such time, the respondent police shall not take any coercive steps against these petitioners, even any, Sakans.
Please, please.
Yes.
Number 8.
First copy ಇಲ್ಲಿ ಕೊಡ್ಬೇಕು. 2:30 move ಮಾಡಿದ್ರೆ.
Sorry.
Yes.
My lord, the
ನಿಮ್
victim
2:30 ಯಾಕೆ move ಮಾಡಿದ್ರಿ?
because my lord is the victim of the offences, my lord, and wherein a criminal breach of trust is there, my lords. And
2:30 ಯಾಕೆ move ಮಾಡಿದ್ರಿ?
because the learned session judge in application for anticipatory bail, my lords, grants an interim order restraining arrest, which is outside the jurisdiction at all, restraining the police.
You are
They
the
can grant-
complainant.
ಹೌದು, restraining arrest. Restraining arrest, which is outside, and that application is filed under 438.
Anticipatory bail ತೀರ್ಮಾನ ಮಾಡ್ಬೇಕು ಬಿಡ್ಬೇಕು.
Restraining arrest ಅಂತ, as if the honorable high court, because maybe the problem is the new section, my lords, 482 for anticipatory bail. But the power is not there. But it's filed under the old section and interim page 29, which is without jurisdiction, my lord.
Page
29.
ಇದು 420, 406.
409. 409 life imprisonment. Page 30, IO shall not arrest the petitioners. This is excising the inherent jurisdiction under 482 service.
Where is the page?
Page 30, my lord, 30. No reasons.
IO shall not arrest the petitioners. PP shall communicate this order to
Yes,
IO.
as if the honorable.
Yes, sir.
The interim, I'm not sure, my lord, looks like interim order has been granted.
Where is the power, sir?
No, interim order 438(1) you can grant, my lord. You can
Of
say.
what kind?
No, any kind, my lord. You can say that subject to, if they arrested.
Shall not
subject-
arrest the petitioner, sir.
That-
Anticipatory bail iದ್ರೆ ತೀರ್ಮಾನ
The
ಮಾಡಿ.
interim anticipatory bail can be granted.
Interim in the
Interim
event of
can be
arrest. This question has been decided on the Supreme Court, my lords, with kind of.
Normally interim bail are.
Court
granted,
officer,
my
please,
lord,
sir.
The statute itself says that
The
interim.
exact
anticipatory
question
can be-
failed for consideration, my lords, before the honorable Supreme Court, my lords. Page,
Page.
please, my lord. Last but one, 313. At the top, that being so, the irresistible inference is that while dealing with an application at 438, the court cannot restrain arrest. And then para 19, discussion on that, and last sentence, my lords.
Yes, sir.
An interim order restraining arrest, if passed while dealing with an application of 438, will amount to interference with the investigation, which cannot at any rate be done under 438.
438, should be T 438.
Now there is amended, my lords. Now by virtue of amendment, interim provision is not there.
438.
That's taken away, my lords. Now the amendment restores the old provision of 438, my lords.
Under the BNSS.
Howdo, the BNSS is 482, my lords. It actually restores the earlier provision, my lords, before amendment. So there is no provision for interim also now in the present.
438 1 na?
Yes, my lord. 438 1. Your
Hello,
lordship,
my
if it
lordship is
provides the-
reading, that has been
CRPC,
deleted, my lords.
correct.
provided that where the High Court or as the case may be, the Court of Sessions has not passed an interim order
BNSS,
under this subsection
That has been
or has
deleted.
rejected
BNSS,
application for grant.
That has been deleted. Deleted. A new provision, 482, sorry, still missed. 482,
IP penal
new
FIR.
provision, my lords. 482,
iPad ಬೇಡ ಇದು ಕೊಡಿ.
I'm sorry.
BNSS ಕೊಡಿ.
I'm extremely sorry. By virtue of an amendment, earlier there was any provision for interim, my lords. 482, direction for grant of bail 482. When any person has reason to believe that may be arrested, so and so, for a direction of this court may, if he thinks direct that in the event of such arrest, he shall be released on bail. Everything else, my lord, by virtue of 1A LI2, amendment, everything is deleted, my lords.
Yes, sir.
ಹಳೆ FIR, IPCL FIR.
ಅದಕ್ಕೆ ಹಳೆ CRPC ಮಾಡೋದು.
CRPC is new, July. This is 14th July.
Procedure, sir, procedure is under this only.
No, but procedure is adopted here is also 438.
All right, anyway.
Petition is also filed under.
Let him pass an order on the anticipatory bail application.
Please, this order, my lord, sir.
This will stay this order.
Please, my lords.
We will direct consideration of the application itself.
That's posted, my lord. That actually one
When
more
is that?
consideration. That's posted to tomorrow. That's posted tomorrow, and interim order is continuing. And the interim order is continuing. And one more reason is, my lord, application is filed under the 430 old 438. It is not at all
The
maintainable.
offense is old anta.
Correct. In fact, saving class.
That
File-
needs an answer still because
That's your lordship can decide because
post facto we will see.
it's filed on 25 July. That cannot be. As a procedure is concerned, the new, my lord, always. It makes a lot of
The
difference.
procedure is definitely what is on that day, sir, not the offense.
25/7.
Jagdish, sir, that's not correct. That will not be a submission acceptable. Procedure, you're following it today, not of the past.
ಇಲ್ಲ, but ಇದರಲ್ಲಿ ಅವ್ರ
Page 18.
Anyway, we'll see. Yes, heard the learned senior counsel PP Hegde appearing for the petitioner. The learned senior counsel submits that the concerned court answering an application under section 438 of the CRPC or under 482 of the BNSS has no power to grant an interim protection by way of grant of an interim bail. Grant of an order of not to arrest. The order passed by the concerned court reads as follows, page 30. The learned senior counsel would seek to place reliance upon the judgment of the apex court in 2005 4 SSC 303, wherein the apex court has held as follows. ಇಲ್ಲಿ mark ಮಾಡಿದ್ದೀನಿ madam, page 313. In the light of the judgment of the apex court and the order that would run foul of what is observed by the apex court, it shall remain stayed. This will not come in the way of the concerned court answering the application seeking anticipatory bail on its merit. List on Wednesday.
May permit take notice on the respond through the council preparing.
One additional SPP, 2 petitioner is permitted to take to serve on the council who represents the respondent in the trial proceeding.
Recently, Supreme Court said that anticipate when cancelling bail,
ಯಾವುದು?
staying of bail order, Supreme Court, my lord, last week said staying of bail should not
Thing
be
of
done
bail should not be done.
without
It's not a bail order.
Without.
This is without
Without
jurisdiction.
hearing.
That's
What is
what-
interim, not to arrest.
Not to arrest is without jurisdiction.
That's what the Supreme Court said last week, my lord. should
Yeah,
not,
if a bail is granted, that's true.
There
It's
is
not a grant of bail.
regular bail.
Yes, not grant of bail at all. Grant
should
of bail,
not
I do.
stay
consider.
unless
But this on the face of it is wrong.
they should not have used that word, my lord. They should have said it saying that interim bail.
And
has been
reasons must
granted.
be there. Reasons must.
That we don't know
Anyhow,
there is a separate
this
order.
runs foul of the Supreme Court decision. This cannot be.
We'll see, we don't know. You purti produce ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ order.
Pardon me, my lords.
Order
No,
purti
this
produce
is-
ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ.
This is the order which is there. This is
Anyway,
the-
let's see, list on Monday, Tuesday, Wednesday in the fresh matters list.
Please, my lords.
Yes.
Yeah.
ಮತ್ ನಾಳೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಬಿಡ್ತೀರಾ? He is the
ಇಲ್ಲ,
complainant.
ಅರೆಸ್ಟ್ ಮಾಡೋದಿಲ್ಲ. By virtue of this, in Rajasthan, they have served purpose is served, my lords. He has absconded. Now not available, will not be available. There are series of cases
No,
registered.
but I will direct till the consideration of the anticipatory bail application, he shall not be arrested because he is not heard in
No,
this
you are asking
matter.
me, my kindly in the
He is
present
not
case.
heard in this matter. Yes.
In the present
Till-
case, you are
till
asking
the
kindly
application
kindly, one aspect is there.
till
my
the
lords.
next date
No,
of hearing.
Let him cooperate. I have no objection.
One
If he
minute, till
cooperates.
the next date of hearing.
One sentence I beg to mention.
Yes, sir.
Now, my lord, as far as power of investigation can not only arrest, there is seizure, etc.
That is
I have no
whatever,
objection. If
whatever.
your lords,
1 minute, sir. Not to arrest is an order in his favor.
Please.
You are the complainant.
Please.
So wait.
No, may I
Based
submit
on-
like this, my
till-
lord?
till the
May
next
I
date-
submit only this one?
Till the
sentence?
next date of
May I
hearing.
submit only this with kind permission, my lord?
Yes, sir.
Your lords may put him into terms, but his physical appearance required because the other cases
Till
and
this
recovery is
day,
there, my lord.
sir,
He will never
you-
be. No, he will never be available.
ಇದು
I'm
ಇದೇ
making a
ತರ-
statement because he
ಈಗ
has run to
one-
Rajasthan.
one
He is from Rajasthan, my
1
lords.
minute, sir.
Please.
Money recovery na?
No, 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 no. This, my
ಮತ್ತೇನಿದು?
lords, as the Ereka,
ಹಾ.
Ereka is supplied to him.
ಹಾ.
Neither the Ereka nor the money. Ereka of the growers and the merchants. And this has ripple effect in the entire state, in the entire Dakshina
Well,
Kannada
see.
district, my lords. There's, my lords, involving crores of rupees. There are several criminal cases
How do
registered.
you serve him?
No, my lord, they take the response. Now, my lord, the police are not able to arrest. The police are gone to Rajasthan, not able to arrest, and he is absconding because of this order. He is not able to be arrested now.
Therefore, your
He has
lordship can
escaped
put
the
him-
clutches. Probably my learned friend should
lordship
take
him to
instruction from the
terms.
police. Because he has escaped the clutches, he will never be available now. Despite my lords are out of stay, he will not be available.
Your lordship
We
will
have
put
seen
him
this.
to terms, saying that will not be arrested subject to cooperate with investigation.
He can appear on a particular day.
Yes. In the light of the interim order being, in the light of the order impugned being stayed, it is made clear that the accused shall cooperate with the investigation. In the event of non-cooperation, it is open to the prosecution to take necessary steps in accordance with law. All this would be subject to the result of the application seeking anticipatory bail being answered by the concerned court. Yes.
3 and 4. Now, my lord, now by virtue of my lord's order, now the other last sentence, the consideration before the run session judge can wait because now the honorable court has protected.
I am not saying all.
Protected
I am not-
because of this matter, because Caesar is there. Lot of Ereka is taken away, my lord.
Let the
Caesar has to be-
concerned court pass necessary
Please.
orders.
Accused number 3 and 2 and 3. Accused,
Yes,
respondents 2 and 3, my lords.
ಏನು?
That the accused in the present case are,
Emergent notice.
They can also serve on the council appearing in the trial court.
that
I
my
made
lord
it
has,
already.
my lord has already.
Yes,
I've already directed.
Yes.
Emergent notice, but you were completely confused then. Yes.
Please, please, please. Grateful, lords.
Fast over here. 5 o'clock. Yes. All
48.
admission matters which have, 1 minute, 1 minute. Admission matters which have not reached will all be listed on. ಯಾವತ್ತು madam ಹೇಳಿದ್ದು ನಾವು? Huh? On 13th. You want me to sit till 8 o'clock? Huh? On 13th, yes.
My lord, serial number 66.
Serial number
Serial number 66.
All matters.
I have filed an IA. Register may be directed to put up that IA.
ಅದೆಲ್ಲ ಅವತ್ತು, yes. ಅಷ್ಟೊತ್ತಿಗೆ put up ಆಗುತ್ತೆ. Interim orders wherever are there will continue. Interim orders will continue all the matters on 13th.
settlement.
4 PM, my lord. 4 PM matter, my lord. Serial number
66 is final hearing. My lord.
ಮೊನ್ನೆಯಿಂದ ಇವತ್ತು ಹಾಕೊಂಡಿದ್ದೀವಿ.
ಎಲ್ಲಿ ಇವರು ಸೀನಿಯರ್ ಇದ್ದಾರಾ? ಜವಳಿ ಸರ್ ಇದ್ದಾರಾ? Where is he that serial number? 4 PM matter ಯಾವುದು?
70, serial number 70.
ಎಲ್ಲಿ ಇರೋದು? ಸರ್ 5 ನಿಮಿಷ ಇರಿ. I will hear you. Yes.
Serial number
430, madam. Dictating order.
What dictating? ಯಾವ್ದು? 498 ಏನ?
So 376.
376. ಈ ಟೈಮಲ್ಲಿ ಡಿಕ್ಟೇಷನ್ ಕೇಳಬೇಡಿ.
My lord.
ಡಿಸ್ಮಿಸ್ ಆಗ್ಬಿಡುತ್ತೆ.
My lord, serial number 66.
Serial number 39 and 40, my lord. The settlement.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ರೆ ಹಂಗೆ ವೇಟ್ ಮೇಡಮ್. Yes. All matters on 13th. All matters on 13th. All admission matters which have not reached are on 13th. Yes.
My lord.
And other matters will come on 23rd.
My lord.
Settlement wait, sir.
Serial number 69 connected matters of part heard.
That also on 13th. Yes.
My lord. My lord. My lord.
One matter.
Further hearing on 23rd. Yes.
Serial number 69 in one matter, there is no interim order. The trial court hearing is on the 7th.
69. ಅದೇ ಅವ್ರದ್ದು. ಹಾ, ಪರವಾಗಿಲ್ಲ. ಏನ್ ಪರವಾಗಿಲ್ಲ. ತೊಂದ್ರೆ ಇಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಅಲ್ಲಿ ಟೈಮ್ ಕೇಳಿ. ಅದು ಕೊಟ್ಟಿರೋದೇ ತಪ್ಪು. That is what he says. On a wrong premise, interim orders are spiraled in that case.
In fact, but in this case also, they have made the same allegation.
We'll see, yes.
Lordship, bill number 48, your
78,
lordship.
my lord.
It was heard the other day
Dictating-
with respect to the interim order, it was to be heard today, your lordship. We'll
Which
serve
one,
the
madam?
state also. This is a matter wherein, your lordship, the public works contractor, the bank guarantee issue, your lordship.
Now
This
bank
was a-
guarantees. 48.
Please,
Admission, is it?
list,
48.
list two, your lordship, 48.
First time ಬರ್ತಾ ಇರೋದಾ?
Second time, your lordship.
Then what?
Your lordship,
When?
it was for consideration of the interim
Oh,
order
no.
since the state.
What, 7A or what is it?
Your lordship, this was on, with respect to, the, state, this is a public works, contractor. The
so?
bank guarantee they claim was
Like
a
bank
fraudulent.
guarantee.
Your lordship, in this is a matter where in 25 years, there have been over 500 bank guarantees given. There's no issue at all. There is a fake bank guarantee issued by one of the private banks during the term, during the time of,
No, no, I heard you. I
2020.
think you had appeared with admission.
Please, your lordship, they were supposed to respond on that
They
aspect.
will
and,
respond. I'll post it on 13th.
Your lordship, difficulty is this.
Yes.
The investigation officer has stated that they would have to seal even the premises and his office if and we are
If they
unable.
do that, you move the matter.
Your
if they-
lordship, then your lordship, I will,
If they do that, you move the matter.
your lordship, they could proceed with the investigation as long as there
ಅವರು
is no.
ಫೋನ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿರ್ತಾರೆ for other reasons. So ಅವರು ಮಾಡಿದ್ರೆ ಅದನ್ನ ಮೂವ್ ಮಾಡಿ.
Your lordship,
Yes.
no precipitative action. That is all we are asking. We,
That fake bank guarantee case, I heard you on the other occasion,
Your
on the
lordship-
first occasion. I grant ಮಾಡಂಗಿದ್ರೆ ಮಾಡ್ತಾ ಇದ್ದೆ ಅವತ್ತು.
your lordship, in fact, I haven't taken your lordship to any of those documents, your lordship. This is
No,
a
no.
matter wherein the state
13th,
was to
13th.
respond.
We'll have it on the 13th.
Please.
71, my lord. 71
also
4
on 10th, 13th.
Huh?
78, dictating order, 13th.
Entry model ಇಲ್ವಾ?
Interim order.
Yes.
My lord, 71 4 PM matter. My lord, say.
4, sir, 5 PM ಆಗಿದೆ.
ಇಲ್ಲ, ಯಾವತ್ತಾದ್ರು ತಾವು
ಬರುತ್ತೆ, yes.
71.
ಇದು ಮಾತ್ರ 376 of Jawli sir, I'll hear, that's all.
My lord,
No, this 71 ಒಂದಿದೆ. Wait, 71 ಇರಿ, ಇಬ್ರು ಇರಿ. Yes.
my lord, serial number 65.
All other matters, please don't make a mention. They are all coming on 13th. Yes.
Just a moment, my lord, there's no interim order.
No problem. Yes.
It is a writ petition of GMRES, my lord. My
Maybe.
request is that it may be posted before the roster judge.
Which one?
Because amendment application as well as interim application are pending for
Which
nearly
one,
2
madam?
months. Serial number 65, under further hearing, list 2.
I should release it. I will not release.
Okay,
Yes.
otherwise it may be had
That
needed
we'll
next
see, no
month.
problem. That chairman, right?
Yeah, but I have filed amendment application and an application for interim order which has been pending for nearly 2 months, my lord.
Which interim order, madam? I have rejected the interim order.
No, post that a new notification has been passed,
well-
owing to which I have filed a new application.
ಅದಕ್ಕೂ you have applied for that also.
Yeah, I want to amend, challenge that notification as well as an interim order.
All right, then
interim direction.
release from the status of being part heard. List the matter before the bench having appropriate roster. Yes, next.
Great.
Serial number 50, my lords. It's
58, my lord.
adjournment.
Cause list 1.
VC, please wait, madam.
Yes, please.
Yes.
Let's cause list 178, my lords. On the first hearing day, the matter was heard here, my lords.
Cause list 1 na?
178.
78.
Yes, my lords, I was held up in court all 20, my lords, when the matter was taken up. Identical matter will stay there. First hearing date ಅಲ್ಲಿ hearing ಆಗಿತ್ತು.
ಯಾರು appear ಆಗಿದ್ರಲ್ಲ?
My lords,
Somebody had appeared, right? Yes, it's on 29th, yes.
my lords, a short date, my lords, identical matter will stay there. It was listed today only, my lords.
Then list on 22nd. Yes. 29th,
List
but
on
22nd.
13th, my lords.
No, nothing, yes.
Serial number.
ಯಾವ್ದು ಕೇಳ್ಬೇಡಿ. ಎಲ್ಲ
Request for listing in fresh matter.
No, sir. Request rejected. Request rejected. Interim order ಇದೆ ತಾನೆ? Yes, next.
70.
In serial number 64, 23rd has been given. You know, I may I request for the Friday previously or the next.
No, madam, on that day you make a mention.
No,
Each
my-
matter we can't deal
You know,
with separately.
The next week, you know, it's my colleague's wedding on that day, on 23rd.
We'll definitely grant time, don't worry on that day, yes.
May I make a submission, my lords?
No, madam, yet, wait.
Yes.
If you have the luxury of sitting in the office and making a mention, you have to wait. Yes, what is this?
Based on an allegation that there was sexual relationship with the person and then the promise of marriage, complaint was tendered here. Matter was initially at the stage of FIR, came up before this court. Your lordship said accorded stay, which is at page 161. Thereafter, after due investigation, they have added 376. It's our contention that 376 and the SC/ST Act will not be applicable. Rest of the portion I would like to submit. I will be fair to that. Let the other proceedings go on.
Let the other offenses go
Yeah,
on.
let it go on.
Yeah, the 504, 506.
And the 417. Let it go on. Otherwise, in my humble submission, it's covered by your lordship decision, which has been put at 163.
No, if you had left her alone, it's a
I
different thing.
understand, but I will
Why,
not just.
why didn't you leave her alone?
That's, I'm not
ಈಗ ಮದುವೆ
justifying.
ಆಗ್ತೀರಾ?
She is already.
No, she's not married. She's waiting for you.
Cancel it. I don't have no instructions on.
Now you want to get married, you can get married. Anyway, you have stopped her marriage.
Monday, your lordship may have.
You have stopped her marriage. So
See.
you want to get
No,
married?
no,
get married.
I'll put it across.
Yes, sir. That's why I said you can't adopt a dog in the manger attitude. ನಿಮಗೂ ಬೇಡ ಯಾರಿಗೂ ಬೇಡ. Yes. List on Wednesday ಹಾಕಿರಲ್ಲ? 7th.
7th.
List on 7th. Yes.
71.
ಎಲ್ಲಿ ವೆಂಕಟೇಶ್ ದಳ್ವಾಯ್?
Matter pertains to.
ನೀವಿದ್ದೀರಾ?
CCB, the contention of CCB is not a police station.
Placing the synopsis.
Fact. My learner friend will not argue that point now.
No, I will argue, but different point on this.
ಅಲ್ಲ ಇದರಲ್ಲಿ ವಾಟ್ ಇಸ್ ದೇರ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್?
No,
ಇದು ನಾನೇ ಕೊಟ್ಟಿದ್ದ ಎಂಟ್ರಿ ಮಾಡ್ರಿ.
I have not seen the file.
There is absolutely nothing.
I have not seen the file.
ಆಯ್ತು, ಇದು ನೋಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. ವೆಡ್ನೆಸ್ಡೇ ಐಲ್ ಟೇಕ್. ವೆಡ್ನೆಸ್ಡೇ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ಅದು 4 PM ಫಾರ್ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕಿದೀವ ಮೇಡಮ್. ಅದು 4 PM ಗೆ ಹಾಕಿರ್ತೀನಿ. ಅದೆರಡು ಅಷ್ಟೊತ್ತಿಗೆ ಹಾಕಿ ಸೇಮ್ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಮಿ, when I granted the interim order, I've seen it. There is nothing against it. Your legal ground CCB ಬಿಟ್ಟು ಬೇರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಇದೆ. Yes.
Interim order may.
Interim order subsisting shall continue till the next date of hearing.
Great.
Yes, Proceedings, sir. You said somebody charge and frame ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Charge, today, my lords, it is posted for issuing, summons has been issued, my lord. But this is a case where, my lord, petitioner number 1 is an MLA, petitioner number 2. is an
Summons
MLA.
issue ಆದ್ರೆ so what?
Summons, only this aspect, my lord, I want. Series of 353 cases. One of his lord, supporters, if I have to use that word, he has constructed a house. The forest officials want to demolish it on the ground that it encroaches upon forest land. But under section 62 capital A, my lord, they are expected to hold an inquiry. The complaint is.
That is forest official.
Well, the forest of, your complaint is to go and demolish a constructed house or to remove it is part of the discharge of the duties. And all that he does, my lords, it is not my house. All that he.
Whether they have discharged the duty correctly or not is not the question here. What you have done on
No,
their discharge.
therefore, my lords, when they came there, all that he says is that under section 62 capital A, you are expected to hold an, no, but kindly appreciate.
MLA na.
MLA and MLA.
ಅಷ್ಟು ನಿಧಾನವಾಗಿ ನೀಟಾಗಿ ಹೇಳಿರ್ತೀರ ಅವರು.
ಅಲ್ಲ, ಅದು ಇವರು
ಅವರು ಆತರ ಮಾಡಿರಲ್ಲ, ನೀವು ಆತರ ಮಾಡಿ.
About this forest officers, kindly permit me to read one sentence at page 169. This is the complaint he gives. He says, going and demolishing is part of.
Summons ಅಷ್ಟೇ ತಾನೆ. I'll take it on 8th.
There is one difficulty they are facing, if lots of, the magistrate wants to issue a non-bailable warrant.
Why?
That is he wants to issue. In fact, today, my lords, the matter, they informed the learned magistrate that the matter is coming up before your lordship. Said, I will wait till the proceeding. I don't want to say more.
ಇದು opposite party.
Coordinate bench of this court. The two petitioners of the same petitioner of the same offences with respect to different locations are given a liberty for him to approach the trial court and with liberty to not to appear.
That's what I wanted to point out. that against this MLA, my lords, whenever he goes to ask something to somebody, they file 353A. But I'll point out.
So you are asking is the
No,
problem.
no, lords, as an MLA, my lord, I'm expected to, my lords, not kindly look at this forest officer.
ಆಯ್ತು, ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಇದೆ offense ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಮಾಡಿದಾರಂತ.
In respect of other incidents, not in respect of this incident. Not in respect, no, that was.
Will exempt you from appearing.
Yes, madam.
He will not issue
Let him file a
NPW.
discharge application.
Yes,
That is what.
today, my lords, but if
They heard the learned senior counsel troubling now would be appearing for the petitioner. Learned additional SPP is ಆಗಿದೆಯಾ notice ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
So it's
ಆಗಿಲ್ಲ sir. First notice ಆಗಿಲ್ಲ. First.
the learned additional SPP is directed to accept notice for the respondent. ಎಷ್ಟೊಂದು ಜನ ಇದ್ದಾರೆ? Accused.
Full follower.
all this, this is a method, I will put it across.
ಅಲ್ಲ ಮೆಥಡ್ ಏನು? 15 accused are there.
Everybody, my lords, they make them as an accused. Whoever comes, but he is literally targeted. My lords, may permit me to. But not only this, this is the third 353A cases, and he goes there.
ಎಲ್ಲ 353.
All 353 discharge of duties. They expect us not to question them at all. And this case, what the complaint is, he says, this is part of a quasi-judicial inquiry to go and demolish.
In fact, in two matters, coordinate bench.
Let's see, the petitioners are exempted from appearance before the concerned court till the next date of hearing.
With liberty to file discharge application. That's what has been done.
Discharge application.
That's what been done by
ಯಾವ್ದು
coordinate.
discharge?
That's what coordinate.
Charge sheet file ಆಗಿದೆಯಾ?
ಹೌದು. Charge sheet file ಆಗಿದೆ.
Offense in 353.
ಹೌದು. All two matters have been done in the same manner.
We'll consider that on the next date.
In all fairness, if lordships are to pass it, we will agree for that next date. If lordship, if that order
Discharge
is,
application.
in that order, in that manner, if lordships are to pass, I will produce that
List on
order.
8 in the fresh matters list.
But till then, lordships may protect. us from-
Exemption from appearance.
I think.
And delivery.
ಯಾವ hand?
Because today it's listed.
ಇವತ್ತು, how do you expect? You tell the court that is the order that is passed.
Finally.
Yes, court is sitting now, is it?
Yes, we'll file a memo.
Yes. File a memo. When the order is passed, despite the memo, you
No,
tell.
no, we'll file. I'm sure they will.
ಗೊತ್ತಾಗ್ಲಿ ಅವ್ರು ಹೇಳಿ.
Sorry, Madam, in the morning, my lord, there's some communication with respect to filing objection or not filing objection. That oversight I made.
ಎಲ್ಲ ಆಗ್ತವೆ. Yes. ಅಯ್ಯೋ ಸಿರಾಜುದ್ದೀನ್ ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡಪ್ಪ. ಇಲ್ಲರೂ ಚೇಂಬರ್ಗೆ ಬಂದ್ಬಿಡ್ತಾರೆ.
I have for respondent number 2, Miller.
ಇದು ಯಾವುದು ಮಸ್ಕೆಟ್?
No, Miller.
This
This
is
is a different case.
49 and 40.
In this case, the offense of 498 ML.
ಎರಡು 498 ಏನಾ?
Where I know the 341 is there, criminal restriction. The wrongful restraint ಇದೆ.
Wrongful restraint. ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್?
The list number 40, Miller.
ಜಾಯಿಂಟ್. ಇದು ಯಾವುದು 10 days ಕಾಪಿ ಕೇಳಬೇಡಿ.
No. I filed the wakalat for both the cases.
Separate order sheet ಅಲ್ಲಿ enters appearance for so and so enters appearance for the respondent. Registry to print the name of so and so is appearing for the respondent. Same drill, madam. So and so challenge during the pendency of the petition, parties to the list have settled the dispute amongst themselves and have drawn up settlement. ಇಲ್ಲಿ this court ಮಾಡ್ಬಿಡಿ ಇಲ್ಲಿ flag ಹಾಕಿ ಅಷ್ಟೇ closed sign ಮಾಡು.
Please. Serial number 50, my lords. May I make
Now tell me, madam. Yes.
Yes, sir. Apologies. Actually, the matter was
When you're on
adjourned.
VC, you should wait because there are others who are waiting here.
Yes, please.
Yes.
I apologize. I believe it was adjourned, but the stay wasn't extended, my lords. Serial
Which
number
serial
50.
number, madam?
50, list 1, serial number 50.
Interim orders are extended, madam. Wherever it is extended.
Yes, please.
Yes. ಏನೋ ಮದುವೆ ಅಂದ್ರಲ್ಲ ಮೇಡಮ್ ಹೇಳಿ.
We are all
ಯಾವತ್ ಬೇಕು ಮೇಡಮ್?
either the earlier week or the next week, my lords.
ಆಯ್ತು 23rd ಹಾಕಿದೀವಾ?
Yes.
ಅದೊಂದು ಮ್ಯಾಟರ್ ಮಾತ್ರ 13th ಹಾಕಿ. 13th ಹಾಕಿ ಅದೊಂದು ಮ್ಯಾಟರ್ ಮಾತ್ರ.
Much obliged.
Yes.
Sorry,
Whose
my
marriage?
lords, my colleague's marriage.
Colleague's marriage.
Madam, please. List to 42nd matter.